Check, check. Good morning, everyone. Thank you very much for joining us. We can start with VC Sir's address.
Very good morning to all of you. Honorable Sri Justice Vijay Sen Reddy Garu, Judge, Telangana High Court. I think some of you may not be aware, there's a great illustrious family, Justice Subhashan Reddy. When we were the just law college students, the great constitutional lawyer, and then he was the former Chief Justice of Tamil Nadu High Court. And thank you, sir, for accepting and coming over and sparing your valuable time. Sri Shyam Divanji, Senior Advocate, Supreme Court. I mention to my colleagues, those who are in academia, the best book in the law schools produced is Environmental Law Cases and Material that was tested by Shyam Divan, Armin Rosenkrantz, first batch of NLS Bangalore. Both of them have taught environmental law course, and then that was a result. I always say one is criminal procedure, R.V. Kelkar, edited by Chandrasekharan Pillai. That's a path breaking in teaching of criminal procedure and environmental law. Thank you, sir, for accepting our invitation. So distinguished guests, esteemed scholars, faculty members, and dear students. It's my honor to welcome you all to the 6th edition of the Courts and Constitution Conference, a landmark academic conference that continues to push the boundaries of legal scholarship, critical discourse hosted by Nalsar University of Law. I think this is an interesting, every year we look at past 1 year Supreme Court judgments and decisions and critically look at how they have contributed to the existing jurisprudence, and also we will look at if they have not contributed, what are the difficulties, problems, and what is the alternative viewpoint. That's what the national law universities are meant for. National law universities promote and engage in critical discussions, not just to accept whatever the decision is given, but go beyond that. I think that was a successful 6 years. Since 6 years, we have been continuing this practice. And I must appreciate all the team. It started with Ajim Premji University. Professor Sitaram is here, and others, and Vikram Raghavan, another one of my student in the NLS Bangalore, and the whole team of students and the team. That was the wonderful event and a conference, and last 6 years we have been organizing this. Today we gather not merely as spectators, but as active participants in the most crucial dialogue of our time, understanding the evolving landscape of law, justice, and constitutional principles. It is through the lens of the contemporary legal developments and Supreme Court judgments in the year 2024. Therefore, this conference represents more than a mere academic exercise. It's a vital platform for exploring the complex intersections of law, society, and human rights. Our carefully curated panels this year reflect the depth and breadth of the contemporary legal challenges, trying to understand the critical developments from the year 2024. This year panel includes Disability Rights Panel, and which has a lot of activity from the Supreme Court. I would like to specially highlight the remarkable work Nalsar Center for Disability Studies does in this regard, and Justice Dhananjay Chandrachud in the last week of the judgment mentioned about that, and he directed Ministry of Social Justice to credit 50 lakhs to the Center for Disability Center in this regard. And I appreciate and congratulate the Center for Disability Rights for this momentous task of submitting the report to the Supreme Court. And also we will carry forward how do we implement it, putting all the stakeholders together. That's not just only accessibility report of the government buildings, courts, educational institutions, and many things. The second issue we'll be discussing is digital freedoms and technology and law, caste and equality, secularism, bail and civil liberties, and finally, fiscal federalism. We have assembled a remarkable group of panelists who bring a wealth of expertise and lived experience. What makes this conference truly exceptional is its commitment to diversity and intersectionality. Our panelists have a rich wealth of knowledge and are able to honestly provide different perspectives. They range from distinguished legal practitioners, investigative journalists, rigorous academics, and passionate activists who have dedicated their lives to understanding and transforming our legal landscape. My dear students, I hope this is a moment of intellectual awakening, and I urge you to approach these panels with more than just passive curiosity, active curiosity. Last year onwards, we have made this as a 1-credit course, and I request all the students take more interest and engage inside the panel, outside the panel, and continue that intellectual curiosity and discussions. Read the panel notes carefully, listen intently, question deeply, and engage critically. The future of legal scholarship and social justice depends upon your ability to think beyond the obvious, to challenge established narratives, and to imagine new possibilities of jurisprudence. I think that's we must contribute. That's what the Courts and Constitution represents. It intends to inspire and expound upon change and creating a new alternative jurisprudence. This conference is not just about hearing experts. It's about creating a collaborative space of learning where every voice matters, where every perspective contributes to our collective understanding of law and society. We aim to foster a dynamic dialogue where diverse perspectives intersect, challenge, and enrich each other. Our goal is to move beyond passive knowledge consumption to active knowledge creation. By bringing together scholars, practitioners, activists, and students, we create a unique ecosystem of intellectual exchange where legal concepts are not merely studied, but critically examined, deconstructed, and reimagined. By deliberately and consciously identifying these panels that represent diverse backgrounds, experiences, and perspectives, we challenge the conventional narratives and open up new possibilities for legal interpretation and social transformation. As we embark on these discussions, let's remember that law is not just static, always dynamics, and has to contextualize response to the challenges. And law is a living, breathing mechanism of social transformation. It's through critical analysis, compassionate understanding, and relentless pursuit of justice that we can truly advance our constitutional ideals. Welcome to the Courts and Constitution Conference. Thank you.
Thank you so much, sir. Next, we would like to invite Justice Vijay Sen Reddy, sir, for the inaugural address. Thank you.
Mr. Krishna Deva Rao, Vice Chancellor of Nalsar, the Senior Counsel, Supreme Court, Mr. Shyam Diwan, Dr. Vasanti, the Registrar Nalsar, organizers of this conference, and pan-India speakers, lawyers, scholars, academicians, students, ladies and gentlemen. It is a privilege to address this esteemed gathering today on pivotal topics related to fundamental, constitutional, and basic human rights, and having bearing on the lives of every Indian citizen. Firstly, I congratulate the organizers and think tank for choosing a variety and wide range of topics and inviting experts from all walks of life to share their thoughts and experience, and also suggest ways and means to navigate the path ahead. As we celebrate 75 years of our living and precious document, the Constitution, we take pride in remembering our framers of Constitution and their invaluable contribution envisioning the future of citizenry. The beauty of our Constitution is and nation is peaceful coexistence and inclusivity. Notwithstanding the competing interests and conflict between the state and its subjects, the brighter side of our successful democracy should not be forgotten. Our nation had been source of strength to many countries and people all over the world for being the largest and the most vibrant democracy. However, the painful side of the story is the plight of little Indian, be it a marginalized person, farmer, workman. Their problems and challenges remain the same. The rich become rich and richer. The poor remains the same. Poverty, in my opinion, is the worst form of human right violation. A question which disturbs my mind again and again is why a person should be born poor. Today's topic on caste equality secularism is of immense importance, which will shape the future of our country. The larger bench of Supreme Court in Indira Sahani versus Union of India, also known as Mandal Commission case, upheld the constitutional validity of reservation for OBCs in government jobs. And you know the journey of judicial intervention with several authoritative pronouncements and affirmative action and evolution with first amendment to the constitution in 1951, Kalelkar Commission 1952, Mandal Commission report in 1980, followed by judicial interventions with judgments in Chempakam Dorerajan 1951, Indira Sahani versus Union of India 1992, TMA Pai Foundation 2002, Nagaraj versus Union of India 2006, and the recent decision in state of Punjab versus Davinder Singh dealing with the subcategorization of scheduled castes. The concept of creamy layer was also evolved by Supreme Court in Indira Sahani's case and extended to marginalized communities like scheduled castes in the recent decision of the Supreme Court, which is a testament to our constitutional courts upholding social and economic justice. As you know, there are several issues relating to personal liberty, remand, and bail. Like a first sight, when you decide the success of democracy and success of functioning of court, the first thing that strikes a person is how a accused is treated in a country. We have seen in the recent past, I will not take the names, people who are well placed, who had been facing trials in Indian courts. Now, they have the advantage of having residency in foreign countries like UK, US, and countries which do not have major role to play in the world polity, and it is very easy for our people who are accused or who are loan defaulters running away from country. And it is so painful to read from newspapers and social media information. Even today, people plead for asylum in foreign countries, saying that Indian courts do not render timely justice. There is discrimination in the jails. Basic human necessities are not provided in jails. These are the general defenses taken in foreign countries to take plea of asylum. And it is a very common thing. Unfortunately, I feel whether he is a diplomat or person who is defending our country, a country with 140 crores, how we are functioning here as a system, how we have evolved from the colonial period with so many amendments taking place to the Constitution and the CRPC, the latest amendment being Section 41A. It's not latest, more than 10 years back. The amendment to 41A, because we have main speaker here, renowned lawyer, Mr. Diwan. So I'd just like to touch upon one topic which is relevant for all of you to think and come out with suggestions, because you are the future of this country. 41A was inserted in order to give some protection to a accused who is involved in an offense punishable with a less than 7 years imprisonment. Of course, with Supreme Court judgment in Arnish Kumar, certain guidelines were given. From the side of accused, it is like a victory won without battle. But we have to think from the side of victim, de facto complainant, and also investigation agency. With the new PNS, I was hoping some sort of gray area will be corrected. So one gray area is whether 41A notice can be given only to an accused or also to a suspect. As on today, we don't have any judgments. I think there is 1 or 2 judgments from Madras and Karnataka High Court. When a matter was heard by me and argued by top Supreme Court senior lawyers, I asked them this question. The issue was whether 41A notice can be issued to a suspect. So even today, it is not a settled law. But one counsel said, yes, it can be issued. When it comes to investigation, police are facing a crisis situation because he has only one option to give 41A. He does not know how to record reasons if a person is to be arrested in terms of Section 41. So by default, 41A notices are issued, and in 99% of the matters relating to punishment with less than 7 years imprisonment, accused are not arrested. But let us see the side effects of this 41A. As I told you, in the context of accused, it is a battle won. It's a victory without battle. See the context of, in the context of victim, the police, now they are in a situation where they do not know how to proceed with investigation. 41A is widely misunderstood. Accused has right beginning with Article 20, 21, 22, and now right to be silent is the right. It is a settled law. You cannot compel the accused to give statement against himself. So with this situation, there is inordinate delay in completing investigation. So I request all the stakeholders and renowned scholars. We have one of the top lawyers of Supreme Court here. I'm sure he has come across this problem, arising out of Section 41 ACRPC. And ultimately, the criminal justice object is truth should come out, and truth should prevail. So in the process of doing justice to the accused, it should not do injustice to the victim. So that is one point which needs to be kept in mind. So I conclude by saying that judiciary has played a critical role in interpreting the Constitution and ensuring social justice through balanced and thoughtful judgments. The path forward is one of continual reflection and adjustment. As we honor the legacy of framers of the Constitution and role of judiciary, we must ensure that principles of equality, justice, and secularism are not only upheld but also progressively applied to ensure an inclusive society. Thank you very much for giving me this opportunity.
Thank you so much, sir. Next, we would like to invite Senior Advocate Shyam Devan, sir, for the keynote address on 75 years of the Constitution and the Supreme Court of India.
Good morning. Justice Vijay Sen Reddy, Judge, Telangana High Court, Professor Sri Krishna Deva Rao, Vice Chancellor, Dr. Vasanthi, Registrar, NALSAR, faculty members, distinguished colleagues, students, ladies and gentlemen. Thank you for this invitation. It's my pleasure to address you at the start of the 6th edition of the Courts and the Constitution Conference. This is a fine platform for dialogue and deliberation. Awaiting you over the next 2 days is an intellectual feast. Do savor it. We will discuss caste and equality, secularism, the criminal process and bail jurisprudence, digital freedoms and technology law, fiscal federalism, and finally, a panel on accessibility and reasonable accommodation in memory of the scholar, humanist, and much more, Shamnad Bashir. That you have organized this event, invited eminent speakers, and will grapple with issues of moment is credit to the organizers. It is also a tribute to the foot soldiers who have fought to preserve our constitutional values and to protect spaces for the citizenry. Do not take these spaces for granted. With creeping authoritarianism across many parts of the world, you too, as citizens, have joined the ranks of the foot soldiers. Foot soldiers who teach in classrooms, exhort in rallies, publish in the media, petition the courts, and speak in our legislatures, all to preserve the essential elements of an open society where we can challenge each other's ideas and contest each other's positions civilly with words. As Pampa Kampana, the central character in Salman Rushdie's wonderful novel Victory City, reminds us, while dynasties and empires are transient, words are the only victors. In your careers as lawyers, words will be a constant companion in documents, in statutes, in the Constitution. But most of all, whether in discussions with your clients or in dialogues with the judge, you will have to find the right words to define and describe images and ideas. In these constructs, basic structure, creamy layer, severability, curative, public trust, that play a balancing role in preserving and protecting our Constitution. Your career in the law is likely to be an extended tango with words. Last week, a friend of mine from the law publisher LexisNexis explained the dazzling abilities of their AI products. The capacity of these platforms to draft pleadings, documents, and research papers, something I suspect a segment of this audience is all too familiar with, left me wondering how this powerful technology might rupture our 5,000-year-old relationship with language. But let us look back before we look forward. In the use of words with felicity, none surpassed Iqbal Chagla, whom we lost in January this year. Allow me to open with a tribute to Chagla, who was just 10 years of age when the Constitution came in force. Chagla exemplified the best in our profession. Apolitical and liberal, Mickey Chagla, as colleagues and friends knew him, was a role model at a time when we need them more than ever. As a junior lawyer assisting him, or as an opponent, or simply as a briefless bystander watching counsel in action, what struck one when you heard Chagla in court was the persistence of excellence. Chagla was extraordinarily persuasive and measured in the courtroom. Neither cunning nor elbow were of any use to him. His dominance drew on his integrity, the ability to simplify knotty issues, and a mastery over law and facts. These qualities enabled him to pick a principle and then shine a bright light to the destination desired by his client. As president of the Bombay Bar Association, Mickey Chagla led the bar at a critical phase in the history of the Bombay High Court. In 1994-1995, the Bombay High Court was buffeted by a storm of corruption that implicated the sitting Chief Justice A.M. Bhattacharjee. During a brief phase, the stench of corruption hung over the High Court. There was a strong buzz that the original side judge hearing motions, as well as the appellate bench presided over by the Chief Justice, could be fixed. Does this work? Next slide. Thank you. At this point, members of the bar obtained copies of fax machine correspondence between a certain Roebuck Publishing based out of London and Chief Justice Bhattacharjee. Roebuck offered and paid thousands of dollars as an advance royalty for commissioning books on Muslim law and Hindu law, authored by the Chief Justice. The Muslim law advance was $80,000, which the Chief Justice received. A search in the British Council library revealed that Roebuck was not listed in the catalogue of British publishers. The London address of Roebuck turned out to be a residence. Roebuck had no number listed in the London telephone directory, a business imperative for every publisher at that time. A call to the number listed on Roebuck's letterhead was answered by someone who had no clue about Roebuck. The huge sums transferred from London to Bhattacharjee appeared dubious. I recall Mickey Chagla characterizing the remittances as hawala transactions. What eventually tipped the scale and spurred the Bombay Bar Association, led by Chagla, to move forward was a decisive deposition. Senior advocate Suresh Parekh confirmed that a gentleman who had no connection with the litigation attended a preparatory conference in a case where Parekh was briefed. Upon inquiring, Parekh learnt that the stranger was a tout engaged to fix the bench. Eventually, the immense pressure brought by the Bombay Bar forced the resignation of the Chief Justice. What you have now is on the screen, and possibly a not very clear copy, is a letter with Chagla's signature at the top, at the bottom left, which was after the assurance of the Chief Justice Bhattacharjee to resign from his position. And it's a letter of request sent in February 95 to the Chief Justice of India to appoint someone of integrity to replace Chief Justice Bhattacharjee. I suspect none of this is part of your curriculum, but these are lessons in courage and public service that may help you in the next chapter of your careers and as foot soldiers to protect constitutional values. Miki Chagla's vision of the Constitution was, and I borrow the expression of the learned judge, inclusive. He believed in capacious societies, not societies driven by competitive slighting of others. In the courage he displayed and the public causes he espoused, Iqbal Chagla was a towering leader of the bar and a champion of the Constitution in its first 75 years. I share his story of excellence in the knowledge that each one of you has the quality and caliber to build on this legacy. 3 books serve as a viewfinder to focus and frame the Supreme Court in its early years. The first is a wonderful book by B. Sen or Barry Sen, 6 Decades, Politics, Law, Politics and Society. The second, which I commend to you, is George Gadbois's Judges of the Supreme Court of India, 1950 to 1989. And a third set of volumes, it's actually in 2 volumes and they're awfully heavy, is Justice Sudhir Kumar Katriyar's Saga of the 3 Top Courts of India, published in 2022, with its generous display of photographs of the Privy Council, Federal Court, and the Supreme Court of India in the early years. What do we learn from these accounts? Barry Sen, as he was popularly known, was called to the bar in 1946 and commenced practice in London before the Privy Council. A few months after the Constituent Assembly passed the Abolition of Privy Council Jurisdiction Act around June 1949, Harilal Kanya, Chief Justice of the Federal Court, visited London with his family on a vacation. He urged the Indian barristers to move to India and form the nucleus of the resident bar in Delhi ahead of the establishment of the Supreme Court. Upon the inauguration of the Supreme Court, the 6 judges of the Federal Court became the judges of the newly constituted Supreme Court. Upon its inauguration, the Supreme Court took residence, and this is what's on the screen, in the Prince's Chamber in the then Parliament House. The Prince's Chambers was home to the Federal Court for 12 years, and the Supreme Court continued there for 8 more years until a new building where it currently resides was ready in 1958. The Supreme Court building has some extensions, and in the middle of last year, it suffered one of those Botox facelifts gone bad. The magnificent open sandstone colonnade fronting the first 5 courtrooms are now backed with a sheet of glass and a grid of steel. Let me take you to those images. So this is the grid of steel, and this is the glass backing the colonnade. This new look is already coming apart. Last week, I discovered that 4 or 5 sets of doors had been removed to allow free passage for the scores of lawyers who previously moved onto the adjacent terrace, but found themselves post-facelift confined to a corridor. More surprises await us. Last October, a stealthy initiative to remodel the Supreme Court building was suddenly announced, unbeknownst to the bar and the public. The images released suggest a stunning lack of aesthetics, with the CPWD providing a standard fare design. No consultation with the bar, the primary stakeholder, no public consultation, no architectural design competition. How I wish these new plans might say what the Mexican artist Frida Kahlo said: I joyfully await the exit, and I hope never to return. Of course, the Supreme Court just a few years ago did not think that Indian democracy, or indeed the Indian people, enjoyed a right to an open and fair design process for a new parliament building. The new parliament building, which I pass every Sunday morning on my way for a game of badminton, is hideous. Its high perimeter walls are chunky and look and essentially proclaim, "Citizen, stay away." So the citizenry, including the bar, will have to push especially hard to require the Supreme Court to adopt transparency and consultation in the remodeling of the building. As with the Central Vista case concerning the Parliament building, remember Vinod Kumar Shukla's poem, translated from Hindi by Arvind Krishna Mehrotra in a slim volume titled Treasurer of Piggy Banks. Shukla writes, "Defeated, the man sat down. I did not know the man, but I knew defeat, which is why, going up to him, I extended my hand. We walked side by side. We did not know each other, but we knew how to walk together. As foot soldiers committed to constitutional values, you, me, us, we will have to pick ourselves up from defeat and battle using words and ideas to preserve an open society." Parliament has raised the strength of the Supreme Court from 8 in 1950 to its current strength of 34. These changes are brought about by amendments to a short act named the Supreme Court Number of Judges Act of 1956. The act was periodically amended to increase the sanction strength, the last amendment being 2019. The increase in strength has been justified by the increase in the workload of the court. This increase, most unfortunately, has not been inclusive. Inclusivity has many, many dimensions, and I will just dwell on one. We are far behind the rest of the world in gender parity. Today, our Supreme Court has just 2 women judges. I wonder whether this is visible across the room, but I'll just summarize it for you. It's a comparison on how we fare against other global courts, just in terms of this issue of gender diversity. So in the Supreme Court of the United States, as you may know, 4 of the 9 judges are women. In the Supreme Court of Canada, a majority, which is 5 out of 9, are women. In the Constitutional Court of South Africa, the number is 4 out of 9. Kenya has 2 out of 7. The Federal Court of Malaysia, apart from Chief Justice, has 5 out of 11. And the number is 3 out of 6 in New Zealand and 4 out of 13 in China. We are, as you can see, laggards in this department, with just 2 Supreme Court judges being women out of 33 currently in harness. Diversity on the bench will improve the quality of justice. We have an exclusive club of just around 10 women judges in the history of our Supreme Court. This is a dismal figure, anachronistic and out of step with the world. The Supreme Court owes it to the nation to swiftly increase the number of women on the court. In the formative years, the SLP filings in the Supreme Court were thin. And in Barry Sen's words, perhaps not more than 20 in a whole week, as most of the cases would come up on a certificate given by the court. Sen continues, and I quote, "During the last few days of the federal court, I made it a point to watch the proceedings to get used to the way advocacy was practiced in the highest court in India." Remember, Barry Sen started off in the Privy Council. Happily, there seemed to be little difference between the way cases were presented or judges reacted to counsel's arguments from the way it happened in England, either before the Privy Council or the House of Lords. The 6 judges who adorned the bench of the federal court seemed to be as traditional as the judges in England, and no less in stature and legal learning from their English counterparts. So this was his first impression of our federal court and the early years of the Supreme Court. No difference really before this court in India and the one which he practiced in initially, which was the Privy Council in London. The Supreme Court in its early years was a court of a more conventional mode, similar to the apex judicial forums elsewhere, aloof, remote, careful, circumspect, and limited in its engagement with the citizenry. The court was primarily an interpreter of laws and the Constitution, and the final arbiter of disputes. The court today is recast in a different mold. It no longer resembles the apex courts of other democracies, which have retained their traditional form and role. Why did this happen, and how did this come about? So I'm sure some of you have surely read about this, and I'll sort of point to a few factors. But how do I see the current role? So the court really has reinvented itself from an interpreter of laws and the Constitution and disputes into something quite different. It's a facilitator of better governance in a vast land now home to nearly 18% of the global population. And along this journey is a search for legitimacy and relevance. Now, institutional legitimacy is something quite distinct and different from just finality. Of course, we know that finality you require in every system where you have disputes, in every complex society like ours. But legitimacy is something much more, because legitimacy speaks to and speaks about confidence which arises from the caliber of the work and the product it delivers. And here you will find that as far as courts generally, not just the Supreme Court of India, is concerned, it comes essentially from the caliber of their judgments. Are they well written? Are they well reasoned? Because that's the connect which a court makes with the citizenry. We have respect for your independence. We have respect for your integrity. And we have respect for your learning of the law. But then you must come with a series of judgments which establish your legitimacy. And I think this happened in the first 2 decades of this establishment of the Supreme Court of India. The judgments, and I'm sure all of you will have occasion to visit them, are not just concise, which is an extraordinary virtue forgotten by the current lot, but they are precise and narrow on the very issue which the court is required to confront and decide. Unfortunately, as you know, there was a complete devastation of legitimacy during the illegitimate emergency. And during the illegitimate emergency, while 12 high courts unanimously stood up for the citizen and upheld, for example, the right of habeas corpus, the Supreme Court capitulated tragically, dishonorably, and it found that its legitimacy was at an extraordinary low. The first connection between the court and the citizenry is the bar, of which you will shortly be members. The bar is a very respected institution in our society because each one of you has the advantage of education. We have a default position where a number of our freedom fighters, and particularly from the leadership, came from the bar. So you have the advantage of wind behind your sails and a certain degree of goodwill, which continues to this day. And I think the citizenry in all democracies expect guidance from leaders of the bar. And when post-emergency, you have, or during the emergency, when you had the reputation of the Supreme Court suddenly crashing and coming to a low, it required, and as transmitted across to the citizenry through members of the bar, it required a reinvention and a rediscovery. And that is when the Supreme Court of India, in the late 70s and moving into the 80s and early 90s, went into this area or adopted this strategy in terms of having a direct connect with the citizenry. And that came through, as you know, the lowering of standing, increasing access to justice and access to the court, actually, and then taking up issues which were human rights related, later on, which were environment related, which the public could connect with in an exercise to rebuild its legitimacy. So this is one element which is taking place, or one feature in which the court is really opening up. So I recall the senior lawyer I worked with, Mr. Temta Nandyarujina, mentioning that in the early days of the Supreme Court, when he used to accompany Sirvai's junior, he would say that the registry of the Supreme Court, that time there were 4 or 5, key advocates on record. So there was J.B. Dada Chanji, there was Gagrat and Company, there were a few others. And a call would go from the registry to these law firms saying that, do you have any special leave petitions for filing next week? Because the order of business appears to be a little thin next week, and the judges don't have as many, cases to occupy them. So if you have some SLPs in the pipeline, please do file them so that we have a busy week next week. Now, this is an absolute far cry from the situation which we're in today. Because the other major feature has been, and this is a concomitant of the tribunalization of our justice delivery system, that probably requires a whole, a seminar on itself and a lot of thinking. But what happened because of tribunalization is that very unfortunately, our high courts were cut out of it. And so you have situations where subject matter jurisdictions are landing up for the first time before the Supreme Court of India. And for the Supreme Court of India, judges themselves, they're learning about a particular discipline for the first time. Now, it's good to have generalist judges. I'm in favor of that because, you get a broad, sweeping approach, particularly when you're picking on principles, etc. But this burdening of the Supreme Court with statutory appeals coming up, previously and traditionally, it used to be from the tax tribunals. Then it extended to the Securities Appellate Tribunal. Then it goes now, of course, directly, as you have seen, under company law. It goes to the NCLAT and it pops up in the Supreme Court. So you're very shortly going to have a whole generation of judges who don't know company law because they have never really studied it in the high courts as practitioners. So you do it in, distinguished law schools, and then you just shut the book and forget about it, and then you pick it up when each one of you is up there in the Supreme Court, or some of you are up there in the Supreme Court of India. So that's a fair sort of deal of a gap in knowledge, learning, and experience. But that's, again, enormously burdened the court. It's enormously changed the nature of business, which the court did in its early decades. And it sort of moved into what some might describe as a miscellaneous court in many, many respects. So the role now of the Supreme Court, as I see it, is first balancing competing claims. Claims between private interests or private parties, claims between the citizen and the state, and between now and tomorrow. And in this regard, again, there is a short game and a long game. The short game is the one where you find that the court is essentially seeking to protect itself. It's the pragmatic court. And you might be able to explain some of the judgments during the emergency by this pragmaticism. The fact that it survives today as a single united institution is in no small measure credit to the Supreme Court of India itself for the manner in which it has restored its legitimacy, made a connect with the citizenry, and remains extraordinarily relevant to the people of India and for the preservation of our open society. So what you do find when you have political winds of a strong type buffeting institutions because of a strong executive, because of a supermajority in parliament, that courts institutionally, I wouldn't use the word retreat, but I'd use the word sort of are infused with a certain pragmaticism where, you nod and you wink and you really know what the answer should be, but you defer consideration or laying down some hard principle to a future generation of judges, and you just play along and you uphold governmental action. So that's often the near-term imperative which takes place in court, during the clash of ideas and principles. And then there's the long vision, which I will come to. But I think the court long vision is essentially to preserve an open society in this part of the world and to virtually 20% of the population. I mean, that's what the court has to do and ensure doing over the next 75 years. Let me just briefly mention what I think the court has done either very, very well or indeed well enough. I think it's done extremely well in promoting constitutionalism. There was, I hate to say it, I remember reading it it's by Sirvai. And the problem is I've looked for this passage so often in Sirvai's book and never found it. But it's in one of his writings where when he's talking about Article 226 of the Constitution of India and the writ remedy, and Sirvai was mostly, he of course argued the fundamental rights case, etc. in the Supreme Court, and he was a distinguished presence in the Supreme Court of India on so many occasions, Needle Industries for those of you who like company law. But he was essentially based out of Mumbai, and he wrote his great constitutional criticism sitting out of Bombay and, observing what was happening across the country. And he writes and says that, look, it's not every writ which you, gentlemen in the High Court, issue. I mean, for Sirvai, you could say, you, gentlemen in the High Court. I have to say honorable and whatever. But he said that the bureaucracy now knows, in Bombay it's Mantralaya. Mantralaya now knows that if the officers do something wrong, then there is a writ court not very far from here which will issue an injunction and which will issue a writ. So in promoting constitutionalism, getting it to permeate, to getting it to sell this idea that, look, we have a supreme law and let's try and follow it. Let's be invested in it. I think the Supreme Court has done extraordinarily well. Second, I think in preserving, protecting judicial review and extending it over constitutional amendments, I think that's been a terrific job. And that's, of course, Keshavananda Bharati. But there's a single line, and you can see a pushback coming from various quarters. But it takes at least 100 years. Now, of course, the American example tells us that even after 240 years, democracy can still be in peril. So that's an important lesson for all of us. But constitutional scholars generally feel it takes about a century for various segments in society to figure out their roles, responsibilities, powers, and boundaries. So for each one of you, you've got 25 years more of excitement in the constitutional space, for sure. But with guys like Trump, who knows, it might be even longer. But that's just to tell you that constitutionalism takes while to this thing. Judicial review, preserving it, protecting it, expanding it as no other court anywhere in the world has done, is great credit to the Supreme Court of India. I think in enhancing access to justice, the Supreme Court deserves high marks. Holding on to the basic structure theory or the implied limitations theory, which I mentioned, being a crucial part of the appointment system, which continues to identify and persuade for judicial office persons who are really good judges of integrity, who any system should be proud of. I was essentially a practitioner in Mumbai before I decided to sort of decamp and shift practice to the Supreme Court. And like many vanities of people from Bombay, I thought that, okay, we've got the cat's whiskers in terms of judges. But then when I went to the Supreme Court, I realized that the Supreme Court of India is fed from across the country by judges. And we have such outstanding judges across the country, not just in this metro and that metro and this, major city of old conventional high court. We are able to produce judges of the finest quality, who would rank at the very top of the pyramid anywhere in the world. And that's because of training of institutions like NALSA. Even in the pre-NALSA and pre-whatever law school days, we obviously have a system which produces and channels great degree of talent up there. And I think the court has to be credited for being able to identify excellent judges over decades and decades. Next, preserving the vitality of our fundamental rights. So the judgment, I guess, reported this morning's papers. It came out yesterday. Imran Pratapgarhi versus the state of Gujarat is a case in point on freedom of speech, where the Supreme Court has really categorized and pushed back. I don't know whether I'm in any peril over here. I guess this is a bit of a safe space, but who knows? But our comedians, our persons who are pushing boundaries of satire, cartoonists, all sorts of people engaging in free speech, this will be a real shot in the arm for them because it reinforces our fundamental rights. Evolving constitution, not constricted to the original vision. I mentioned this because there are competing theories. In India, we are very happy to have this theory, which is firm and which is not likely to be upset, at least in the course of my career, that the Constitution is an organic document responding to the challenges of moving times. We are not originalists in our vision as you have in certain other jurisdictions. In new manners of governance through judicial intervention, I think the court has an enormous learning in this, where they realize that, look, there's a lot of work going on in law schools, in academia, apart from the law, institutions. There's work in think tanks in governance, but there's a bit of a gap. NGOs have so much specialist knowledge, but there's a gap. And so you will find across our judgments, to improve the quality of governance in this country, they have lent an arm and pushed and joined, actually, built a bridge sometimes between these ponds or pools of expertise and the governance to have better legislation moving forward. I think the court's been good, except on itself, in terms of advancing and protecting diversity. Most important, it's preserved itself. It isn't fractured and splintered physically. We don't have factions in the Supreme Court of India. You will, from your library, pick out a book called Courts in Glass Houses by Chief Justice Shah, former Chief Justice of the Pakistan Supreme Court, where the Pakistan Supreme Court sits in benches. So one bench was sitting in Karachi. The Karachi Chief Justice was, the big daddy there because they didn't have their own building. So he would assign the Supreme Court bench in, the corner next to the toilet block or something of that sort, not quite toilet block, but would reduce the prestige of the Supreme Court. So in the Supreme Court in Pakistan, it's kind of fractured because it has these benches. And then he also writes about an incident that, again, harks back to the days of facsimiles, where the cause list would come from different, the Chief Justice thought as master of the roster or whatever, he would decide the cause list. But you'd have a splintered court and you'd have all these competing claims coming from different parts of the world. So I think in preserving yourself as an institution is very important. And I'm very delighted and glad that it isn't fractured and splintered. I think in expanding human rights and recognizing new rights, and in protecting the natural resources and the environment, the court gets a very, very high grade. What has the court done badly? I think it's, in terms of diversity, I've mentioned that. I think there's a huge, huge deficit and things must move forward. The second big point which I'll make is we concentrate too much power in the Chief Justice of India. And there was I recall hearing this. There was someone was talking about or trying to define an institution. And the definition he came up with was an institution is something like the State Bank of India. So this is why. So the next question was why? What's so special about the State Bank of India? And the answer was that even if you make a monkey the chairman of the State Bank of India, it will still function. It has everything in place. It has systems in place. It will move. It has protocols in place. It has a history. It knows what its job and its business is. So institutional structures don't depend on individuals. They depend upon a much broader framework or network of checks, balances, responsibilities, divisions of labor. And I think that is somewhere where the Supreme Court of India, of course, it's a question of giving up power, which is always a very difficult thing to do, but it's something which I believe in the long term might help the Supreme Court. I think it's too large for its own good. I believe 34 judges is too large. You have the wag in the courtroom corridors, and some of you must have interned in the Supreme Court, would probably know. They don't even describe it anymore as the practitioners, and the local wit. They describe it as the Supreme Courts of India. Because, there's 16 courts just now currently functioning. It's not a one single united court. If you want to have authority, legitimacy, you don't want to talk in, rival tones. You want to provide a certain direction to the law for a vast country and for, as I said, 18% of humanity. Then I think a more compact court is probably a wiser way. Larger benches is a wiser way. What we do with our cases, and on that, I think I have, so this is the national grid last taken on the 25th of March. So it has 81,000 pending cases in the Indian Supreme Court. And this is, it rivals with something like less than 100, which the US Supreme Court disposes of. This is probably pendency across the country. The other couple of points which I will quickly make is that I believe it has failed to tap adequately with a large reservoir of talent and ability, both at the bar and amongst our judges who are not necessarily chief justices of a high court across the country. I think we need a system of appointments which really recognizes talent across the country. You don't have to be a chief justice in the high court. We will bring you up. I think that will incentivize the delivery of justice much greater. One of my favorite points is the folly of too much public service. I think when you have judges who think that public service is invariably deciding in favor of the state and against the citizen, both during your tenure and hopefully post-retirement if you get some post or something like that, it skews the vision of doing justice in the case before you and deciding as you ought to. Because I believe public service under this constitution over the next 75 years is going to involve this issue of balancing between citizen and state, but also citizen and corporations. And that's going to be a huge, huge challenge. So your notion of public service may have to change. Our understanding of public service of, always and invariably deciding in favor of one party may have to radically alter if we are going to preserve our constitutional values, etc. I will end with an addition to the Bengaluru principles of judicial conduct. So the 6 core values are independence, impartiality, integrity, propriety, equality, and finally, competence and diligence. These principles were adopted by the United Nations Basic Principles on the Independence of the Judiciary in July 2000. Perhaps, as suggested by Justice Michael Kirby from the High Court of Australia and Nihal Jaivikrama of Sri Lanka, we need to add another core value: courage. It's going to be an imperative quality to preserve our open societies and democracy. Allow me to end with a reading by Wendy Cope. Everybody in this room is bored. The poems drag, the voice and gestures irk. He can't be interrupted and ignored. Poor fools, we came here of our own accord, and some of us have paid to hear this jerk. Everybody in the room is bored. The silent cry goes up, how long, O Lord? But nobody will scream or go berserk. He won't be interrupted or ignored. At last, it's over. How we all applaud. The poet thanks us with a modest smirk. Everybody in the room was bored. He wasn't interrupted or ignored. Thank you. Thank you very much.
Thank you so much, Mr. Diwan, for this incredible presentation. All of us are left in absolute awe, and I'm sure that I speak for all when I say that it was truly an honor to have had the opportunity to benefit from your vast knowledge and experience. So I would now like to call upon Dr. Vasanti, Registrar Nalsar and Professor of Constitutional Law, to deliver the vote of thanks.
Good afternoon, everyone. Distinguished guests, faculty members, students. I have the pleasure of proposing a vote of thanks to our distinguished guests. Let me begin by thanking Justice Vijay Sen Reddy for taking time off from his schedule to come join us in this conference and extend the support of the judiciary to our conference. Thank you also, sir, for highlighting the idea of a living constitution and the values of peaceful coexistence and making sure that this conference will not lose sight of the little Indian at the end of, for whom the entire constitution has always been designed for. I would like to also thank Senior Advocate Sham Diwan for his presentation, assuring him, sir, that I don't think anybody in the room was bored at all. Thank you so much for highlighting the need for courage in these difficult times, and also making sure that all of us assembled here acknowledge our role and responsibility in making sure that we are the foot soldiers of the Constitution. And it is the Constitution as it is played out every day, not merely in the big cases in the Supreme Court, but on a daily basis. And the need to preserve this space and to preserve this Constitution, as well as the idea that unless we all walk together in this and walk with each other, then the question of preserving this Constitution is indeed going to be quite difficult. Thank you for setting out the vision for the next 75 years for all of us. Many students in this hall, we hope to see them back in many years to see how far this vision has been taken forward. Special thanks to the faculty who really put this program together, to all the distinguished participants who are coming here to make sure that we have an exciting weekend of discussions, and also to the organizing team of students, the special effort to make this sustainable and remove plastic. I really appreciate that. I hope all of you have a wonderful conference. Thank you.
We would again like to thank the chief guest and the keynote speaker for truly inspiring our students with the legacies that have shaped the Constitution. We would just like to request VC sir to present mementos to the chief guest and the senior advocate, Sham Diwan.
Guys, thank you so much for this session. Can you just stay back for 2 more minutes here before leaving? Uh, yes, yes. Uh, Professors and panelists can go in front of Thinking Men near Moot Court Hall for tea and coffee. There's also constitutional law exhibition there, so you guys can visit it. And all the students are requested to just stay back here for 2 more minutes.
Sadan is also the advocate who did the case in Delhi. That will be followed by Dr. Sambaya. Sam is a colleague from Ajim Premji University. We were colleagues together in School of Policy and Governance, and now Professor Sambaya is part of Kriya University near Chennai. And he has a particular position. He has already written about it. And he also wrote about the Dalit politics in Andhra, Telugu states. So he is very much knowledgeable, and he is going to give his own take on that particular case. That will be followed by Sri Krupakar, who is the co-founder of the Madiga Reservation Porata Samiti, very much based in Hyderabad. He is going to speak in Telugu. That's what his comfort zone of language would be. And Professor Murali Karnam kindly agreed to translate. So he's going to help us understand what the presentation of Sri Krupakar is. And that I suppose, would be also on the subclassification and the struggle within the states here. And followed by, finally, we'll have a broader perspective on this matter is Professor Nandini Sundar from Delhi School of Economics, prominent academic, and whose academics as well as activism most of you are familiar with, including her work, The Burning Forest, and the question of the tribal rights issue, I think is very, very familiar and already known in the law schools, particularly the kind of work she has done. So I'm so grateful to all four of you for agreeing to be on the panel. And we want to more hear and learn rather than me standing in between. So may I therefore invite Sadan, you can just stay there and speak.
Thank you, Professor Sitarams. It's a real privilege to be here with you. Professor Sitaram taught us in the early 2000s, taught me and my entire batch and a whole bunch of us, a whole range of subjects, which changed our perspective on life completely. And we came in as robos into law school and graduated as human beings thanks to him. And so you guys are really lucky to have him as a professor teaching you. Make full use of him because he's a rare commodity, or I won't call commodity, rare. Podium is better? Yo, I'll go to podium. So I'll just comment that you use his teachings to the best possible way you can. And with that, I'll begin on the issue today. So effectively, just in terms of, before I dive into the issue of subclassification, in terms of reservation in India, I think one thing which we need to keep in mind, which I picked up really as a part of practice, is that in India today, reservations are really for the electoral majority. When you include SC, STs, and OBCs, they're about 75 to 80% of the population. I think India is possibly one of the few countries, if not the only one, where reservation is for an electoral majority. And that's a huge political and constitutional impact. Because what it effectively means is that you work around in terms of how to make it work, to expand it, to control it. But really in terms of questions of whether it should exist in the polity, that question really at any fundamental level does not arise. So be it a government of any political color, left, right, center, or be it a Supreme Court, and irrespective of their own judicial philosophy, the engagement you're going to see is engaging with reservation broadly. You won't have a situation like you have in the United States today where, a president comes and says, DEI, out you go. Because DEI is effectively for the black people, their electoral minority. They don't vote for Trump. He can afford to say, okay, out you go. That can't happen in India. And I think that's a huge distinction when we approach, I think that we have to keep at the back of our minds when we are discussing reservation in the Indian context. Neither can the government nor can the court really unless there is a complete overhaul of how the society is and we reach that objective, can prematurely remove it. Let me put it this way. So that's the broad background. Now, in the context of this, what was the subclassification issue? The subclassification issue, in effect, was that SCs and STs are defined under Article 341 of the Constitution, and that definition happens basically by the president putting in the list for each state a bunch of castes which are either the scheduled caste, and that's why they're called a scheduled caste, because they're in that schedule, or a scheduled tribe. And there are varied castes which are put in that list. The only way that list can then be changed is through a parliamentary amendment. Even the president herself or himself cannot change it. So once these lists came in 1950 at the time of establishment of the Republic, thereafter amendments to that list, that to bring out somebody or put in somebody in a state list, say of Karnataka or Telangana or Maharashtra, you will need the parliament to amend it through a simple majority. It doesn't need a special majority. So that's the scheme. In the OBC spectrum, the law already was that you can subclassify. So you can have more backward, and within the backward classes, that within backward classes has both OBCs and SC/STs. So SC/ST is one group. Other meaning apart from SC/ST, other backward classes are the remainders. So in the OBCs, you already had subclassification existing as a matter of fact and as a matter of law both. So there would be what would be called more backward classes within that. So within the OBC quota, you would take out a certain portion of that quota and make it exclusively for the more backward classes. So that was permitted. It has been happening. In fact, I think my understanding is factually it's been happening even before the law sort of expressly said it's all right. But in the context of SC/ST, that question was, can it be done? And there was a judgment, Chennaiya, which arose from Andhra. And that said it can't be done. And the logic of Chennaiya judgment was that, listen, once you are in that list which has been put through by precedent, if there is any further classification in that list, that amounts to tinkering with that list, is what the phrase which is used in Chennaiya. And if the president herself or himself cannot tinker, only parliament can change it, how is it that the state legislature or a state executive can then further classify it one way or the other? So Chennaiya said, once you are in that list, you are cast in stone. There can't be any further classification because of the nature of Article 341, 342, the manner in which that list is brought into existence and how it can be amended. So that was Chennaiya. Then, of course, this issue again arose, and Devender Singh is the judgment in which Chennaiya has been overruled last year by the Supreme Court. Devender Singh is the matter which arose from Punjab, unlike Chennaiya, which arose from, although there were interventions and other petitions even from Andhra in this bunch as well. And what we effectively, I was for the state of Punjab, I argued the matter. And what we effectively put before the Supreme Court was that, listen, you can obviously have varied positions between the caste, between a scheduled caste also, although all of them have commonly faced untouchability. That's the marker which joins them. But nevertheless, there could be differential access to that quota. So the more backward amongst the scheduled caste will have possibly zero access to the scheduled caste quota. It's a reality. I mean, data shows it in state after state where that data has is available. And a lot of states that data may not be available. So factually, there is actually a difference. And secondly, if you can take out, even if the parliament can take out a certain category out of it. So you put a scheduled caste list, you can take out, you can add. How do you take out? You take out that caste itself, right? Now the Chennaiya argument was that once you are in that list, you are a homogeneous group. It's like you are mixed with, sugar is mixed with water and you can't differentiate between what is sugar and what is water, right? We said, no, that's not the case. It's like a salad bowl. It may have different components, but you can pluck out of it. So even when the parliament plucks out that caste and puts it as a non-scheduled caste, how does it do it? Obviously, that caste retains its existence quite apart from the fact that it has been put in that list. So therefore, this reasoning in Chennaiya that once you are in that list, you are a homogeneous group is wrong. And for the purpose of Article 14, 15, 16, to actually ensure substantive justice to all groups within the scheduled caste group, you need to be able to differentiate. And this time around, the Supreme Court agreed with us. And they said, yes, it can't be a homogeneous group. That is incorrect. There are differences. And therefore, subclassification should be permitted in SC/ST just like it is permitted in the OBC groups. 341 is not a bar on it. In fact, the mandate of Article 14, 15, 16 of substantive equality requires you to have such classification if the situation so warrants. So that is on the subclassification thing. The other aspect which was not really before the court, which is that creamy layer question within scheduled caste, scheduled tribe. Now, in an earlier judgment of the Supreme Court called Jarnail Singh, they had said that creamy layer, Justice Nariman's judgment, creamy layer is permissible under even SC/ST. Here, the creamy layer question did not at all arise. It's a question of subclassification within the SC/STs. But the reference judgment, that is the judgment of 5 judges which referred the Devender Singh matter to the 7 judges, also took upon itself to deal with creamy layer in a very assertive fashion. It was Justice Arun Mishra's judgment, and it went on about it. And I think this bench, although before the 7-judge creamy layer question was never really argued by either of the sides, because subclassification was the issue, the bench picked up on it, and 5 out of 7 judges have in fact said that, oh, creamy layer in SC/STs is permitted. I think that is a clear error. A, because the issue didn't arise, but even on substance, even Jarnail Singh, I feel, is wrong. Because I think that position they're coming to more from an academic perspective of saying, oh, if you have the advantages in one generation, like 2 of the judges say, if you are IAS or IPS in one generation, next generation should not get it. Correct? Now, creamy layer question is by itself an individual economic question, right? How do you pluck out the creamy layer? You say, okay, this is the group, you belong to the group, you're entitled to reservation as part of the group, but economically you are above this threshold, therefore we pluck you out of the group. That's the creamy layer. Now, there are 2 problems with introducing creamy layer in SC/ST. One is, in SC/ST, if you have any touch with reality and you look around us, in any system, I look at the Supreme Court, the bar, the judges, in administration, secretaries, Government of India, additional secretaries, Government of India, joint secretaries, Government of India, any positions of power which matter, there are barely any scheduled caste, scheduled tribe individuals. So where is the milk and where is the cream? The milk is the cream when it comes to SC/ST. It's not as if there is a large group. Creamy layer was nomenclatured such because it's the cream which floats on the top. So there is a substantive bunch which is otherwise there, which will benefit. But the cream which floats on the top, you pluck out the cream, you take it off, skim it off, and then the rest of the milk can take advantage of it. Here, the cream is the milk is the cream. So therefore, the question of actually having a creamy layer in SC/ST is counterproductive. You're going to take away the representation which they provide in those posts per se. I think it's a hugely problematic judgment. Interestingly, none of the governments, not a single government, any state government in India or the union government has acted upon it. Nobody has classified as creamy layer. Because here, in fact, in this instance, the governments are more in touch with reality than the Supreme Court. Apart from the point which I first made, that electorally, it is not going to be easy for them. So, creamy layer, I think there was no issue which arose in this case, and they have completely, I think, got it wrong, even on the merits of it. Insofar as subcategorization and its critique is concerned, one critique which arises is, I support subcategorization. I think it is the right view for the court to have taken. Till the time you cannot exclude a caste completely out of the schedule. So you can't say 99% or 90% or very high percentage. You have to have a general pool of scheduled caste. And then you have, like, say, 50% you have a general pool, and remainder 50 you divide 25 for, say, one caste, which is relatively backward, another 25 for somebody. And you can give it on a preferential basis. So that is, if candidates are available for from that subcaste, then they will get. Otherwise, it goes to the regular SC quota. So it's not like it's necessarily taking away as well. Now, if that is the case, then I don't see any problem at all with it. It does not necessarily impact the so-called other non-backward SC/STs. But I think one thing it's very important to realize that when we are dealing with subclassification, we are dealing with a weak and a weaker group. Nobody is really empowered in that group. I think when the Supreme Court mixes up the creamy layer question with the subclassification question, they mix up the fact that they bring the forward caste, backward caste and mirror it exactly in those terms in subclassification. One is better off, and then they say, oh, creamy layer is better off. That is a complete mixing of, they have to realize that actually this is not really to knock out the relatively well-to-do scheduled caste in that sense who have had access to jobs. This is to bring up the ones who have not had access to jobs or governmental or education. So by mixing up those two questions, I think the Supreme Court commits a very, very fundamental error there. Apart from that, let's see how this plays out. It's early days yet. Most governments are in the process of, state governments I know are in the process of actually getting data or putting out commissions or doing things, which will then sort of, the test for bringing something as a, in a subcategory is that you have to be backward as per the definition of backwardness. And secondly, that you have to have inadequate representation in either the government or in educational institutions. Now, so both those things have to be satisfied through data, which will be done through a commission inquiry or whatever mechanism they follow. Once that is satisfied, then you can subcategorize them. So how it will play out, we'll have to see. It's early days. Let's see how the governments come out with it and factually how it works. But I think what I noticed in the Supreme Court, interestingly, was that within the SC/ST group, this has created a schism because the groups which were defending it were the groups which have conventionally benefited. Although they're still definitely a weaker group in the society, have conventionally benefited from the SC reservations. So they were the groups which were saying that the Chinaya position is right and therefore there should not be any subcategorization. So let us see how it plays out on the ground, both in politics and in terms of actual benefit, which is good. So that's my introductory comment. Thank you.
Yeah, thank you, Sadan, for all the legal niceties and the nitty-gritties to just help us understand what the real question is. So, Sam.
Friends, I am delighted to be here actually for the first time, in fact. And I sincerely hope that, this is just a beginning of a long and then meaningful association. I am actually hugely honored to share this space with Professor Nandini Sundar, Mr. Sadan Farasat, and Mr. Krupakar Ponugoti, whose unwavering commitment to justice for the marginalized truly inspiring. Professor Murli is also here. He was my super senior at University of Hyderabad. I'm delighted to see him as well. I'm also especially pleased to see Professor Sitaram Kakarala, my mentor and guide at Azim Premji University, who has remained a cherished friend and a source of support over the years. A special thanks to student members of the organizing committee, particularly Kirti, Satvika, Vishnu, Push, and Vaishnavi, for their enthusiasm and invaluable assistance in facilitating my trip and stay. It's very interesting. The title of the panel, Caste and Equality, is very interesting. Especially equality is the #1 enemy of caste, right? Caste and equality stand, I'm sure you all know that, an inherent contradictions, right? While the caste system of graded inequality that enforces rigid social divisions and determines social status, occupation, and access to resources, the principle of equality asserts that all individuals should have equal rights and opportunities, right? From this point of view, there is no space for the justice in caste system. The caste system, by its very nature, is based on structural inequality or hierarchy, exclusion and discrimination, and inherited privilege, that denies individual merit, which fundamentally contradicts the principle of justice, equality, and human dignity. Now, with regard to this, reservations, if you have to go back some 75 years, at the beginning of this constitution, so what this has done, without reservations, the Dalit communities, untouchables or scheduled castes, whatever the nomenclature you would like to use, they would not have able to access educational, employment, and then political opportunities. Without these reservations, we must truly speak to each other. Without these reservations, it would have been not possible for the marginalized community to access institutions of education, employment opportunities, or kind of political opportunities. Okay. And then there's also kind of an emergence of a small percentage of middle class. Without these reservations, and again, would not have been possible and all that. But this is another negative impact of this reservation is that the emergence of advanced caste within the Dalit category. And then, and so therefore, there's also marginalized community and all. I mean, there's a lot of historical reasons for that. But you see that, across India, for instance, like Chamars in, Uttar Pradesh, then you have this Mahars in Maharashtra, Holayas in Karnataka, Malas in Andhra Pradesh, and so on and so forth. You have this, slightly improved communities and all that, because the quota of reservations kind of confined is 50%, and then also the marginal communities kind of could not access these reservations. Therefore, the story of the subcategorization or demand for subcategorization began and all that. Now, I just wanted to kind of with this initial remarks, let's ask, how do we understand the Supreme Court's verdict in the state of Punjab? More broadly, how do we make sense of the entire question of the subclassification within the scheduled caste reservations, right? Now, in my opinion, and you're more than welcome to kind of disagree with me, the very existence of an administration called scheduled caste is not merely a colonial burden that we continue to carry in the post-colonial era. More significantly, it reflects the failure of the post-independence Indian state to realize the vision of our democratic republic, a vision that promises justice and equality to all its citizens, right? Now, it reflects the dominance of the upper caste political leadership, which continues to control education, employment, and political opportunities for the Dalits. It reflects the deep pervasiveness of the Brahminical mindset, even among the Dalits themselves. If you look at why Mala Mahanad has been kind of countering or kind of led a counter movement or arguing against reservations, against subclassification, you would understand that the mindset that's there, the caste mindset that's there among the upper caste, it's also kind of not confined to this upper caste. It's kind of there everywhere among all the castes, including those people who are kind of demanding subclassification as well. Nobody's kind of free from this casteism as such. Then it also exposes the hypocrisy of some Ambedkarite leaders, who demand justice for the Dalits as a whole, but deny the same justice to the marginalized among them. It also reveals the Indian judiciary's disconnect from socioeconomic realities, as it repeatedly fails to acknowledge the lived experiences of the marginalized communities. Imagine this is just the subclassification is kind of just a simple procedural thing, but the judiciary has kind of dragged it for 3 decades, 30 years. Okay. Now, the question before us is not merely legal or administrative. It is profoundly political and ethical. Now, can we truly claim to uphold justice while allowing internal hierarchies within the scheduled caste to persist, right? Well, Justice Bela Trivedi in Davinder Singh and what's the state of Punjab, believes that by providing reservations for the scheduled caste, justice has been upheld and there is no need for considering, inequalities within this group. Do you agree, is my question. Now, I am sure majority in this hall aware that Justice Bela Trivedi, the sole dissenting voice in 7-judge bench of the Supreme Court in Davinder Singh. Now, my friend, Sadan has kind of touched upon this homogeneity idea. I'll just kind of say my own take on that actually. So Justice Bela Trivedi rejections on the subclassification of scheduled caste reservations is built around this
three key arguments or themes, let's say. The homogeneity of scheduled castes, the subclassification tinkering with the presidential list, and then the subclassification, as a violation of Article 14 of the Constitution. I won't touch, all these things, but just kind of, a few thoughts. Now, allow me to address each of these claims very briefly. Justice Bela Trivedi's argument that scheduled caste should be treated as a single homogeneous category without internal subclassification for reservations. Now, her reasoning is based on constitutional interpretation, judicial precedent, and concern over social cohesion. Now, intent of the constitutional framers. She argued that the framers of the Constitution intended to uplift all scheduled castes collectively rather than favoring specific subgroup within them, right? Now, if I put this in a similar question, actually, kind of, the people who fought for independence, or kind of, people who wrote this in the Constitution, they just wanted to kind of upheld the justice for all the citizens in India. Then, would you say that, okay, from that perspective, you don't require reservations for the scheduled castes? I don't know whether you're kind of getting my point or not. I mean, justice required for all of that. But, the point here is what I'm trying to say, that, most marginalized deserve, better justice, right? Facilities and all. That's what I'm trying to say, that, Then, the whole idea of, tinkering with the list and all that, I mean, I really don't really understand that, whenever there is a kind of, context, socio-political, economic context, then you require, this is not kind of, something like, Vedas or a Bible or kind of, Gita, that you cannot kind of, change forever. And this is Constitution. And then Constitution for the people, right? Whenever there is a situation occurs, you need to kind of, change it. Again, for not kind of the way BJP is doing, but to impart justice for the marginalized. That's where my position is kind of. You cannot kind of tinker with the Constitution as you like, but then like if this is kind of has to kind of do for the marginalized, justice for the marginalized, then I would kind of say it. Okay, because nobody is going to hurt. You're only kind of giving justice to the marginalized, right? Now again on this idea of preserving collective strength and all that. Now. Trivedi's argumentation. Now, while I appreciate Justice Trivedi's concern for maintaining Dalit unity, we must recognize that the scheduled castes, as Sadan has kind of already told, that it's not a homogeneous entity; it's a kind of collective and all that. See, the diversities within scheduled castes is undeniable. People with vastly different social standings, occupations, and levels of discrimination have been grouped under a single administrative category. Now, in fact, if you look at this, the presidential list itself actually kind of contradicts the whole idea of homogeneity, right? Because it includes communities from different occupations and social standings, right? You cannot kind of say that all these snake catchers, charmers, and acrobats, and then watchmen, and then butchers, all kind of comes under one, or IAS and IPS people within this Dalit category, all come under one category, right? This kind of diversity, and shouldn't we kind of address this diversity within the Dalit communities and all that? Now, also, I just wanted to kind of ask. Why we need to kind of take this caste into consideration, not the homogeneity of this class and all that. For this marriage, some of these Ambedkarites also, for example, Gopal Guru, Professor Sukhdev Thorat, and other people have been kind of arguing that we need to kind of take this group into consideration rather than caste and all that. But these are the people who are kind of arguing that we should take into caste into consideration. Now, one question is that. For the marriage, Mahars, if they have to kind of marry someone, would they approach Mahars or monks? Obviously, they would be kind of going for this Mahars only, right? Then how can you say that all the Dalits are kind of one homogeneous community, right? It's not you go to this your own caste of people for the marriage, but with reservations, certainly you say that we are all kind of one kind of people. How justified that argument is at all. Okay. Now, I mean, in this case, actually, kind of at least, Justice Chandrachud is rightly pointed out, recognizing internal diversity within the scheduled caste actually, does not negate their collective identity. One of these, primary argument of, Justice Trivedi is that, it's going to destroy this, drawing from this, Justice Channaya's judgment, it's going to destroy it and all that. But it's not going to kind of destroy, Dalit category as such, right? Negate this category. Instead, it ensures that the most disadvantaged subgroups receive the benefits of affirmative action rather than allowing historically dominant scheduled castes to continue, cornering opportunities. So the question we must ask is this: is true justice achieved by treating unequal groups as equals, or by ensuring that those most in need receive the support they deserve? Right? Now, I just wanted to touch upon one point, and then I'm going to close. One of the arguments of those people who have been kind of demanding subcategorization, Mr. Krupakar Ponugoti will kind of explain in a better manner because he's one of the founding members of this movement for subclassification. On the question of representation, actually, then underrepresentation. I want to kind of touch upon this because it will kind of help you to understand what is this the movement's position all about. Now, the call for subclassification within the scheduled caste, reservation stems from this concern about underrepresentation. We require subclassification because we are not represented, we are underrepresented and all that. The general argument that an unequal or disproportionate presence of caste groups in administration constitutes an injustice. People who kind of it's not acceptable. Let's say this underrepresentation is not acceptable. They generally kind of come up with three arguments. They contest with three arguments. One is kind of lack of qualifications. Some argue that a group's underrepresentation in administration results from its members lacking the educational and necessary skills for these jobs rather than systemic injustice, right? They don't have qualifications, so that means it doesn't really kind of constitute systemic injustice. Then there is this argument, variability in career preferences. The assumption that a group's representation in bureaucracy should align with its democratic weight presumes a uniform aspiration for government jobs. However, preferences for occupations may vary among different social groups, right? Leading to disparities in representation that do not necessarily indicate injustice. As group, as individuals, we have varying preferences and all that. So therefore, the communities which are kind of demanding for this representation might not kind of have that aspirations, the preference for government jobs and all that. That's kind of one of the arguments that one can put forward. Then there's also middle class nature of bureaucratic jobs. Since administrative roles are largely middle class professions, some argue that that a group's low representation in them does not constitute injustice. Bureaucratic demographics would only mirror society if all social groups were equally distributed across the class hierarchy. Now, each of these claims, we can challenge it from the perspective of equity and social justice. Ram, just only 2 minutes maximum. Thank you. One, structural injustice and the skills gap. If a group lacks the education or skills necessary for administrative jobs, that itself reflects a deep-rooted structural injustice. This calls for a systemic solution, ensuring access to education, skill development, and affirmative action to enable fair participation in employment. Yeah. Then the second point is that social conditioning and restrictive choices. Individual preferences do not develop in vacuum, right? All the social scientists would understand this. They are shaped by historical norms, social conditioning, and available opportunities. Why Dalits eat beef? Why Brahmins don't eat beef? That's social setting. You must understand that. In caste society, lower caste groups have been systematically relegated to menial labor, their cultures devalued, and their aspirations socially stifled. Outside reservations, limited access to alternative careers reinforces these restrictions, discouraging aspirations for administrative roles. The combination of structural barriers and socially imposed inferiority complex erodes confidence and motivation, making it difficult for marginalized groups to access or to aspire prestigious jobs and all that. Now, dominance of certain castes and systemic injustice. While administrative jobs are inherently limited, we accept that. The dominance of certain castes and the exclusion of others signals institutional bias and discrimination rather than a natural outcome of merit preferences. Like, how do you explain, some communities, dominance of some communities? How do you explain, underrepresentation of other communities and all that? Yeah. Then underrepresentation of marginalized groups in governance and administrative reflects historical injustice that persists despite formal equality. Now, why subclassification matters? I'll just kind of conclude now in half a minute. Recognizing the systemic disadvantages, reservations serve as a mechanism of representation, ensuring Dalits and Adivasis have proportional access to education, employment, and political spaces. Subclassification within SC reservations simply extends this principle of representation, ensuring that the most disadvantaged within the Dalit category are not left behind by the dominant subcaste. Rather than fragmenting SCs, it corrects intra-group disparities and ensures the affirmative action reaches those who need most. Thank you so much. Thank you.
Thank you, Professor Sambaya, for that passionate argument about the larger conceptual questions, in locating Devinder Singh in that structural injustice question, and a series of points about representation as justice, but representation taken more seriously, and how therefore we perhaps should look at the subclassification question. Thank you indeed. May I invite, sir, Miru Uncham, ante ikkada టెలివైజ్ చేస్తున్నారు, అది రికార్డ్ చేస్తున్నారు, సో అందువల్ల ఇక్కడ నుంచి ఉంటే సరిపోతుంది. అందుకని ఓకే.
ప్రియమైన విద్యార్థులు, రీసెర్చ్ స్కాలర్స్, టీచర్స్, ఈ సమావేశానికి డిసైడ్ చేస్తున్న రామం సార్, సీతారామం సార్, అట్లాగే మిగిలిన మిత్రులు అందరికీ కూడా వందనాలు. కులము, సమానత్వము అనే దాని మీద మీ ముందు షేర్ చేసుకోవడానికి అవకాశం ఇచ్చినటువంటి మీ అందరికీ, యూనివర్సిటీ వారికి నేను ప్రత్యేకంగా కృతజ్ఞతలు చెప్తూ ఉన్నాను. కుల వ్యవస్థ గురించి, భారతదేశంలో వర్ణ వ్యవస్థ, కుల వ్యవస్థ గురించి మనకి కొత్తగా తెలియనిదేమీ లేదు. భారతదేశంలో వర్ణ, కుల, వృత్తి ఆధారిత భిన్నత్వాలు, అసమానతలు చాలా ఉన్నాయి. ఆ నేపథ్యంలోనే రాజ్యాంగ నిర్మాతలు వాళ్ళు అఫర్మేటివ్ యాక్షన్ కింద సమానత్వాన్ని తీసుకురావడానికి చాలా ప్రొవిజన్స్ మనకిచ్చారు. ఆ ఇచ్చినటువంటి వాటిని ఉపయోగపెట్టుకునేటువంటి క్రమంలో ఏం జరుగుతుంది అనేటువంటి విషయాన్ని నేను మీ ముందు చెప్పదలుచుకున్నాను. గత ఏడాది ఆగస్టు 1వ తేదీ నాడు 7 మంది కాన్స్టిట్యూషనల్ బెంచ్ జస్టిస్ చంద్రచూడ్ గారి ఆధ్వర్యంలో వచ్చినటువంటి జడ్జిమెంటు చాలా అద్భుతమైనటువంటి జడ్జిమెంటు. మన దేశంలో ఎగ్జిక్యూటివ్తో ప్రాబ్లం వచ్చినా కోర్టుకే రావాలి, అట్లాగే లెజిస్లేచర్తో ప్రాబ్లం వచ్చినా మళ్ళీ కోర్టుకే రావాలి. కోర్టు అట్లాంటి ముఖ్యమైనటువంటి పాత్ర భారతదేశ ప్రజాస్వామ్య వ్యవస్థలో ముఖ్యమైన 3 పిల్లర్స్ అని అనుకుంటే ఆ మూటిల్లో కూడా చాలా అద్భుతమైనటువంటి పాత్రని పోషిస్తూ ఉన్నది మన న్యాయ వ్యవస్థ. అట్లాంటి న్యాయ వ్యవస్థతో మేము న్యాయం చేయించుకోవడానికి ఒక 3 దశాబ్దాలు పట్టింది. 3 దశాబ్దాల తర్వాత మా ఆకాంక్షని, మా డిమాండ్లని సుప్రీంకోర్టు మీది న్యాయం అని చెప్పేలాగా చేసుకోగలిగాము. ఈ మొత్తం ప్రాసెస్లో ఈక్వాలిటీ, జస్టిస్, ఫ్రాటర్నిటీ అని ప్రియాంబుల్ చెప్తుంది. మేమేం కోరాము? డిస్ట్రిబ్యూటివ్ జస్టిస్ విత్ హ్యూమన్ డిగ్నిటీ ఫర్ ఎవ్రీ సోషల్ గ్రూప్ అని చెప్పి మేము కోరాము. ఆ కోరిన దానికి మేము ఒక సుదీర్ఘమైనటువంటి పోరాటం చేయాల్సి వచ్చింది. చివరికి సర్వోన్నత న్యాయ వ్యవస్థ దాన్ని గుర్తించి మా కోసము న్యాయాన్ని డెలివరీ చేసింది. చాలా హ్యాపీగా ఉంది. గత ఏడాది సుప్రీంకోర్టు ఇచ్చినటువంటి జడ్జిమెంట్ అని నేను చెప్పదలుచుకున్నాను. నిజానికి మన దేశంలో 1100 పైన షెడ్యూల్ కాస్ట్లు ఉన్నాయి. ఆల్ ఓవర్ ఇండియా 1100 షెడ్యూల్ కాస్ట్ ఉన్నాయి. అట్లాగే 630 షెడ్యూల్ ట్రైబ్స్ ఉన్నాయి మొత్తం దేశంలో సుమారు. అయితే ఇవి ఎలా ఉన్నాయి అని చెప్పినంటే నొమాడిక్, సెమీ నొమాడిక్ కండిషన్లో ఉన్నాయి, స్థిర జీవితం కలిగి ఉన్నాయి. కొన్ని కులాలు అయితే ఫ్యూ అంటే 10ల సంఖ్యలో కొన్ని కులాలు, 100ల సంఖ్యలో కొన్ని కులాలు, 1000ల సంఖ్యలో కొన్ని కులాలు, కొన్ని మాత్రమే లక్షల సంఖ్యలో ఉన్నాయి. మాదిగ, మాల, చమార్, పరయ లేకపోతే ఇలాంటి కులాలు కొన్ని మాత్రమే లక్షల సంఖ్యలో ఉన్నాయి. అంటే ఇన్ని వేరియేషన్స్ ఉన్నాయి. అమాంగ్ షెడ్యూల్ కాస్ట్ దేర్ ఈజ్ ఏ ఆక్యుపేషనల్ హైరార్కీ. ఏమిటి ఆక్యుపేషనల్ హైరార్కీ? బాటమ్ లేయర్లో పాకి వృత్తి కులాలు ఉన్నాయి, అంటే మాన్యువల్ స్కావెంజింగ్ కమ్యూనిటీస్ ఉన్నాయి బాటమ్ లేయర్లో. సెకండ్ లేయర్లో చర్మకార వృత్తి కులాలు ఉన్నాయి, లెదర్ వర్కింగ్ కమ్యూనిటీస్ ఉన్నాయి. అట్లాగే టాప్ లేయర్లో అగ్రికల్చరల్ లేబరర్ కమ్యూనిటీస్ ఉన్నాయి. అమాంగ్ షెడ్యూల్ కాస్ట్ ఇన్ని ఆక్యుపేషనల్ అంటే జనాభా రీత్యా కానీ ఆక్యుపేషన్ రీత్యా కానీ చాలా వేరియేషన్స్ ఉన్నాయనేటువంటిది మనం గుర్తుపెట్టుకోవాలి. షెడ్యూల్ కులాలన్నీ ఒకటే కాదు, వీటి మధ్య చాలా అసమానతలు ఉన్నాయి. సరిగ్గా మేము ఎప్పటి నుంచో చెప్తూ వచ్చాం. ఏమనంటే ఒకే ఒక డామినెంట్ కమ్యూనిటీ డిస్ప్రపోర్షనేట్గా ఎడ్యుకేషనల్, ఎంప్లాయ్మెంట్, పొలిటికల్, వెల్ఫేర్, రిజర్వేషన్స్ అన్నిటిని కూడా అవైల్ చేస్తూ ఉంది. అట్లాంటి పరిస్థితుల్లో వాళ్ళతో మేము స్ట్రగుల్ అవుతూ వచ్చాం. ఇది కాదు, ఎవరి ప్రపోర్షనల్ ఎడ్యుకేషనల్, ఎంప్లాయ్మెంట్ ఆపర్చునిటీస్ వాళ్ళకి ఇస్తూ ప్రిఫరెన్షియల్ ట్రీట్మెంట్ ఇవ్వాలి. అత్యంత వెనకబడ్డ కులాలు, జాతులు, తెగలు ఏవైతే ఉన్నాయో వాళ్ళకి ప్రిఫరెన్షియల్ ట్రీట్మెంట్ ఇవ్వాలి, వాళ్ళ ప్రపోర్షనల్ డ్యూ షేర్ వాళ్ళకి ఇవ్వాలని చెప్పి మేము చెప్తూ వచ్చాము. సరిగ్గా మమ్మల్ని అర్థం చేసుకుంది సుప్రీంకోర్టు. సుప్రీంకోర్టు మమ్మల్ని అర్థం చేసుకుంది. ఈ సందర్భంగా ఒకసారి చప్పట్లు కొట్టాలి మీ అందరికి నేను కోరుతూ ఉన్నా. సుప్రీంకోర్టు మేమేముంటూ వచ్చామంటే మాదిగల కంటే కూడా డక్కలి, చిందు, బైండ్ల, మాస్టి, పాకి, పంచమ, గొడగలి, గొడారి, తోటి లాంటి అనేక చిన్న చిన్న కులాలు ఉన్నాయి. వాళ్ళు మాకంటే, మాదిగల కంటే కూడా ఎడ్యుకేషనల్గా, ఎంప్లాయ్మెంట్లోనూ వెనకబడి ఉన్నారు. ఫస్ట్ వాళ్ళకి ఇవ్వండి, వాళ్ళ ప్రపోర్షనల్ అవకాశాలు వాళ్ళకి ఇచ్చి ఫస్ట్ ఇవ్వండి, ఫస్ట్ గ్రూప్లో పెట్టండి. ఆ తర్వాత మాకు ఇవ్వండి. రిలేటివ్లీ ఎవరైతే డామినెంట్ ఉన్నారో వాళ్ళకి లాస్ట్ గ్రూప్లో పెట్టి వాళ్ళ ప్రపోర్షనల్ అవకాశాలు వాళ్ళకి ఇవ్వండి అని చెప్పి మేము కోరాం. ఎప్పటి నుంచి? 50 ఏళ్ల ఆకాంక్ష ఇది. సదరన్ స్టేట్స్ ఆదిజాంబవ అరుంధతీయ ఫెడరేషన్ డిమాండ్ చేసింది 50 ఏళ్లుగా. ఆ తర్వాత మాదిగ రిజర్వేషన్ పోరాట సమితి గత 30 ఏళ్లుగా మేము డిమాండ్ చేస్తూ వచ్చాము. సరిగ్గా మేము ఏదైతే చెప్పామో దాన్ని సుప్రీం తన జడ్జిమెంట్ తన శంఖులో పోసి చెప్పింది. ఏమనంటే ఎస్, మాదిగ న్యాయమే సుప్రీం న్యాయం, మాదిగ న్యాయమే సుప్రీం న్యాయం, మీరు కోరింది సరైంది అని చెప్పాను అన్నది. 2000 సంవత్సరంలో కర్నూలు కేంద్రంగా మాదిగలు మాలా కాకుండా చిన్న చిన్న కులాల వాళ్ళు ఉన్నారు. వాళ్ళందరినీ కూడా కమిషనర్ ఆఫ్ సోషల్ వెల్ఫేర్ గవర్నమెంట్ వాళ్ళందరినీ ఆర్గనైజ్ చేసింది. ఈ సంఖ్యా బలం కలిగినటువంటి మాదిగలు మాలల్ని పక్కకు పెట్టేసి అసలు చిన్న చిన్న కులాలు ఉన్నాయి కదా షెడ్యూల్డ్ లిస్టులో, వీళ్ళు ఎవరు ఎంతమంది ఉన్నారని వాళ్ళందరినీ కాల్ఫర్ చేసింది ఒక కాన్ఫరెన్స్కి. 69 కమ్యూనిటీస్ ఉన్నాయి. 69 కమ్యూనిటీస్ ఉంటే కేవలం 30 కమ్యూనిటీస్ అక్కడికి వచ్చారు. అక్కడికి వచ్చిన వాళ్ళల్లో టక్కలి వాళ్ళు అని ఒక కులం ఉంది. వాళ్ళు ఏమని అడిగారంటే, యానిమల్ ప్రొటెక్షన్ యాక్ట్ ఉంది మనకి. యానిమల్ ప్రొటెక్షన్ యాక్ట్లో రేడియో ఐడెంటిఫికేషన్ ట్యాగ్ వేస్తారు జంతువులకి, వాటికి ప్రొటెక్షన్ ఉంది, బడ్జెట్ ఉంది, అవి సంతానం ఎన్ని కంటున్నాయి, వాటి ఆరోగ్య పరిస్థితి ఎక్కడుంది, ఎక్కడెక్కడ సంచారం చేస్తున్నాయి అని చెప్పి లెక్క తీస్తుంది అటవీ శాఖ. కానీ మనుషులం మేము, జస్ట్ మనుషులం మేము. కానీ మా గురించి ఇప్పటి వరకు ఎవరు వెతుక్కోలేదు. మా వెల్ఫేర్ ఏంటి, మా ఎడ్యుకేషన్ ఏంటి, మా ఎంప్లాయ్మెంట్ ఏంటి, మేము అసలు మనుషులమా కాదా, పొలాలలో అడవుల్లో ఊరి చివర బయట గుడిసెలు వేసుకొని క్యాంపులు వేసుకొని అడుక్కొని తింటూ ఉన్నాం మేము. అసలు మాకు గవర్నమెంట్ అనేటువంటిది ఏమిటి, గవర్నమెంట్ ఏమిటి, మాకు అవకాశం ఉందా లేదా ప్రభుత్వంలో అని చెప్పి వాళ్ళు అడిగారు. యానిమల్ ప్రొటెక్షన్ యాక్ట్ కింద వాటిని ప్రొటెక్ట్ చేస్తున్నారు, కానీ మాకేంటి, మమ్మల్ని ఎవరు వెతుక్కోలేదు, మీరు వెతుక్కున్నారు ఫస్ట్ టైం అని చెప్పి కమిషనర్నే వాళ్ళు ఈ మీటింగ్ మేము రావచ్చా అని చెప్పి అడిగారు వాళ్ళు. అట్లాంటి పరిస్థితులు ప్రివైల్ ఉన్నాయి గ్రౌండ్లో, సొసైటీలో. దాన్ని అర్థం చేసుకోవాలని మిమ్మల్ని ఈ సందర్భంగా నేను కోరుతూ ఉన్నాను. సమాజంలో వర్ణ వివక్ష ఉంది, కుల వివక్ష ఉంది, వృత్తిపరమైన, అంటే ఇది కేవలం నాట్ జస్ట్ సోషల్ వివక్ష, ఇది ఎకనామిక్ ఇన్ఈక్వాలిటీస్ ఉన్నాయి, పొలిటికల్ ఇన్ఈక్వాలిటీస్ ఉన్నాయి, కల్చరల్ ఇన్ఈక్వాలిటీస్ ఉన్నాయి, జెండర్ ఇన్ఈక్వాలిటీస్ ఉన్నాయి, ఎథనిక్ ఇన్ఈక్వాలిటీస్ ఉన్నాయి, లింగ్విస్టికల్ ఇన్ఈక్వాలిటీస్ ఉన్నాయి, మైనారిటీ ఇన్ఈక్వాలిటీస్ ఉన్నాయి. ఇన్ని రకాల ఇన్ఈక్వాలిటీస్తో, భిన్నత్వాలతో భారతీయ సామాజిక వ్యవస్థ ఉన్నది. ఇది గ్రౌండ్ రియాలిటీ. దీన్ని సరిచేయడానికి రాజ్యాంగ నిర్మాతలు మనకు రిజర్వేషన్స్ ప్రొవైడ్ చేశారు. ఆర్టికల్ 15(4), 16(4), 14, అట్లాగే ఆర్టికల్ 46. ఆర్టికల్ 46 ఏం చెప్పింది, ఆల్ ఫార్మ్స్ ఆఫ్ ఎక్స్‌ప్లాయిటేషన్స్ నుంచి ఎస్సీ ఎస్టీని ప్రొటెక్ట్ చేసి వాళ్ళ ఎడ్యుకేషనల్, వాళ్ళ ఎకనామిక్ వాటిని వృద్ధి చేయాలని చెప్పి గవర్నమెంట్ రాజ్యానికి డైరెక్ట్ చేసింది ఆర్టికల్ 46. అట్లాగే ఆర్టికల్ 38, 39. ఆర్టికల్ 38, 39 చాలా అద్భుతంగా చెప్పినాయి. నేషనల్ వెల్త్ ఎక్కడా కూడా అన్నేచురల్గా కాన్సన్ట్రేట్ అవ్వద్దు, డిస్ట్రిబ్యూటివ్ జస్టిస్ మేనర్లో, కామన్ గుడ్ మేనర్లో అందరికీ పంచబడాలా. ఈవెన్ జీతభత్యాలలో, హోదాలలో కూడా వ్యత్యాసాలు ఉండటానికి వీల్లేదు అని చెప్పి ఆర్టికల్ 38, 39 చెప్పినాయి. మేము కోరింది ఏంటి, అదే కోరాం. మార్జినలైజ్డ్ అన్టచబిలిటీ మీకు తెలుసు. ఈరోజు ప్రివెన్షన్ ఆఫ్ ఎస్సీ ఎస్టీ అట్రాసిటీస్ యాక్ట్ ఉంది, అట్లాగే 1955 సివిల్ రైట్స్ యాక్ట్ ఉంది, అట్లాగే ఆర్టికల్ 17 ఎరాడికేషన్ ఆఫ్ అన్టచబిలిటీ అనేటువంటిది ఉంది, అట్లాగే డ్రై లెట్రిన్స్ అబాలిషన్ యాక్ట్ ఉంది, అట్లాగే మనకు ఇంకా ఏముంది, ఒక పక్క నేషనల్ సఫాయి కర్మచారి కమిషన్ ఉంది, అట్లాగే అబాలిషన్ ఆఫ్ దేవదాసి యాక్ట్ ఉంది, అట్లాగే వెట్టి చాకరీ నిర్మూలన చట్టం, అంటే వెట్టి చాకరీ ఏమంటారు, బాండెడ్ లేబర్ అబాలిషన్ యాక్ట్ ఉంది, అట్లాగే చైల్డ్ లేబర్ అబాలిషన్ యాక్ట్స్ ఉన్నాయి. ఇవన్నీ లైవ్గా ఉన్నాయంటేనే ఆ సమస్యలు సొసైటీలో ఇంకా ఉన్నాయి, వాటికి గురవుతున్నటువంటి మార్జినలైజ్డ్ సెక్షన్స్ ఇంకా ఉన్నాయి. వాటిని సమర్థవంతంగా అమలు జరిపి ఈక్వాలిటీ, జస్టిస్, ఫ్రాటర్నిటీ అనేటువంటిది ప్రతి ఒక్కరికి అందుబాటులోకి తేవాలనేటువంటి మహా సంకల్పంతో రాజ్యాంగ నిర్మాతలు చాలా గొప్ప రాజ్యాంగాన్ని మన కోసం, మా కోసం, మార్జినలైజ్డ్ సెక్షన్స్ కోసం నిర్మించారు. కానీ నేనేమంటానంటే, నిజానికి ఇప్పుడు మాకు పొలిటికల్ సైన్స్ ఒక మాట చెప్పుద్ది, ప్రాబల్య వర్గాలు ఎవరైతే ఉన్నారో సమాజంలో వాళ్ళ ఆకాంక్షలు, వాళ్ళ డిమాండ్ల మేరకే పాలసీస్ గవర్నమెంట్లో రూపొందించబడతా ఉంటాయి, చట్టాలు రూపొందించబడతా ఉంటాయి, బడ్జెట్ కేటాయింపులు జరుగుతూ ఉంటాయి అని చెప్తూ ఉంటుంది పొలిటికల్ సైన్స్. కానీ ఎవరైతే రిలేటివ్లీ మార్జినలైజ్డ్ ఇంపవరిష్డ్ కమ్యూనిటీస్ ఉన్నాయో, క్లాసెస్ ఉన్నాయో, వాళ్ళ ఆకాంక్షల గురించి ఏంటి, వాళ్ళ డిమాండ్ల గురించి ఏంటి, అవి కావడం లేదు. ఇలాంటి పరిస్థితులు ఉన్నాయి. అట్లాగే మీకు ఒక విజ్ఞప్న, కరియా ముండా జ్యుడిషియల్ సిస్టంలో ఎస్సీ ఎస్టీలకి రిజర్వేషన్స్ ఇవ్వాలని చెప్పి కరియా ముండా రిపోర్టు 1980 ఒకసారి చదవమని చెప్పి మీ అందరినీ నేను రిక్వెస్ట్ చేస్తూ ఉన్నాను. అందులో ఆయన ఒక మాట అంటాడు కరియా ముండా రిపోర్ట్లో. ఆయన ఏమన్నాడంటే, చాలా అద్భుతమైనటువంటి వ్యవస్థ మంది న్యాయ వ్యవస్థ. అయితే ఆ న్యాయ వ్యవస్థలోకి వచ్చేటువంటి హ్యూమన్స్ ఎవరైతే ఉన్నారో జడ్జెస్, వాళ్ళేమి సూపర్ హ్యూమన్స్ కాదు. వాళ్ళు సూపర్ హ్యూమన్స్ కాదు. వాళ్ళ వెంట వాళ్ళ ఇష్టాలు వస్తాయి, వాళ్ళ అయిష్టాలు వస్తాయి, వాళ్ళ స్పిరిచువాలిటీస్ వస్తాయి, వాళ్ళ ప్రిజుడీస్ వస్తాయి. ఇవన్నీ కూడా క్యారీ చేసుకొని వస్తారు. కానీ జస్టిస్ అనేది ఇండివిజువల్గా మనం చూడొద్దు. అది కాన్స్టిట్యూషన్ పరంగా ఏముందో దాని స్ఫూర్తిని, దాని స్పిరిట్ని క్యారీ చేయాల్సినటువంటి అవసరం ఉందని చెప్పి ఆయన చెప్పాడు కరియాముండా. సో అందుకని మేము చేసినటువంటి ఈ పోరాటం ఏదైతుందో, ఈ పోరాటంలో జస్టిస్ చంద్రచూడ్ గారు రిటైర్మెంట్ అయినప్పుడు టైమ్స్ ఆఫ్ ఇండియాలో ఒక ఫుల్ పేజీ ఇంటర్వ్యూ వచ్చింది. అందులో ఒక క్వశ్చన్ వేశారు. ఏమని క్వశ్చన్ వేశారంటే, 10 ఏళ్లకే కదా రిజర్వేషన్స్, ఎవ్రీ 10 yearsకి ఎక్స్టెండ్ చేసుకుంటూ పోతున్నారేంటి, ఇంకెంతకాలం ఇది, రిజర్వేషన్స్ ఏమన్నా ఎటర్నలా అని క్వశ్చన్ వేశాడు ఒక ఆయన. అప్పుడు జస్టిస్ చంద్రచూడ్ ఏమన్నాడు తెలుసా? ఈక్వాలిటీ, జస్టిస్, ఫ్రాటర్నిటీ అనేది మన రాజ్యాంగ లక్ష్యం. ఈ రాజ్యాంగ లక్ష్యము సాధించబడేదాకా సమాజంలో వివక్షలు తొలగిపోయేదాకా, సమాజంలో సమానత్వం సాధించబడేదాకా రిజర్వేషన్స్ కూడా ఎటర్నలే అని చెప్పన్నాడు ఆయన. జస్టిస్ చంద్రచూడ్ ఇంటర్వ్యూ చూడండి దయచేసి టైమ్స్ ఆఫ్ ఇండియాలో. అందుకని మాకు పర్మనెంట్గా రిజర్వేషన్ మాకు అక్కర్లేదు. ఎస్సీలకి, ఎస్టీలకి, ఓబీసీస్కి, మహిళలకి మాకేమీ పర్మనెంట్ రిజర్వేషన్స్ మాకు అక్కర్లేదు. మేము ఎంపవర్ కావాలి. మేము ఎంపవర్ అయినప్పుడు మాకు అక్కర్లేదు. అట్లాంటి రోజు రావాలని చెప్పి మేము కోరుకుంటూ ఉన్నాము. డిస్ట్రిబ్యూటివ్ జస్టిస్ విత్ హ్యూమన్ డిగ్నిటీ మేము కోరుకుంటున్నాం. ఈ దేశంలో అత్యంత అణగారిన సమూహాలు సంబంధించినటువంటి వాళ్ళంగా డిస్ట్రిబ్యూటివ్ జస్టిస్ విత్ హ్యూమన్ డిగ్నిటీ మేము కోరుకుంటున్నాము. అది మాకు ఈరోజు సుప్రీంకోర్టు ప్రసాదించింది. చాలా సంతోషకరమైనటువంటి విషయం. దానికోసం ఎన్నో స్ట్రగుల్స్ చేశాం. ముందు హైకోర్టులో ఆర్టికల్ 338 ఒక పాలసీ డెసిషన్ తీసుకోవాలంటే ఎస్సీ ఎస్టీలకు సంబంధించి మేజర్ డెసిషన్, పాలసీ డెసిషన్, ప్రిన్సిపల్ డెసిషన్ తీసుకోవాలంటే ఆర్టికల్ 338 ప్రకారం నేషనల్ ఎస్సీ కమిషన్ని కన్సల్ట్ చేయాలి, మస్ట్ అని చెప్తా ఉంది. ఫస్ట్ 1997లో జియోస్ ఇష్యూ చేసింది ఆంధ్రప్రదేశ్ గవర్నమెంట్ ఫర్ రేషనలైజేషన్ ఆఫ్ ఎస్సీ రిజర్వేషన్స్. కానీ వైలేషన్ ఆఫ్ ఆర్టికల్ 338 అని చెప్పి అప్పుడు కొట్టేసింది హైకోర్టు. మళ్ళీ అప్పుడు ఎనాక్ట్మెంట్, యునానిమస్గా ఎనాక్ట్మెంట్ జరిగింది 2000 ఏప్రిల్ 1 నాడు. అప్పుడేం చేశారంటే, ఇదిగో వైలేషన్ ఆఫ్ ఆర్టికల్ 14, వైలేషన్ ఆఫ్ ఆర్టికల్ 341 అని చెప్పి మళ్ళీ సుప్రీంకోర్టుకి వెళ్ళారు. కానీ పంజాబ్, హర్యానా కేసులో జస్టిస్ అరుణ్ మిశ్రా 5 జడ్జెస్ ఏదైతే ఉందో అది మళ్ళీ దానికి ప్రాణ ప్రతిష్ఠ చేసింది. ఏమనంటే, దేశవ్యాప్తంగా ఎస్సీ ఎస్టీల మధ్య అంతర్గత అసమానతలు ప్రివైల్ అయి ఉన్నాయి, వాళ్ళకి రిజర్వేషన్స్ అందాల్సినటువంటి అవసరం ఉంది. అవసరమైతే ఈవి చిన్నయ్య జడ్జిమెంట్ని కూడా రివ్యూ చేయాలి. అందుకోసం విస్తృత రాజ్యాంగ ధర్మాసనాన్ని ఏర్పరిచి చేయాలని చెప్పి జస్టిస్ అరుణ్ మిశ్రా జడ్జిమెంటు పేర్కొన్నది పంజాబ్ కేసులో. అప్పుడు 7 మంది జడ్జీలతో జస్టిస్ చంద్రచూడ్ బెంచ్లో మాకు గత ఏడాది ఆగస్టు 1 నాడు వచ్చినటువంటి జడ్జిమెంట్ ఏదైతుందో, అన్ని హోమోజీనియస్ కమ్యూనిటీస్ కాదు, షెడ్యూల్ కాస్ట్, షెడ్యూల్ ట్రైబ్స్ అన్నీ కూడా హెటరోజీనియస్ కమ్యూనిటీసే, వేరు వేరు నేపథ్యాల నుంచి వేరు వేరు సమస్యల నుంచి భౌగోళిక, సామాజిక, భాష, సాంస్కృతిక, ఆర్థిక నేపథ్యాల నుంచి వచ్చినటువంటి హెటరోజీనియస్ కమ్యూనిటీసే తప్ప వేరే కాదు. వాళ్ళందరికీ న్యాయం జరగాల్సిందని చెప్పి ఒక అద్భుతమైనటువంటి జడ్జిమెంట్ని జస్టిస్ చంద్రచూడ్ బెంచి విస్తృత ధర్మాసనం ఏర్పరిచింది. మాకు చాలా నమ్మకం ఉంది. భారతీయ న్యాయ వ్యవస్థ మీద చాలా నమ్మకం ఉంది. భవిష్యత్తులో మీరంతా కూడా రాజ్యాంగాన్ని చేతబట్టుకొని దాన్ని పరిరక్షించేటువంటి ఎక్కడెక్కడో అడ్వకేట్స్గా, జడ్జెస్గా, ఇంకా అనేక ఫ్యాకల్టీస్గా రకరకాలుగా మీరు ముందుకెళ్తున్నటువంటి ప్రాసెస్లో భారతీయ సామాజిక వ్యవస్థలో ఉన్నటువంటి అసమానతలు ఏవైతున్నాయో, వర్ణ కుల అసమానతలు, వాటికి వ్యతిరేకంగా విద్యా సమానత్వం రావాలి, ఉద్యోగ సమానత్వం రావాలి, ఆర్థిక సమానత్వం రావాలి, రాజకీయ సమానత్వం రావాలి, జెండర్ సమానత్వం రావాలి. అన్ని రకాల సమానత్వాలు వచ్చేటువంటి దిశగా మనము మీరు అందరూ కృషి చేయాలని చెప్పి నేను కోరుకుంటూ, ఈ అవకాశం నాకు ఇచ్చినటువంటి సీతారామం సార్, అట్లాగే మీకు మీ అందరికీ కూడా నేను మరొకసారి వందనాలు చెప్తూ ముగిస్తున్నాను. థ్యాంక్ యూ.
Can you brief? Yeah, go ahead. Yeah, better. So we'll have a quick translation of the same for non-Telugu audience.
Krupakar Madhika is a founder member of Madhika Reservation Porat Samiti. I'll try to briefly summarize what he has said. Caste based on occupational differences and hierarchies and inequalities are well known to each one of us. But constitutional framers prescribed justice, social and political and economic, and that has to be realized in practice. It took 3 decades for MRPS to fight with the judiciary to achieve what is legitimately our right. He was talking about, there are 1100 castes among the scheduled castes, and there are 630 castes, 630 scheduled tribes among the tribals. And among the scheduled tribes, there are nomadic, semi-nomadic communities. And out of these 1700 scheduled castes and scheduled tribes, some of the communities are in single digit, few hundred people. Some of them are just not even 20 or 30 people. And there are only few castes among the scheduled tribes and scheduled castes which can be counted in lakhs. And there is a occupational based hierarchy within the scheduled caste and scheduled tribe communities. You have to understand. At the lowest level, there is the scavenging communities, and above them, there is a community based on the leather workers, and the third communities, third category of community is agriculture based laborers, which constitutes in lakhs. And but of these 3 hierarchical communities, only some communities are overwhelmingly represented in government jobs and in public life, but there are other communities who are never represented. All that we began to ask some 30 years back, even 50 years back, there was a community called Jambo community who demanded that the people who are at the bottom of these scheduled castes and scheduled tribes should be given preferential treatment. We have not, even though MRPS started agitation for a subclassification, we never asked who should be given preferential treatment. Below Chamar community, there are so many communities which are nowhere in the public life, and they should be given preference. That is what our argument has always been. And he was saying that in 2000, the Andhra Pradesh government tried to organize the communities other than who represent in lakhs. I mean, Madiga and Mala communities are in lakhs, but there are some communities who are no, not more than single or double digit. When 69 communities were invited to organize something, only 30 communities have attended that meeting. Some communities said there is Animal Protection Act, which actually recognizes the animals and they trace how they are protected, how they live, but we are the human beings. Nobody cares about us. There is no scheme for us. So are we below the animals? This is a important question. But to overcome this kind of differences, the constitutional framers have created a lot of things like equality. So we are saying that unequals cannot be treated as equals. Therefore, unequals must be treated, recognized as unequals, and that should be, addressed. And he was talking about, Article 46, Article 39, and also Article 38, which says there is a need to prevent concentration of wealth, differences in the social status. And he was parading how many laws are there. For instance, Untouchability Eradication Act, Civil Rights Act, and Prevention of Atrocities Act, and Dry Latrine Abolition Act, and Bonded Labor Abolition Act. Why do they exist? The existence of these many laws are an indication of existence of so many communities at the bottom of social life. And ignoring this diversity, this hierarchy is completely doing injustice to us. And it took 30 years for Supreme Court to recognize this reality. And it is our relentless fight with the society, with media and judiciary that finally we could achieve this. And he was talking about Karya Munda report of 1980, which talks about representation in the judiciary for the SC/ST, where Karya Munda report speaks that the judges are not superhuman beings who would overcome their biases, their prejudice, their caste opinions. Therefore, there is a need to include people from marginalized communities. Otherwise, access to justice as envisioned by the constitutional framers will not be realized. And finally, he was mentioning about Justice Chandrachud interview in the Times of India, where somebody asked how long we are going to continue the reservation. This is the question he was asked, but it seems Justice Chandrachud said, as long as the equality, liberty, and dignity and fraternity are constitutional visions, unless we achieve them, reservation must remain eternal. And finally, he concluded saying that we don't want reservations forever. What we want is distributive justice, which is there in the Constitution, and distributive justice with dignity. Unless we are empowered, we are able to access all these values of justice and distributive justice especially, then reservation is the means to achieve that. That is what we are asking. We don't want reservations, but we want justice, that too, distributive justice. Thank you.
Thank you, Krupakar sir, for giving us the background, the social action background of the social justice litigation. I think the summary you already heard, there are many points of empirical facts and the way they interact with the constitutional norms as well as legal constructions. So we'll hopefully get a better idea of how constitutional law could be perhaps seen. May I request Professor Nandini Sundar to.
Jai Bhim, Jai Johar. Good afternoon. I'm very grateful to NALSAR, especially the student volunteers for organizing this and for inviting me and for staying up so late to make sure that we were all in and well taken care of. It's always a pleasure to come back to NALSAR, and I've enjoyed listening to the other panelists and learned a lot. So I want to just start with saying that my ideal bundle of judgments would be to have subclassification, no creamy layer exclusion, reservation for Christian and Muslim SCs and STs. STs are already Christian, Muslims, STs already have reservation. So reservation for Christian and Muslim SCs, abolition of EWS reservation, a census, which nobody seems to have gone to court on, but you can't have any subclassification or anything until you have a census, and justiciable funds specifically targeted funds for health and education, which are justiciable and can be gone to court on. Because right now, anything that is targeted to SCs, STs are only schemes, and they're constantly being diverted. So in order to achieve some of the rights that are there on paper, it would be meaningless unless you also had these other rights. So let me just go into some of these issues. Now, as far as this judgment goes, the rationale for subclassification was that there should be an intelligible classification and rational nexus. But I fear that the judgment is actually making that nexus only with one aspect of the classification, which is the economic backwardness and social discrimination within the subcaste, but not of the social discrimination between SC communities and the rest of society, and between the kind of exploitation that ST communities face and the rest of India. So although ST's subclassification is not at issue here, but obviously it is being extended, and given the way that the judgment was framed, calling for a policy, it will be most likely extended. Now, it's very important to remember that SC/ST classification was not on the basis of economic backwardness alone. And I think the EWS judgment does a huge disservice to the whole country by making economic backwardness an acceptable criteria for reservation. Because SC reservation was clearly on the basis of untouchability, social discrimination, which is why in the original reservation, Hindu SCs were given reservation and Muslim and Christian STs were not given reservation. So on the one hand, you cannot argue that you have economic backwardness as a criteria or subclassification as a criteria and keep Christian and Muslim SCs out of reservation. And people's lives, whatever the Supreme Court may do, however many benches the Supreme Court may be subdivided into, or however many subcategories it may come up with, people's lives are not subcategorized according to the judgments of the Supreme Court. They are not subcategorized into whoever is able to bring a case to court. The fact is that it is actually currently completely immorally permissible not to extend reservation to Muslim and Christian Dalits if you are going to accept the EWS judgment and accept the subclassification judgment. As far as STs go, the rationale for having reservation and PESA, fifth schedule, etc. for STs is completely different from SCs. And it's important to keep them apart because the criteria there is not social discrimination because Muslim and Christian STs are also counted as STs. Tribals are default not Hindus. There may be Hindu tribals, there may be Christian tribals, there may be Muslim tribals. But as much as the government is trying to make all tribals into Hindus, refusing to accept that they are not Hindus by default position, not accept, again, having only economic backwardness will take away from the very rationale of why Adivasis have been given reservation. And it's not even reservation alone, it is a recognition of a need for a certain kind of political autonomy, a recognition and inchoate federalism in the system that applied not just to states, but also to different types of populations with different types of governance structures. So we need to think of the fifth schedule, the sixth schedule as a form of federalism which acknowledges political autonomy, although the language of the local committee of 56, or wherever, sorry, I'm forgetting the date, was isolation, shyness of contact, backwardness, etc., right? But at heart, unless you recognize the different rationales for SC/ST reservation, the rationale for reservation in the first place, it's going to be far too easy to take it away under the new EWS categorization that we're heading towards. It's true that there are differences within the SC/ST community. There can be, as the previous speaker said, there is no denying that. There is no homogeneity in either economic conditions, representation in the government, occupations. But again, lack of homogeneity is an issue in other forms of reservation as well. So you have women not being a monolithic category. And unfortunately, the same kinds of forces which are going to deny the lack of homogeneity in SC/STs will say that women as a category should not have SC/ST OBC reservations within them. So if we are to actually think about subclassification, categorization, we actually need to think about the different principles under which reservation is given or different forms of autonomy are given, what should be applied as a subcategory to all of them or not necessarily to all of them. I think these are sort of more general first principles that we also need to debate, right? And this problem of having the courts give judgment in one case, not give judgment in the other case, actually takes away from the first principle kind of argument that we need to have. The other problem is that the EWS categorization and the introduction of the creamy layer principle in this judgment actually is a very narrow perspective on what reservations has meant for the SC/ST community and historically affirmative action has meant for Blacks in the US or elsewhere that it's been. One needs, as Shadan said, the creamy layer is not really creamy, it's really part of the milk, but you need a creamy layer. You need somebody who will argue for your community. Ambedkar could have been part of the creamy layer. His father was in the government. He would have been, if by any these kinds of principles, excluded. But without an Ambedkar to argue for his community, where would we have been, right? The creamy layer is the layer or the educate. I mean, this is quite apart from the subclassification thing, which I'm not disagreeing with, but you need somebody to be vocal in defense of rights. There is evidence, there is research among Blacks who have benefited from affirmative action that they spend a lot more effort, time, money of their own in community work among other Blacks than whites do among their own communities, right? So a Black who went to Yale will spend more of his time working for his community than a white who went to Yale, right? So there are other reasons apart from just individual economic advancement or not, whether you need a creamy layer. The third is that even if you apply categories like previous employment in government service, we know from representations by SC/ST unions that there is a greater mortality rate among SC/ST employees, even in government, because of generational inequality in health and nutrition. So there are all sorts of reasons why, apart from just the economic logic, there is a reason why you need vocal advanced members of a community, whether that community is homogeneous or not. Finally, you also have a great deal of discrimination existing, even as was pointed out, the marriage issue. Go to any newspaper, caste advertisements, marriage is entirely on the basis of caste. Even though they say caste no bar, when you actually turn up with your caste identity, you're not going to be entertained. There was this judge in Allahabad High Court, SC judge, who had his, the succeeding judge washed his chamber out with Ganga Jal because it had been used by an SC judge. If you look at the 2006 volume by Ghanshyam Shah, Thorat and others on untouchability in rural India, it's, 70% of village Dalits are denied entry to the homes of upper caste, et cetera, et cetera. So there's huge evidence for the continuation of untouchability across the category. Secondly, if you look at untouchability in urban India, there's a study by Sari 2016, which was published in EPW, which says that in Delhi, where you would think that caste differences would be least likely to apply in an urban context because many of them are migrants, 39% of non-Dalit Hindu women admitted that someone in their household practices untouchability. 21% of non-Dalit Hindu women admitted to practicing untouchability themselves. In urban Uttar Pradesh, 42% of non-Dalit Hindu men reported that someone in their family practiced untouchability, and 35% of non-Dalit Hindu women said that they practice untouchability. So poverty is not the biggest problem facing this country. It is intersectional with other kinds of discrimination, and to forget that reservations were explicitly codified, institutionalized on the basis not just of economic backwardness, but on the basis of these other forms of discrimination is extremely important. I also want to add that, as the previous speaker said, you have all of these laws to do with Prevention of SC/ST Atrocity Act, etc. But what we don't have is a way of looking at, in a way, having this whole debate on reservations takes away from the fact that people's resources are being taken away from them. You cannot have, the kind of deaths that we're seeing in Chhattisgarh in the last 1.5 years, about 400 now, and the kinds of mining that is coming into all the Adivasi areas, and people's resources are being destroyed. You're making people poorer, and then saying, oh, they should be given reservation, and for what? You're taking away all their resources and making them further impoverished and destroying their various occupations, and then saying that, we should have these issues. If we, as teachers, as somebody who's been teaching in Delhi University for the last 20 years, you don't need to know about the actual basis of subclassification because we see it all the time. I know that all the SC/ST seats in the university are occupied by people from the Northeast because, and there is hardly any, if you have anybody, there are Oraons from Jharkhand and Meenas from Rajasthan. That is it. Nobody else is really included. And we know that because these areas have historically had education, the Northeast is recognized as peoples, as nations, even if they are not, if they are suffering from other forms of attack like AFSPA, etc., and militarization. But it's not, the ability to access reservation is not only about education and income. It's about the history of the region where you came from, what else was going on in the region at that time, and the same with SCs, right? Why is it that Mahars in Maharashtra are able to take advantage of the SC seats and a Musahar from Bihar is not? Because of the history of Maharashtra and the history of Bihar. It's not just about the history of the discrimination within these subcastes. It's not just about, it's about many things. And it's, unless we get away from this reservation just a narrow reservation angle and look at actually questions of distributive justice, questions of just justice, questions of why people are suffering from SC/ST atrocities, and the Supreme Court is sitting on it for years. Our case in the Supreme Court has been sitting there for 20 years on fundamental rights, and yet we're talking about, distributive justice without even fundamental justice. So just to sum up, I think that the subclassification judgment is necessary, but but the reasoning on which that judgment was given is quite faulty. And the creamy layer argument and the EWS judgment really need to be, the EWS judgment needs to be reviewed, struck off the rolls, and the creamy layer argument needs to be put to rest. And we need a census, and we need funds as a matter of right, not as a government handout or scheme. Thank you.
Thank you, Professor Sundar, for that larger picture and also the complexity of the classification and the creamy layer point that you emphasized, and also the need for relooking at economic basis for reservation as a question under the Constitution. I'm not venturing to do anything, but I'm going to ask the organizers, can we extend the session by about 15-20 minutes? Is that okay? Is there anyone? Yeah, okay, right, thank you. So what I could see is actually one quick point from my side. As you can see that, the preamble, if you begin with the equality question, then this 14 to 18, the technical part of it, if you want to see, and maybe other intertextual readings of portions of Constitution or statutes you can bring. But the story that has unfolded in the last 1 hour plus is this very complex, and just complex is a very understatement, the mind-boggling condition of the social fact and the struggles of the doctrine even to be relevant to the context in whatever way. I suppose that's something that we will see. So if one were to teach equality in a constitutional law class, what are all things that obviously need to be brought to bear upon in addition to the doctrinal part? I think that becomes even more clear in this 1 hour conversation as some kind of an appetizer, as something that is flagging something that we need to take note of in the context of a law school. I won't say anything more than that. We will take one round of questions and then all the panelists would give their response and see. I think that is all perhaps we will be able to achieve in this remaining 15 odd minutes that are available to us. But once again, thanks to the panel, but the floor is open. Here.
Am I audible?
Yeah.
Thank you all the panelists for giving their opinions on this issue. I think this is really significant and it is really enlightening to hear all of you. My question is, given the socioeconomic diversity, as all the panelists have talked about, of the SC/ST categories across different states and regions, how should we determine the basis of the subclassification? And should it be implemented uniformly at the national level, or should it be implemented at this at state or even more localized level? And additionally, should the reservations be structured differently for education, employment, and political representation, as some caste groups might have more access to one particular sector rather than the other? So how should we determine that is my question.
Do we have any other question? This looks like a cluster of questions. She just bombarded some 3 or 4 together. So yeah, can we have one more question? Then we'll probably, that's good enough for response. Anyone else is interested? Yes. It's on. So let's
My question is to Shadan sir and Nandini ma'am. So with regards to the exclusion of the creamy layers from the ambit of reservation, would it be possible to make it a preferential model, let us say, wherein we do not exclude the creamy layer, but we give preference to those who are coming from non-creamy layer, and in case there are not sufficient number from those categories, to then go to the creamy layer and give them as well, to ensure that representation is maintained, but among that class, individuals who are more disadvantaged get more preference in these terms.
Okay, so I think there are two big questions. So then I request in the same order, let us the responses. So Shadan, you can begin.
Yeah, I think there were, by the first person who question, I think there are two questions which I noted. One is, what is the criteria? So the criteria, I mean, textually from the Supreme Court judgment is, you have to determine if the person is socio-economic, if the group is socio-economically more backward, that's one. And second, if the group is, there is a difference in the inadequacy of representation between the group which you are seeking to subcategorize. So those are the two broad criteria. The second question you asked there was, how should it be determined nationally or state-wise? So my sense is a state-wise assessment is what is going to be done primarily in this. It also makes more sense to do it state-wise because I think state governments are more alive to situation of smaller groups. Yes. So I think the state governments are more alive to the situation of smaller groups within their states. One thing I want to just bring it to everybody's notice was, in fact, the union government was in a quandary as to what position to take. Right till the arguments began, nobody knew what position, because normally you have an affidavit in court, you know what position the government has taken. Union's position was not known in this matter until the government actually argued the matter. And I'm told the instructions came very late that they have to support subcategorization. The reason for that was, of course, I'm now entering into the realm of politics, is that then you allow state governments to do categorization, right? If you allow subcategorization, you're allowing state governments to do categorization, which could obviously be of a different political government color than the union government is, correct? And therefore, you permit whatever impact it has on electoral politics, this kind of subcategorization for a state government of another ruling party to do. So I think there was a quandary there, but I think eventually the union government rightly supported subcategorization in this matter. And to your question on, can you do a preferential treatment on creamy layer? I think the occasion for even that has not really come because like Nandini so beautifully said, Ambedkar would also have been possibly creamy layer, and we are not really at that stage. I mean, just look around, even in your colleges, in your spaces. I mean, despite reservation, the numbers are very, very, very small. So I think there is no need at all for a creamy layer. In fact, what happens very often is that irrespective of reservation, you will have a qualifying criteria, correct? Whatever it may be, with the number of students and the marks. Very often you do struggle to get those numbers as well. So, you know, there is no question of excluding creamy layer. I think they're essential. The cream is the community and they play a very important representation role, like Nandini said. They have a very, very important, it's not just for their personal benefit. Like the Supreme Court judgment is talking about IAS, IPS, and the IAS, IPS is not just there for himself and his children. He's playing a very important representational role for the community there, right? That the Supreme Court completely misses out. So I think let's keep it, and the important thing is politically no state or central government has even sought to implement creamy layer. That's the correct thing to do. Supreme Court has said constitutionally is permitted, but nobody on the ground is doing it, right? Why? Because they know the social reality better than the Supreme Court, in this case at least.
Thank you. Yeah, similar positions actually. With the subclassification, I don't think, national criteria would be a better idea. The state has to be kind of, proper unit. Recently, previous frontline, previous month actually, I wrote an article on the Telangana subclassification where I sort of agreed with this, Telangana, categorization. But I also said, you need to come up with, some better criteria than what they have kind of categorized A, B, C. What I said, actually, you should have, preferences in order to kind of, justice, to do justice to the most marginalized. What I said, take the government education as a criteria. Someone kind of a student who studied government school vis-a-vis kind of someone who kind of studied in a private school. Okay, first preference should be kind of given to this student who has gone to government school. Then the parents, if they are not kind of had a not education, but at least not kind of have any government job, then that candidate should be kind of given another preference and all that. Weightage should be. Then I also said, each category has kind of given certain percentage of the quota. For instance, like group A here they're given 1, and then group B kind of 6, and then group B, I think 6 or 7, something like that. But what I said, within that also, you need to kind of give reservation for the women as well. For instance, like group B has 7% quota, then 3.5 should be kind of go to this women gender. That has to be kind of taken into consideration. So, I think there are kind of various ways one need to kind of work out, which justice to the most marginalized has to be done and all that. Yeah, on this on the creamy layer aspect also, like my position is kind of similar, Professor Sundar and then Sadan, that I don't think that this is should be kind of topic of discussion at all. Obviously, because I mean, if there are Dalits, better off Dalits, like who maybe kind of if they want to kind of voluntarily give up their reservation, that's absolutely fine. But as Sadan pointed out, it's kind of it's doing a representational work, and I think we should kind of agree on that point. Thank you.
మా చాలా మంచి ప్రశ్న వేశారు. ఇదేంటంటే యూనియన్ గవర్నమెంట్ షెడ్యూల్ కాస్ట్కి, షెడ్యూల్ ట్రైబ్స్కి ఎడ్యుకేషనల్ రిజర్వేషన్ ఇస్తుంది. ఇది సెంట్రల్ గవర్నమెంట్ ఎడ్యుకేషనల్ ఇన్స్టిట్యూషన్స్లో ఎస్సీ ఎస్టీలకి రిజర్వేషన్ ఉంది. అట్లాగే సెంట్రల్ గవర్నమెంట్ ఎంప్లాయ్మెంట్లో కూడా ఎస్సీ ఎస్టీలకి రిజర్వేషన్ ఉంది. అట్లాగే స్టేట్ గవర్నమెంట్ కూడా స్టేట్ ఎడ్యుకేషనల్ ఎంప్లాయ్మెంట్ ఇన్స్టిట్యూషన్స్లో రిజర్వేషన్ ఇస్తూ ఉంది. ఆర్టికల్ 15(4) ఏం చెప్తా ఉందంటే, ఒక వీకర్ సెక్షన్ లేదా కొన్ని వీకర్ సెక్షన్స్కి సెంటర్లో, స్టేట్లో, వాటి సంస్థల్లో అడ్వకేట్ రిప్రజెంటేషన్ లేదు, విద్యలో వెనకబాటుతనం కలిగి ఉన్నాయని గుర్తించినట్లయితే వాళ్ళని విద్యలో అడ్వాన్స్మెంట్ చెందించడానికి కావాల్సినటువంటి అన్ని చర్యలు స్టేటు ఆర్ సెంటర్ తీసుకోవచ్చును అని 15(4) చెప్తా ఉంది. సెంటర్ తీసుకోవచ్చు, సెంటర్కి సంబంధించినటువంటి ఇన్స్టిట్యూషన్స్లో, స్టేట్ తీసుకోవచ్చు, స్టేట్కి సంబంధించిన ఇన్స్టిట్యూషన్స్లో అని చెప్తా ఉంది. అట్లాగే 16(4) ఏం చెప్తుందంటే, ఒక వీకర్ సెక్షను లేదా కొన్ని వీకర్ సెక్షన్స్కి ఎంప్లాయ్మెంట్లో అడ్వకేట్ రిప్రజెంటేషన్ లేకపోతే తగినటువంటి అడ్వకేట్ రిప్రజెంటేషన్ కల్పించడానికి సెంటర్ ఆర్ స్టేట్ అవసరమైన అన్ని చర్యలు తీసుకోవచ్చు అని చెప్తా ఉంది 16(4). అంటే స్టేట్ గవర్నమెంట్లో విద్యా సంస్థలు ఉన్నాయి, ఉద్యోగ సంస్థలు ఉన్నాయి. కేంద్రంలో, సెంటర్లో విద్యా సంస్థలు ఉన్నాయి, ఉద్యోగ సంస్థలు ఉన్నాయి. ఈ రెంటిల్లో కూడా ఈక్వల్గానే ఇది అప్లికేబుల్ 15(4), 16(4) అనేది. అంతేగాని స్టేట్కి మాత్రమే వర్తించే జడ్జిమెంట్ కాదు ఇది. ఎందుకు స్టేట్కి సంబంధించి వర్తించింది అని అనుకుంటున్నామంటే, స్టేట్ గవర్నమెంట్ మొట్టమొదటిగా తనిచ్చే రిజర్వేషన్స్ని రేషనలైజ్ చేసింది. ఫస్ట్ ఆంధ్రప్రదేశ్ కానీ, పంజాబ్ కానీ, లేకపోతే తమిళనాడు కానీ, కర్ణాటక కానీ కొన్ని స్టేట్స్లో ఆ స్టేట్ గవర్నమెంట్స్ ఇచ్చేటువంటి రిజర్వేషన్స్ని స్టేట్ గవర్నమెంట్స్ రేషనలిస్టిక్గా డిస్ట్రిబ్యూట్ చేసే ప్రయత్నం చేసినాయి జీవోలు, చట్టాల ద్వారా. అయితే ఎవరైతే వర్గీకరణ వ్యతిరేకులు ఉన్నారో, అంటే రిజర్వేషన్ క్లాసిఫికేషన్ యాంటీ క్లాసిఫికేషనిస్టులు ఉన్నారో, వాళ్ళు ఏం చేశారంటే ఆ సెంటర్కి పార్లమెంట్లో యాక్ట్ చేయాలి, ప్రెసిడెంట్ ఆఫ్ ఇండియా అసెంట్తో పార్లమెంట్ యాక్ట్ చేయాలి, ఇది చెల్లుబాటు కాదు, స్టేట్స్ చేయడానికి వీలు లేదని చెప్పి వేరే వేరే సెక్షన్స్ అన్ని ఆర్టికల్స్ అన్ని తీసుకొచ్చి అడ్డం పెట్టారు. అందుకని మనమేమనుకుంటున్నామంటే ఇది స్టేట్స్కి సంబంధించిన జడ్జిమెంటేనా, సెంటర్కి వర్తించదా అనేది మీరు అన్నారు. కానీ సెంటర్కి, స్టేట్కి కూడా వర్తిస్తుంది. తమాష ఏంటంటే జడ్జిమెంట్లో ఇది స్టేట్స్కి పవర్ ఉందని స్పష్టంగా చెప్పింది. అయితే సెంటర్ కూడా వెల్కమ్ చేయాలి. కానీ సెంట్రల్ గవర్నమెంట్ దీన్ని మేము వెల్కమ్ చేస్తున్నామని చెప్పి సెంట్రల్ గవర్నమెంట్ కానీ, సెంట్రల్ గవర్నమెంట్ ప్రతినిధులు కానీ, ఆ పార్టీకి సంబంధించిన వాళ్ళు ఎక్కడ కూడా మాట్లాడలేదు. కానీ రెండుకి వర్తిస్తుంది, సెంట్రల్ గవర్నమెంట్కి వర్తిస్తుంది జడ్జిమెంటు, స్టేట్ గవర్నమెంట్కి వర్తిస్తుంది. అట్లాగే స్టేట్ యావరేజ్, సెంట్రల్ గవర్నమెంట్ యావరేజ్ ఒకటి ఉంది. ఏది సెంట్రల్ గవర్నమెంట్ 7% ఇస్తూ ఉంది, 14% ఇస్తూ ఉంది ఎస్సీలకి రిజర్వేషన్. విద్యా ఉద్యోగాలలో సెంట్రల్ గవర్నమెంట్ రిజర్వేషన్ 14%. అట్లాగే సెంట్రల్ గవర్నమెంట్ విద్యా ఉద్యోగ సంస్థల్లో ట్రైబల్స్కి 6% అనుకుంటాను ఇస్తూ ఉంది. అంటే ఆ యావరేజీ సెంట్రల్ గవర్నమెంట్ వర్తింప చేస్తుంది జనరల్గా. స్టేట్ గవర్నమెంట్స్కి వచ్చినప్పుడు ఆయా స్టేట్స్ పాపులేషన్లో ఒక్కొక్క స్టేట్కి ఒక్కొక్క పర్సంటేజ్ ఆఫ్ ఎస్సీస్, పర్సంటేజ్ ఆఫ్ ఎస్టీస్ ఉన్నారు. ఒక్కొక్క స్టేట్కి ఒక్కొక్క పాపులేషన్ పర్సంటేజ్ మారుతూ ఉంటుంది. సపోజు తెలంగాణలో 18%, లేకపోతే ఆంధ్రప్రదేశ్లో 17%, తమిళనాడులో ఇంకా ఎక్కువ, పంజాబ్లో 24%. ఇట్లా టోటల్ స్టేట్ పాపులేషన్లో ఆ పర్టికులర్ స్టేట్ పాపులేషన్లో ఎస్సీ పాపులేషను, ఎస్టీ పాపులేషన్ పర్సంటేజ్ మారుతూ ఉంటుంది. ఆ మారిన పర్సంటేజ్కి అనుగుణంగా ఆయా రాష్ట్రాలు, స్టేట్స్ రిజర్వేషన్స్ ఇంప్లిమెంట్ చేస్తూ ఉంటాయి. ఇది బ్రాడ్గా జడ్జిమెంట్ని మనం అర్థం చేసుకోవాల్సినటువంటి అవసరం ఉంది. అట్లా ఇకపోతే నేను పర్సనల్గా క్రీమీ లేయర్ అనేటువంటి కాన్సెప్ట్ని నేను అంగీకరిస్తాను. ఎందుకంటే నా నేపథ్యం అగ్రికల్చరల్ లేబర్ ఫ్యామిలీ నుంచి నేను వచ్చాను, రూరల్ నుంచి వచ్చాను. నా కుటుంబం, నా తల్లిదండ్రులు వ్యవసాయ కూలీలు. నాది డ్రాప్ అవుట్ బ్యాక్గ్రౌండ్. నేను 5th క్లాస్లో చదువు ఆపేశాను. ఎట్ ఏజ్ ఆఫ్ 46 నేను అంబేద్కర్ ఓపెన్ యూనివర్సిటీలోకి ఎంటర్ అయ్యి 3 ఏళ్ళు గ్రాడ్యుయేషను, 2 ఏళ్ళు పొలిటికల్ సైన్సు, 1 ఏడాది పీజీ డిప్లొమా రైటింగ్ ఫర్ మాస్ మీడియా చదువుకొని నేను ఇప్పుడు అంబేద్కర్ ఓపెన్ యూనివర్సిటీలోని అకాడమిక్ కౌన్సిలర్ని, బోర్డ్ ఆఫ్ స్టడీస్ మెంబర్ని, అట్లాగే అనదర్ ఎంఏకి నేను స్టూడెంట్ని కూడా. ఇప్పుడు నాకు చాలా కోపం ఉంది. ఎస్సీ ఎస్టీలలో మళ్ళీ అవకాశాలు పొందిన వాళ్ళు ఎవరైతే ఉన్నారో ఆ కుటుంబాల పట్ల నాకు చాలా వ్యతిరేకత ఉంది. ఎందుకంటే వాళ్ళ సోషల్ రెస్పాన్సిబిలిటీని వాళ్ళు ఫుల్ఫిల్ చేయడం లేదు. సపోజ్ 2 కుటుంబాల పేర్లు చెప్తాను, తెలుగు సంబంధించి, ఎస్సీలకు సంబంధించి. ఒక మాల, ఒక మాదిగా. సపోజ్ కాకి మాధవరావు కుటుంబం, వాళ్ళ ఇంట్లో చాలామంది ఐఏఎస్లు ఉన్నారు. కత్తి చంద్రయ్య కుటుంబం, వాళ్ళ ఇంట్లో చాలామంది ఐఏఎస్లు ఉన్నారు. నేనేమంటానంటే పొందిన వాళ్ళే మళ్ళీ పొందుతున్నారు, మిగిలిన వాళ్ళు ఎప్పుడు పొందాలి? బ్రదర్ చెప్పారు ఒక మాట, అగ్రికల్చరల్, నేనేమంటానంటే ప్రిఫరెన్షియల్ ట్రీట్మెంట్ అన్నప్పుడు అడ్మిషన్స్లోను, అపాయింట్మెంట్స్లోను కొన్ని ప్రిఫరెన్షియల్ సెలక్షన్ బోర్డ్స్, సెలక్షన్ కమిటీలు, ఇంటర్వ్యూ బోర్డులకి కొన్ని ఎలిజిబిలిటీ క్రైటీరియా పెట్టాలి. ఏమిటంటే రూరల్ నుంచి వస్తే క్యాండిడేటు 1 మార్కు కలపాలి, ఫస్ట్ జనరేషన్ అయితే 1 మార్కు కలపాలి, మదర్ టంగ్ అయితే 1 మార్కు కలపాలి. ఎందుకంటే బ్యాక్వర్డ్నెస్కి సింబల్ మదర్ టంగ్ అనేటువంటిది. రూరల్ నుంచి 1 మార్కు, ఫస్ట్ జనరేషన్ 1 మార్కు, మదర్ టంగ్ అయితే 1 మార్కు. ఇలా కలిపితే ఆటోమేటిక్గా అడ్మిషన్స్లో కానీ, అపాయింట్మెంట్స్లో కానీ ఫస్ట్ జనరేషన్స్ ఎవరైతే ఇప్పటి వరకు మోర్ నీడీ పీపుల్ ఉన్నారో వాళ్ళకి అవకాశాలు పోవడానికి వీలవుతుంది. అప్పుడు అసలు ఎటువంటి క్రీమీ లేయర్ కూడా అవసరం లేదని నా దృష్టిలో నేను చెప్పదలుచుకున్నా. కానీ క్రీమీ లేయర్ని నేను సపోర్ట్ చేస్తా. పొందిన కుటుంబాలే మళ్ళీ పొందుతున్నాయి, మిగిలిన వాళ్ళు వెనకనే ఉంటున్నారు. ఇది సరైంది కాదు. ప్రతి కమ్యూనిటీలో కూడా అమలు జరుగుతుందే కొన్ని, ఆ కొన్నిట్లో కూడా మళ్ళీ పొందితే మిగతా వాళ్ళ పరిస్థితి ఏం కావాలి? కాబట్టి క్రీమీ లేయర్ ఉండాలి. క్రీమీ లేయర్ ఉండకూడదు అనుకున్నప్పుడు ఇదిగో ప్రిఫరెన్సెస్ ఫిక్స్ చేయాలి. సెలక్షన్ కమిటీ, అడ్మిషన్స్లోను, అపాయింట్మెంట్స్లోను సెలక్షన్ బోర్డ్స్, ఇంటర్వ్యూ బోర్డులు, కమిటీలు ఏవైతే ఉన్నాయో వాళ్ళకు ఒక గైడ్ లైన్స్ ఫిక్స్ చేస్తే అప్పుడు చాలా సైంటిఫిక్గా మోర్ నీడీ పీపుల్ ఎవరైతే ఉన్నారో వాళ్ళకి ఫస్ట్ అవకాశాలు, ప్రిఫరెన్షియల్ అవకాశాలు వాళ్ళకి పోవడానికి వీలవుద్ది అనేది నా ఉద్దేశం. థ్యాంక్ యూ.
Just briefly, just 2 sentences. One is, he says that Article 15(4) and 16(4) specifically say that if wherever there is inadequate representation in education and employment for whichever community, there is a need for creating special treatment, providing a reservation for those communities. So therefore, this judgment is not applicable to only to the state governments. It is also applicable both for the center and state, though central government is not very open about what it is going to do. That's one thing. The second thing is, at the state level, the application of reservation should vary from state to state because the proportion of the population in each state differs. For instance, in Telangana, it is 18%, in Andhra Pradesh, it is 17%, in other states, their proportion of the SC population, ST population must be much less or more. According to that, the reservation should be given. He differs with other speakers on the question of creamy layer. He thinks that there are already few jobs for SC, ST under the reservation, but those who have used the reservation first generation and the next generation is not behaving responsibly. Therefore, while recruiting or and admissions in the educational institutions, he proposed certain kinds of criteria for giving preferential treatment for certain kinds of communities. If a candidate is a first generation educated, he should be given preference. If a candidate is with a mother tongue, he goes up in the education, he should be given preference. And if the candidate is from rural background, then they should be given preference. I think this criteria guidance to the people who admit people in the educational institutions and employment will automatically take care of the problem of the creamy layer. And yeah, this is the, thank you.
Oh, I have to say anything? No, I think if anyways we're going to have sub-classification, then go to the other classes within the sub-classification rather than leaving them unfilled, because that's also then a way of upper caste saying that, oh, they have not been filled for many years, so that's the way it's been happening. The second issue of affirmative action, and I agree that one should be able to bring in points, like JNU used to bring in points for region, first generation, etc. But now under the new QET system, everything is standardized. We don't even know who we're admitting. And even at PhD level, we have no way of actually controlling who we admit, because you have to admit people with JRFs or etc. So I think it's not just a question of how do we give autonomy to institutions to implement these affirmative actions and make that the norm, not just that. I mean, where will these norms be otherwise? Who is going to do the screening? At least, I mean, I just know from the perspective of educational institutions. I don't know about others.
సుప్రీంకోర్టు జడ్జిమెంట్లో ఒక మాట చెప్పింది, ఎట్లా పడితే అట్లా స్టేట్స్ చేయడానికి వీల్లేదు, సెంటర్ అయిన స్టేట్స్ అయినా. అట్లా కనుక మీ ఇష్టం వచ్చినట్టు అవకతవకలతో తప్పులతో మీరు రేషనలైజ్ చేసే ప్రయత్నం చేస్తే సబ్ క్లాసిఫికేషను మేము రివ్యూ చేస్తాము జాగ్రత్త అని ఒక హెచ్చరిక చేశారు. చేస్తూ వాళ్ళు ఏమి చెప్పారంటే, ఎంపిరికల్ డేటా ఆధారంగా ఇండికేటర్స్ పెట్టి, ఆక్యుపేషనల్ ఇండికేటర్స్, బ్యాక్వర్డ్నెస్, ఎడ్యుకేషనల్ బ్యాక్వర్డ్నెస్, ఎంప్లాయ్మెంట్ బ్యాక్వర్డ్నెస్, ఎకనామిక్ బ్యాక్వర్డ్నెస్, ఇట్లాంటి బ్యాక్వర్డ్నెస్ ఇండికేటర్స్ పెట్టి వాటి ఆధారంగా బ్యాక్వర్డ్నెస్ని నిర్ధారించి అప్పుడు గ్రూపింగ్ చేసి ప్రిఫరెన్షియల్ ట్రీట్మెంట్ ఇవ్వాలని చెప్పి చాలా స్పష్టంగా సుప్రీంకోర్టు జడ్జిమెంట్లో చెప్పారు. అది మనం గుర్తుపెట్టుకోవాలి. అంతే తప్ప ఎట్లా పడితే అట్లా స్టేట్స్ కానీ సెంటర్ కానీ చేయడానికి వెళ్ళలేదు, మేము రివ్యూ చేస్తాం జాగ్రత్త అని చెప్పి హెచ్చరిక చేసింది. థ్యాంక్ యూ సార్.
He is trying to remind that Supreme Court very specifically, categorically said that you can't implement reservation without data. You have to have a clear data on the educational backwardness and employment backwardness and social backwardness of the communities, and you have to implement. Otherwise, we are going to review the entire process. So this is a warning from the Supreme Court that it is going to observe the process of implementation of this judgment.
Okay, thank you, everyone. Thanks for the questions, and I think everyone has responded adequately. So I won't venture to do anything as summary. I think we have had enough of complexity debated, and I think there is much to munch over. and we will move into the next session. So you would agree with me that we started with a big bang. So therefore, let us give a big applause to the panelists. Thank you. We'll break for lunch. I'm not sure when are we expected. Maybe I request the organizers to make the. Yeah, but what time are we back? 2:30. Yeah, so we'll be back at 2:30.
The panelists, OC members, and volunteers are requested to move to Thinking Man for lunch. Everyone else, please go to the mess. Thank you. And we'll reconvene at 2:30 for the next session.
Good afternoon. Welcome back. We have a very interesting panel to discuss about criminal process and bail and what has happened in the past 1 year in relation to bail jurisprudence in the Supreme Court and whether what has happened is transitory in nature. There seems to be some turnaround that Supreme Court is asserting its power to grant bail even in cases like EAP and PMLA. Is it judiciary over the arbitrary power of the state and defend the constitutional right to personal liberty? So we have with us a very interesting panel. Advocate Abhinav Sikri is a legal scholar and lawyer from Delhi who practices in trial courts in Delhi, and he also runs a blog, Proof of Guilt. The name of the blog would be very counterintuitive in the present context, because do we need a proof of guilty at all? And we also with us Advocate Nihal Singh Rathod, who invested a lot of energy in defending personal liberty of Professor Sai Baba. Actually, students were very enthusiastic to name this panel as Professor G.N. Sai Baba Memorial Panel. And this is to draw the inspiration from an academic becoming a serious activist, and for his convictions getting imprisoned and eventually acquitted as innocent. But the consequences of his long incarceration resulted in his death. The personal liberty doesn't remain a concern within the corridors of the judiciary at all. Beyond that, there is so much that happens. We also have with us Ms. Sukanya Shanta. Perhaps you are familiar with the name because she was the petitioner in caste discriminations in the prisons. Justice Chandrachud delivered a very good judgment on the caste discriminations and in the prisons. And we also have the fourth speaker, that is Mr. What kind of echoes that he hears when he actually handles the questions of personal liberty. So now I call upon Mr. Abhinav Sikri to speak for 15 minutes, and each one of them will speak for 15 minutes, followed by there will be 2 rounds of discussions on the entire subject. Thank you.
I'm trying to keep a timer, but I'll try and promise to be less than 15 minutes if I can, to make sure that we maximize time for discussions. But no promises are fully kept. Okay, so thank you so much for having me here. This is my first time here physically to be part of this conference. I've been part of it virtually before. And look, in terms of, the scope of my presentation is going to be a little limited, because in terms of bail and civil liberties, frankly, we can have a 4-day or a 2-day conference just on various aspects of that, and to try and crunch it down into an hour and a half and to talk about it from various perspectives. Monumental effort for this panel, within which what I am going to try and do is I'm going to try and look at the so-called, the headline making side of things, which are now frankly 2 acronyms in the form of UAPA and PMLA when it comes to bail, or rather the anti-bail laws, if they've sort of become, where jail is supposedly the rule and bail is the exception. And 2024 within that context for me is a very interesting year. The theme of my presentation is going to be largely focused on the one trend that I would say, the Supreme Court of India sort of seems to reflect as in a retrospective when it comes to bail under the UAPA and PMLA, which is this remembrance of the right to speedy trial in a bail context. And I think this tendency starts to be seen towards the end of 2023, but it really blossomed into a full-blown theme all through 2024. The highlights of it obviously being cases such as Manish Sisodia's case, where within a period of 8 months, the Supreme Court first says, look, no bail, but we say that finish the trial in a year, being fully aware that that is practically impossible, giving ways to move again within the space of a year, and then saying that a period of incarceration, which at that point of time was a year and 5 months, is too long, and the delay is so much that we conclude that the right to speedy trial of the petitioner is going to be infringed with the prospect of a very delayed trial.
Is it audible? Is there some problem?
Okay, great. So in terms of, to get to this, we just need to do a little bit of background first, right? So normally you would say that bail is the rule and jail is the exception, is what the books will say. But when it comes to the Indian criminal process, I would say that frankly is not the rule in any sphere of its working, let alone spheres of working such as the UAPA and the PMLA, statutes that specifically make bail harder to get as opposed to other scenarios. The reason for that is a very complex contextual reason that has developed over time. Legally speaking, unlike, let's say, other jurisdictions which have a bail law or a bail act that specifies what are the grounds on which a person can be further detained in custody, bail in India is largely a question of judicial discretion that is not guided by legislative sort of parameters. And I'm sure that that will get developed on during the course of this panel itself. What that means is, over time, historically, and if you turn back the clock, you will see that historically, the merits of the matter, right? What is the alleged case against you has always held a great importance, even though the law also in the same breath says that you're presumed innocent at this point of time. Whatever is the accusation against you, the gravity of those potential charges have always held great sway in matters of bail. It's not new, it's old, it's been part of the law for forever, practically. And if you go back in time, it was in fact the norm, right? So we've never broken free of that in a sense. And that still remains how bail jurisprudence at the ground level is done. You will argue merits. There is no bail matter. And again, as a practitioner, I can tell you this, no bail matter will be just, oh, he's not a flight risk, or he's a person who is young, and therefore you will always have a conversation about what are the allegations against a person. That's just how it works. Where it comes to certain kinds of offenses under, let's say, the UAPA, which is your premier anti-terror statute, and the PMLA, which is the anti-money laundering law in India, the norm, which is just have judicial discretion, is supplanted by a legislative edict telling court that please don't grant bail unless the person in custody is able to show you reasonably that they are not guilty of the offense. Like it's so paradoxical if you think about it, that you are innocent until proven guilty. You literally have no idea what the material against you is at this point of time, because anyone who has sort of been near courts will know that you will only start getting material once the case has completed its investigation, right? So during the investigative stage, nothing as such gets shared with a person who is an accused and in custody. But still, in spite of all of this, the legislative edict is very clear. Please only grant bail if the person can convince you that they are not guilty of the allegations against them. And that is understandably a step up, right? So the courts are being told that your normal discretion is not good enough, even though that normal discretion may also be fairly conservative. But in these cases, please be extremely conservative. That's the clear signal that is being sent. In that vein, 2024 started with a very sort of polarizing decision in a sense. And I still remember, when this decision came. The decision was a judgment by the name of Gurvinder Singh versus State of Punjab, It really is at the start of the year. It was delivered on Feb 7th, where an observation was made that in such statutes, it was a UAPA case, the observation was made that in such statutes, jail is the rule, right? And it was so harshly and tersely put that I mean, again, as an anecdote, I'll share with you, we were arguing some bail cases at that point of time where the dates between our arguments concluding and the response by the prosecution was sort of met by this judgment coming. And you went to court and you knew exactly whatever you had argued was sort of out of the door, because now all that the prosecutors would do is show this decision that is telling special courts in a UAPA context that, look, if the Supreme Court of India is telling you that jail is the rule, who are you to differ, right? So ultimately, it places a legislative edict at such a higher pedestal that when the Supreme Court sort of buttresses it in that cold, hard language, that really jail does seem like the rule, right? So that's how 2024 sort of started, which was a very sobering start, because at the same time you had judgments, and this is where the polyvocality of the court sort of comes in. You had judgments that are trying to deal with the merits of a case, which is what you have to do in these offenses, and try and come to an answer that no, the accusation is not made out, so on and so forth. But at the same time, you have a judgment that comes and says it in as black and white a language as you can imagine. What then happens over the year is what I find interesting, where you have not a stated effort where you have seen, let's say, either a bench of a higher strength, right? So this is a 2 justices bench, a division bench as we call it. It's not like there was a 3 justices bench or a 5 justices bench that said, no, let's clarify, it is not the rule. This might be a way in which we work, but definitely not the rule. You saw the blossoming of this separate stream of jurisprudence altogether. It is not new, which is why I wouldn't credit it as being a novel sort of discovery by the Supreme Court in 2024. But I would call it a rediscovery and definitely a sort of revisit to the classics of the late 1970s era and the 80s era. And this is the right to speedy trial and its interaction with bail. What is this history that I'm referring to? Again, for the benefit of everyone here, Mr. Diwan, in his opening today, I don't know how many of you were present in the audience, he was sort of doing a retrospective of, the history of the court. And he mentioned the emergency phase and what followed, where the court sort of takes steps to re-legitimize itself in the eyes of the public. And a key phase was during that era of public interest litigation starting, were judgments that looked at the prison as a site of intervention for the law. For the first time, you had the law really break open the doors of prisons and move in and claim that space. And there you have one area which was talking about under trial persons who had been in custody for unfathomably long periods of time. So much so that sometimes they had served the entirety of their sentence in prison without ever realizing that they ought to have been released. And that then starts a conversation in decisions such as Husainara Khatun, that there is not only a right to speedy trial, but it has to be an enforceable right. And the way you make it enforceable is you start pegging it to certain parameters and give relief. That's where you have that interaction that if a certain period of time has been crossed for a person as an under trial in custody, their further custody now becomes unconsignable. It is an affront to personal liberty, and therefore they ought to be released. In 2023 and in 2024, you see the Supreme Court tap into this jurisprudence, because the commonality in almost all of the cases under, let's say, the UAPA or PMLA was the unconsignably long period of custody that under trials has suffered. And so you see in Manish Sisodia's case, which is a PMLA decision, in V. Senthil Balaji, again a PMLA decision, Satyendra Jain's case at the trial court level for that matter, there are various UAPA cases, again, the more prominent of those being probably Athar Parvez and Jalaluddin Khan. You will be unsurprised to see that some benches are common in some of these decisions, right? So again, clearly some benches adhere to this philosophy more than others. But the idea was very clear that when the time elapsed has become so high, you can't have a legislative sort of prohibition override the constitutional mandate, right? So in the eyes of Article 21, in a sense, and this is the language of the court, that legislative prohibition sort of dissolves or withers away after a certain point of time. And that was recognized to be a ground for bail. And which saw therefore persons get released where otherwise probably they weren't getting released. And we started with a mention of Professor G.N. Sai Baba's case. And there again, in other cases of UAPA, let's say till 2023, you have instance after instance where this was not an argument that was willingly taken, aggressively taken, or it was rejected by courts. So you can say that, you know, very well, this is a great development for lawyers. You have now an additional grounds to argue. And well, everyone should be happier at the end of 2024, which is where you will see my face and say that I'm not smiling as I'm saying this, because clearly there is a hint, not only a hint of irony, but a lot of irony in my saying that. Because this is what my argument is going to be for every one of you to consider. I think that this is actually not as positive a development as is being seen to be, because what has actually happened is, and this goes back to a remark that ma'am you made in the morning about rights versus handouts, where what has happened in the guise of giving, you know, enforcement or respect to a fundamental right, bail has actually become so much more capricious, so much more judge dependent, to look like a handout, that you can't reasonably say that what you're dealing with is a new dimension of a fundamental right, because the very essence of a fundamental right is its consistency in its enforcement. And that is entirely absent from this new sort of revisited domain of speedy trial and bail, where, again, take a step back and think about it. What is this so-called point of time in your arc of under trial custody that your custody becomes an affront to your right to personal liberty? Is it 1 year? Is it 2? Is it 5? It may be 6, right? And I'm not making light of this. There's a table right in front of me which I had prepared. In one case, it was 4 years and 4 months. In one case, it was 1 year and 5 months. In one case, it was 9 years and 5 months. In another, it was 7 years and 6 months. Right? So it's a spread across the spectrum. Not only this, but when it comes to things such as, well, is it that the court has to be satisfied that your right has been deprived? You've been, let's say, in custody for 5 years and it's a bad thing. Or is it that at the end of 1 year and 5 months, the court thinks that, look, we see that there is no reasonable prospect of you having a trial anytime in the future. And we are now convinced that keeping you in further custody has no purpose at all, because your trial will never see any conclusion in a reasonable point of time. So 1 year, 5 months today will definitely become 7 years, 6 months later. But again, that's a very slippery slope, right? So what that depends upon is your deep pockets to get the best lawyers to convince the court. And obviously the unstated assumption there is you having the wherewithal to go to the Supreme Court in the first place, which might be true for a lot of persons in PMLA cases, which is where I don't think it's a surprise that this sort of revisit happens in PMLA cases, but it does not happen with UAPA cases to begin with, because there is that intersection between persons who have the ability to go to court and enforce their rights versus persons who don't, right? So there is that side of the spectrum as well. What then the third side of the spectrum, which is where I don't think that this is as positive a development, is that the language of the court so far, and this is something that possibly could be remedied going forward, is that the language of the court, not only the Supreme Court of India, but also various high courts dealing with this, has sort of tried to expressly in some cases and unsaid in some other cases, make it a point of constitutional courts and their powers, not the trial courts, not your magistrate, not your special court that is actually dealing with these cases, that is actually the so-called court of first instance, the court of first instance, and the first defender of civil liberties, as has been referred to by the senior judiciary itself. Where you frame this argument in an argument of constitutional rights and liberties, you automatically bring in a power that only a constitutional court can get, which is again a forum that is not accessible to one and all. And that again is something that will require time, energy, resources, and that also elongates the period of time. Because where your entirety of your bail proceeding will, let's say, end in 6 weeks, 8 weeks, 12 weeks at best at a special court level, that automatically becomes a conversation of months when you travel upwards of the judicial ladder. And sometimes it is only a conversation in years when you've traveled furthest up the judicial ladder, right? So in terms of really empowering civil liberties, giving meaning to Article 21 from that facet, it's again questionable as to how far this has gone ahead and done it. So in terms of, again, my 15 minutes are up, so I'll just try and conclude as quickly as I can. I think that the defining theme on bail and civil liberties in this UAPA PMLA context in 2024 was the blossoming of recognizing speedy trial as something relevant for the bail conversation, which all said and done is definitely a positive development because you now have a further grounds to argue. But is that a long-term solution to what is a much deeper problem? Is that a sustainable solution? And is that really making a difference at the ground level, which is where all of these conversations start? I am very uncertain about it. And I think that a lot of finesse will be required going forward to make sure that this right and this sort of new paradigm, or rather, old wine in a new bottle paradigm really delivers the promise that it does contain. Because make no mistake, this is a very viable argument if developed in a consistent manner and an enforceable manner. But in the hands of, caprice and whim, it is just a question of, well, satisfying the individual prejudices of each judge, which ought not to be how fundamental rights are operationalized. So that was my presentation. Thanks.
Thank you, Abhinav, for actually bringing out the real implications of the judgments that came in 2024. I mean, the way that you said, why not in EAPA cases? And also, if the court really says that speedy trial is a fundamental right, which can determine granting of the bail, is it extended to lower courts also? I want to ask you to, because if that is not going to happen, I think this will remain only at the level of Supreme Court. It's a very scary picture, and whether it is sustainable, this model of adjudication and bail jurisprudence, is it sustainable, which will really help 5.5 lakh people who are in the prisons, is a serious question that is before us. Thank you. Now I ask Nihal Singh Rathod to speak.
Thank you. Thank you so much, Murli sir. To me is really too big, and as my friend indeed said, that when we talk about bail and bail jurisprudence, 3-4 days wouldn't be even enough. On top of that, I've been asked to speak also about Sai Baba's case. Now, adding to these two things, I suppose even 8 days wouldn't be enough. We made tremendous efforts to get Sai Baba on bail, parole. Even during COVID, we tried to obtain bail for him, bail on medical grounds, bail on every possible ground, but that was not to be. Anyhow, I need to restrict myself to the time that is given, and therefore, first time ever, I have prepared my speech, my presentation. It is in writing. I'll try and read it out. However, given my friend having already touched on some of the important aspects, I will skip some parts, and I'll try and complete myself in 10 minutes so that we can have more time for discussion afterwards. So going back to May 2014, Maharashtra police went on a mission to the capital of nation to catch an extremely dangerous terrorist. They picked up this terrorist from his Maruti Alto car while he was proceeding to Delhi University. They lifted the terrorist by his shoulders, took along his wheelchair and flew him down to Nagpur and then to Aheri, a small town in Gadchiroli district of Maharashtra. This terrorist was on his way to Delhi University. There, he was planning to teach his students that day, just like any other day. He was a professor imparting lessons of English language. He was little known activist in the circles of Delhi and Telangana. He was Professor G.N. Sai Baba. He was an activist, a scholar, a vocal critic of state. A wheelchair-bound paraplegic 90% disabled man with his only 2 arms functioning then had just begun his ordeal, which was to last for about a decade for others, while for him, it was to last for his remainder of life. State alleged that he was found to have treasured in his house various Maoist-related literature, mostly in his hard drives. Few months prior to his arrest, they had raided his house. In the raid, over 50 policemen stormed his residence and took away hard disks, pen drives, laptop, etc. However, they did not seize it in the manner that is known to law. They were flanked by cyber expert videographer, yet no videography ever surfaced. Yet electronic records were not seized in the manner IT Act requires. Though he was labeled as an extremely dangerous terrorist, state could not even allege, let alone attribute and prove any single act of terrorism. He was called terrorist without having committed any terrorist act. He was slapped with Unlawful Activities Prevention Act, a law enacted to deal with terrorism where bail is just a dream. Similarly, another person, Pandu Narote, a tribal man residing in the far interiors of Gadchiroli, was booked along with Professor G.N. Sai Baba. It was alleged that he was intercepted while on a mission of escorting another terrorist. This person, on highly secret, discreet mission, while though was hiding his identity, as per accusation of prosecution on his arrest, he was found carrying with him his own caste certificate, caste validity certificate, his domicile certificate, his ration card, his election card, his school living certificate, on top of that caste certificate of his daughter. While Pandu and others managed to secure bail, it was not easy for Sai Baba. His bail was rejected by Nagpur bench of Bombay High Court. Few days thereafter, a suo motu PIL was registered by principal bench, which examined his health condition and granted him 6-month-long bail to avail medical care. Court said that he can apply for extension, and when he applied for extension, he was ordered to surrender even before those 6 months could expire. Later on, Supreme Court expedited the trial pending his plea for bail and eventually granted him bail pending trial. Soon, Sessions Court at Gadchiroli handed down a verdict of conviction, calling upon all accused to make submissions on the sentence to be imposed. All refused, for none believed that there was anything legal in the case, nothing worth conviction. The verdict said, and I quote, "Life sentence is not enough, but my hands are closed," making it clear that had there been a provision in the law, at least Sai Baba could have been sentenced to death. Without having to sentence to death, Pandu Narote, one of the convicts, indeed died while in jail, awaiting outcome of appeal. For him, conviction proved death sentence, for he died of suspected swine flu inside the prison itself. Nothing different happened with Professor G.N. Sai Baba either. In fact, we as lawyers used to always discuss among ourselves and wonder whether he will make it before his appeal is decided. He of course made it, however, not for long. Although he died as a free man, but he died of what he was compelled to acquire in the fetters of prison. His pre and post conviction incarceration made uncountable dents to his health. When he first went in jail, as I said earlier, his both arms were functioning. However, when he came out, he could barely use his one hand. I cannot even imagine how must he have survived on his own in the jail. How did he wheel his chair? How did he get on and off his chair? How did he attend to nature's call? Not all the time Pandu or Mahesh were there to assist him. He was ferried to hospital many a times, most of the times by ruthless guards who would treat him like a pound of flesh. Another case is Yalgar Parishad Bhima Koregaon case. At least one common thread between these two cases is Professor G.N. Sai Baba himself. All 16 who are suffering in this case were fighting for release of Sai Baba in various parliamentary, legal and democratic ways. One of them happens to be Sai Baba's main defense lawyer, Mr. Surendra Gadling. When Sai was second time acquitted by the High Court, he came to be released very reluctantly after 2 days of our fight since his order of acquittal. While interacting with media, he said, and I quote, "I was a healthy man, only suffering from my disability. This prison time has given me many ailments. My heart function is down to 55%, while my liver, gallbladder, kidney, muscle, spine are equally affected. Doctors have advised multiple surgeries." And he put a pertinent question: how will my days be returned to me? Being a lawyer as a part of justice delivery system, I also ask this question: how to return these days spent in jail? How to return the health lost in prison? How to restore life back to where it was intercepted from? And if that cannot be done, then what is the solution? What is the resolution? An accused who faces accusation remains innocent until proven guilty. He has right to prepare an appeal after conviction. Law journals are full of instances when persons are honorably acquitted by high courts and even Supreme Court. Most of the times on merits, and in some cases even on technicalities. There is at least one instance that I can refer to when Supreme Court, after dismissal of appeal, review and curative, intended yet another review and found people on death row to be innocent and directed their release with further orders to pay them compensation. Question therefore really becomes, how will you restitute the harm caused to the life, liberty, dignity and health of the person? After Justice Krishna Iyer, many a times our courts have reiterated that bail is rule and jail is an exception. However, reality is rejection of bail is norm and allowing it has become an exception. denial of bail citing whatever reason has led to people languishing in jail for a prolonged period. I want to look at this issue of bail from the point of view of principles as are available as such under civil and constitutional laws, not under criminal laws. One is principle of restitution and principle that act of court shall prejudice none. Second is principle of balance of convenience. And third is principle of exception. Order granting or refusing bail has been held to be an interlocutory order, meaning thereby an interim order. In case of Southeastern Coalfield Limited, Supreme Court elaborated on principle of restitution. I will not read what Supreme Court has said, but then restitution is a principle recognized under section 144 of Civil Procedure Code, where it says that if a party suffers due to an order of the court, be it interim, on its reversal, court is duty bound to place that person back to the position where it would have been had it not been interfered by the court's order. Now that is the principle available. And what Supreme Court has said, and I'll read only one part, one line, the section 144 CPC is statutory recognition of pre-existing rule of justice, equity, and fair play. Simply put, the principle of restitution requires a court of law to put the affected person to a stage where he would have been had it not been for the order of the court. Principle of restitution is facet of actus curiae neminem gravabit, meaning act of court shall prejudice none. This principle of restitution is routinely applied in cases of unjust enrichment, unjust impoverishment, gained or suffered owing to an interim or final order, which are varied subsequently. It necessarily pertains to monetary gains of property, which is not even a fundamental right, whereas bail order, which is also an interim order, results in deprivation of liberty. When liberty, a right far greater and sacrosanct than right to property, is involved, then why shouldn't same principle of restitution apply? Another one that comes in the case of interim order is balance of convenience. In cases of interim orders, stay, injunction, etc., aspect of balance of convenience plays a pivotal role in consideration of court. Apart from prima facie case, irreparable harm, etc., are considered. Simply put, courts are duty bound to pass an order to avoid a situation which will become irreversible if it is not interfered with. When person is put in jail by refusing to restore his liberty, an irreversible situation is created for his days lost in confinement cannot be restored back. What courts do in dealing with the bail application, they either endorse suspension of right to liberty or revoke it by their interim orders. Supreme Court in cases while dealing with an interim order in consideration held that satisfaction that there is prima facie case by itself is not sufficient to grant injunction. Appearance by the court would result in irreparable injury to party seeking relief, and that there is no other remedy available to party except one, to grant injunction and hence protection from consequences of apprehended injury. In the cases of bail, it is always the accused who stands to suffer if his liberty is not restored. The comparative hardship that the accused will suffer by his incarceration is manifold. The last one that I would like to push today is principle of exception. It is by now not just well settled, but well recognized and practiced statutory principle that a party which seeks exception to the rule must make out its case for such exception. What could these exceptions be? Flight risk, endangering witnesses, tampering with evidences, committing another offense, etc. In Arnesh Kumar and followed thereafter in Satyendra Kumar Antil, it was directed that the magistrate, the police officer shall furnish to magistrate the facts, the reason, the conclusion. Those shall be perused by the magistrate while authorizing the detention, and only after recording his satisfaction in writing that magistrate will authorize detention of the accused. This is with respect to those tripod tests. That being so, when bail is rule and jail an exception, why should it be for an accused to file an application and seek release when it should be the other way around? Should it not be for the state to approach the court and obtain a positive order from the court of law, entitling it to injunct a person from temporarily exercising his fundamental right to liberty? In my opinion, those of the provisions of law which restrict power of the court in granting bail compel courts to cause prejudice to the person, whereas it is bound not to. It compels court to act against its own duty. These offending provisions, therefore, should be held invalid, for they require that fundamental right to liberty be kept suspended irrespective of final outcome. The resolution, therefore, to my mind is that court should refrain from doing something which cannot be undone. Time has come when court should hold that bail is rule, while imprisonment should only be in rarest of rare situation, pending trial or pending appeal. Thank you.
Thank you, Nihal, for that beautiful presentation. Courts should refrain from ordering which will lead to irreversible effects on the accused. I think we'll have more discussion on that. Now I request Sukanya Santa to speak on effects of long incarcerations under EAPA and PMLA.
Good afternoon, everyone. And thank you so much for having me, for inviting me to be a part of such an important discussion on liberties. While my fellow speakers are all legal experts and many of you in the audience are also experienced legal practitioners and scholars, I won't pretend to actually match your expertise on by dissecting UAPA and PMLA and the bail provisions. That's not my area of expertise. Instead, I will, from my experience of having been a journalist for close to a decade and a half, of having covered judiciary, of having covered social justice and human rights for this long, I will try to bring in from my experience of having interacted with people the human cost of these laws. I'll try to like how liberty crushing these laws are, and how like it's like trampling your human rights all under the guise of national security. So the beginning of my career actually coincides with the establishment of the National Investigation Agency, the NIA. And it's not that the UAPA did not exist in the books then, but it wasn't the sledgehammer that it is today. In 2008, it was soon after the 26th November 2008 blast, the terror blast case of Mumbai, when soon after that the NIA had actually been set up. And the then Home Minister P. Chidambaram had actually termed it as a necessity of an extraordinary times. This would sound familiar because that's how even POTA and TADA actually came into being. So among the first few cases that were actually handled by the NIA was the 2006 blast case of Malegaon. This is not the same case in which Pragya Singh Thakur is actually accused, who was a former BJP MP from Indore. This is the one before that. So in this case, I think around 38 people had actually died, and like over 100 people were injured very seriously in this case. The Maharashtra State's anti-terrorism squad was handling this case at that moment, and some 9 men, all Muslims from Malegaon, were picked up in this case, and they were actually sent to jail, and they were in jail for 5 years. Suddenly in 2011, when NIA had taken over this case, NIA realizes that all the men who were actually arrested in this case were wrongly implicated, and all the men were released on bail, and later like they were discharged. In 2016, they were finally discharged from the case. So I'm not talking about like some ancient history. I'm talking about something just a decade ago where NIA did that. So like just putting it in perspective, like in the beginning of NIA, this was possible that people were wrongly implicated, and where the agency was willing to take a responsibility of actually addressing wrongs done to individuals. So in the initial years of its inception, NIA only had one police station that was in Delhi. So NIA Delhi was the only unit that was actually taking care of all these cases. So you had not more than, like, say, 8 or 9 cases being registered in those initial years. Then the number of cases slowly went up. So from 8 to 9 cases, it became like 20 cases per year, then 30 cases. And now you have 50 to 60 cases of terror, of terror, like so-called terror cases are actually like being registered by the NIA. And like as on today, like there are some 617 cases that have been registered by the NIA. NIA now has 14 different like police stations. Like it's got its office in 14 different states, and so the courts are also situated in the respective state capitals wherever they have like set up their centers. So if you are actually arrested, say, in a remote part of any state, and you're like brought to another state, you will be moved to a prison of that state capital. So the NCRB data, which actually provides us data about number of people arrested, the type of cases they're arrested in, the prisoners, their social profile vis-a-vis their caste, their education, their literacy, their whether they're landed, they're not landed, all those details that you get in under the NCRB data doesn't provide any data on the social nature of people who are arrested under UAPA. But largely, if you look at like the people who end up in jail, you know like which community that they belong to. They belong to the SC, ST, OBC communities. Like over 70-75% of the representation of the prisoners like come from these communities, not just among the Hindus, but also like across religion. Even among the Muslims, if you see, the ones who actually get picked up in terror cases mostly invariably end up coming from Pasmanda communities. So these people who are actually arrested belong to the marginalized identities. They come from mostly unlettered families, like a family like where family members are not educated. And then once you are arrested, the entire onus, the entire burden is actually then on the family members to ensure that the funds are raised. They have to identify a decent lawyer. And now again, like if I am like somebody who is in a remote area of say Maharashtra, and I'm booked under UAPA and NI is actually handling this case, like the case will be taken to Mumbai. So the family member who's actually not traveled to the city, who doesn't really know exactly like what exactly city life would be like, has to there go find a lawyer, ensure like somebody is taking care of these cases. So like that individual is then like then suddenly like given this whole onus of like strategizing the freedom of the person who's facing trial. In cases where persons are actually arrested for their political convictions, popularly known as political prisoners, you still have a chance of getting a good lawyer in these cases. But in cases where an individual's act is not considered to be political enough, what happens then? Then finding a lawyer is like really, really hard. During my like research and like stories like I've traveled for extensively, I realized like especially in FICN cases, the counterfeit cases, you really do not really have people representing any of these persons, individuals who are actually booked under UAPA for in counterfeit cases. So when I was I've traveled to West Bengal very recently, Bihar, Jharkhand, Karnataka, Kerala, like and then I realized like in especially in counterfeit cases, it's invariably the legal aid lawyers who are actually taking care of these cases, and most often these cases actually end up in conviction. So like I said, like most of these cases are interstate cases where individuals from different states are like clubbed together and put in one case. Several hundred kilometers from the places that they actually come from. So many individuals that I have actually written about, that I have been interacting with, have also been booked under multiple cases. Especially if you see in cases pertaining to say ISIS or Indian Mujahideen, you would find that like an individual is booked under like 5, 6, 7, 8 cases, and those trials have not actually started in most of these cases, but they are ferried from one jail to another jail, from one state to another state. When you speak to the family members, and also in some cases, like even the lawyers, when you speak to them, you realize that the family is not even able to tell you like which particular jail they are at that moment. So that's the case of that's a helplessness with which like these cases that families are actually struggling and dealing with. Language is also a major problem. Like I realized that people who are like say from Kerala, like a couple of incarcerated persons who were like just recently out on bail, and I met them in Kerala like recently. They are from Coimbatore. They speak Tamil. They don't speak any other language, not even very little English. and they were booked in some case in Kerala. Like they were in Kochi for 6 years, and their bail condition is such that they have to like actually stay there. So I was interacting and trying to understand like what exactly do they understand, how much have they managed to understand of the cases. So one of the major problems that they were saying that we do not understand the language that has been spoken, like we have spoken with. We are unable to actually even make sense of the cases that has been slapped against us. For this, like I'll cite another example of a leader, like a young tribal rights leader, Hidme Markam. Like she is from Bastar in South Chhattisgarh. Hidme is a very young woman and belongs to the Gond tribe. She has been instrumental in actually exposing a series of human rights violations in the region. She has meticulously exposed the state for setting up illegal detention centers in Bastar. The cold-blooded murders of young Adivasi boys and girls that has been happening in this region for very long. Nandini also mentioned that like the recent score like number is like has gone up to like 400 now. Also the whole drama of fake surrender that has been actually going on in this region for a very long time. So she's somebody who is very equipped to understand and expose the state. Her ability, her strength of being able to do what she's doing is her ability to speak in the language that the local people, her people speak. That's the Gondi language. But that language also, like that is the only language she spoke. She did not speak any other language. She barely managed to speak, like understand some bit of Hindi. So the language that she actually was able to connect with her people so well, and she was like being a leader with of the community for so long, suddenly like actually worked in against her. It was like a disadvantage. So Hidme has also been like Hidme was booked in a I think over like some half a dozen cases. So she also was like 2 years ago she was out. Like she was finally acquitted of all the cases and she's out now. So I had an opportunity to meet her and like through some friends, like was able to like have some communication with her. And her problem was also the same, like as like not being able to understand what is the case that is actually, she knows that NIA has actually booked her and the state police has booked her under several, like there are several UAPA charges and like other state laws that have been actually slapped against her. But she doesn't know what exactly these cases mean. And here we're talking about somebody who's been fighting for rights of the people. It's not like somebody who doesn't know her own rights, who doesn't know like she doesn't actually fall in that category of being marginalized and somebody who is not able to fight for herself. Then there is like so Hidme, like yeah, Hidme finally has managed to come out because she managed to have a very good lawyer. But well, there are hundreds of Gond, Koya, Madia youths who are in jail and they don't really have the privilege of having like good lawyers appearing for them, and they continue to rot in jail. Another like language is another problem that I noticed is solitary confinement, and it's a staple of UAPA. Sudha Bharadwaj, who's one of the 16 persons to be implicated in the to be booked in the Elgar Parishad case. She writes in her book Fasi Yard very well. Like she actually like lays it bare very efficiently in that book. So again, like I happened to meet this very young 20-year-old boy, Alan Shoaib from Kerala, who was booked along with one of his friends, Twaha Fasil. Again, the same charges of being a Maoist. And he was just 20, he was studying law, like perhaps like most kids in this class, like from the same age, like and he was also aspiring to actually be a lawyer. He got picked up and then I think he endured a long stint of isolation. He was put in solitary confinement for a very long time. Alan now is on bail and he's continuing to study law. And very recently, he actually wrote this very poignant piece on solitary confinement. And he says that the torturous part of his stay in prison was not being able to tell what time it is, like not knowing the time of the day. Like, and that was the most torturous thing for him. It's been 4 years since he's out and it still haunts him. like last year, he actually tried to, he attempted suicide last year, and he survived, like, but he also in his letter, he writes about like how he has been pushed to the condition that he is in because of his, the state has pushed him in this condition. Now, solitary confinement also gets weaponized in a very different way. Like take the case of Kashmiris. So Kashmiris who are lodged in like jails of, in Indian jails, like in say, like in Delhi or maybe in other parts of North India, they face a potent threat to their lives. If you are actually put in a room full of men or women who would not actually subscribe to the thought that you have, and then especially the political like people who are actually arrested for their political views, they actually have this potent threat of being attacked, of getting attacked in prison, and these attacks are not uncommon. So like a bunch of prisoners in the past few years have actually moved an application before the court saying that we should be put in solitary confinement. But here, the jail officials actually come back and say like we don't do solitary. So like that's the way they actually use it in a different way for these prisoners. A few months ago, I actually had been to this remote part in Parbhani district in Marathwada region of Maharashtra. So years earlier, like a few years ago, like the NIA had actually come up with this big claim that a very sophisticated ISIS module is actually in work in rural parts of Maharashtra, especially in Parbhani, and a whole bunch of people were arrested in these cases, including one school teacher. I arrived months after two of them were released, including the teacher, and so I went to his place, and what struck me was this hulking TV screen that was dominating the house that he was living in. That house was otherwise simple. It was sparsely furnished, like there was barely any chairs or tables in that room. But there was this one big TV screen that was like actually set up in the house. That TV set was not something that the family would actually gather around and watch like their daily soap opera. Like that was not what they were doing. The TV screen was connected to the CCTVs that the family had set up inside and outside their houses. And these CCTVs were their only way of protecting themselves. So I could not like really make sense of like why exactly these CCTVs were actually put up. So I was intrigued, and I was like wondering like why, like somebody who's either like already been released on bail or who's been acquitted, why would they actually do something like this? And then I realized it's a very common practice among most people who have actually come out on bail, especially in UAPA cases and especially in terror cases, where they have set up these CCTVs in and outside their houses. So what is the reason? Like, why would you actually impose surveillance upon yourself? So it's very simple. Like for them, it's the dread of like sudden raids that are happening by the police, of evidence getting planted in their houses, of police picking up individuals from their homes and then later claiming that they were found like 100 kilometers away, participating or like plotting terror. So I actually went ahead interviewing, like I did write like a long piece on this, and like I interviewed a whole bunch of people to understand like the reasons behind such kind of such kind of like putting up CCTVs in the houses. So most of the individuals who have actually done this are traditional Muslim families, where women practice parda. Their children, their daughters are wear hijabs. But once the cameras are actually installed in their houses, like the houses which are like homes which are supposed to be this safe space where you can actually feel a little comfortable, you can let your hair down, and like you'd actually be like a little comfortable, no more remains that kind of space for them. The women remain cloaked top to bottom, like head to toe through the day. And the reason is like, should this TV footage ever become their husband's lifeline in the court, the dignity should remain intact. So like that's the kind of life that living. This practice of pushing oneself under self-imposed surveillance, not the one that is carried by the state. Like the state is finding different ways from like different kinds of malwares that are actually like put in your phones and like phone tapping. That's not what I'm talking about. I'm talking about the self-imposed surveillance that these guys are actually putting themselves through. It goes beyond the ambit of law. So yeah, like I'll just quickly just touch upon one more thing. Is so an average case, it actually drags on, like the UAPA cases like drags on for 5, 6, 7 years. And in one of the Supreme Court judgments in this K. Najib case, like it was highlighted that it's a troubling issue, and prolonged incarceration under the UAPA is a concern. Najib had actually like spent some 5.5 years, and the court had actually deemed it a potential violation of Article 21. And then like he was actually granted bail by the court. So, but in practice, this is it's not understood the way the Supreme Court actually tried explaining it. So in practice, like there's some unspoken benchmark that the lower courts have seemingly come up with, and they have pegged it as 5 years. So when Elgar Parishad, in the Elgar Parishad, there is this one person called Hani Babu, who is also a Delhi University professor. He has spent like some 4 years and 9 months in jail now. And he recently had moved the court, thinking that because 2 of his, like 2 more human rights defenders who are actually accused in that case got bail recently, Rona Wilson and Sudhir Davle. So they got bail on the basis of inordinate delay, and they have spent like some 6.5 years in jail. So he also moved the court, thinking that his case also would qualify for the same thing. So he was said that like, no, come after 5 years. So like this person has been in jail for 4 years, 9 months, and that is the understanding of the court. So while we are talking about UAPA, like all the speakers are actually like looking at all these stringent laws, there is something very important that is which I think like should be flagged, and I'll just like quickly speak about it. Is a bill that has been introduced recently in Maharashtra called the Maharashtra Special Public Security Bill 2024. It was tabled last year in the monsoon session, and it's currently in the stage of inviting suggestions and objections. This bill, the then the Deputy CM and now the Chief Minister of Maharashtra, Devendra Fadnavis, he claims that the law has been brought in to address the menace of Naxalism in urban areas. So all this while urban Naxal, the coinage which was used outside in public, outside the purview of law, like suddenly like is now going to be brought under the ambit of law. This draft has been like, it's along the lines of the Chhattisgarh Vishesh Jan Suraksha Adhiniyam and the Andhra Pradesh Public Security Act. These acts have already been extensively criticized, and it is used to target journalists, human rights defenders, environmental defenders, Adivasis, citizen activists, like it's and anyone who's dissenting. Like, so it's not that like we have not actually spoken about these existing laws. In fact, the constitutional challenge to there is a constitutional challenge to the Chhattisgarh Act actually that is pending in the Supreme Court. So yeah, like so. It's not UAPA alone, like that is an isolated weapon in the government's arsenal actually. It's not like it's no more like the only tool that the state has to actually curtail public the personal liberties of an individual. So from MCOCA to PMLA, like, and now like the looming Maharashtra public security bill. The state has found different ways of innovatively expanding their collection of draconian laws to just tighten its grip on the individual's freedom. Yeah, thank you.
Thank you, Sukanya, for bringing out the nature of the cases and also who are the real sufferers in this long incarceration. See, Hani Babu has not spent 5 years, therefore his case is not going to be taken up. In Telangana, there is a rule that unless a convict completes 5 years of his sentence, in life sentence, that case cannot be taken up for trial at all, cannot be taken up for appeal at all. There is a rule, a famous case, Nagarjuna versus State of AP. Even if court is not busy with appeal cases also, it won't take it up. what I understand from Sukanya's presentation is that what has become a principle in case of appeal of convicted prisoners is becoming a norm in case of even under trial prisoners in EAPA case. If somebody is granted after 5 years, should we feel happy that they are granted, or is it becoming a norm that before 5 years we are not going to be giving bail? This is a very bizarre, and this if accused is forcing to create self-surveillance to protect from the state, I think we need new kind of Orwells to write new kinds of story, because George Orwell has written about the nature of the surveillance that the state creates, but now we need a much more serious way of creative method. Thank you. Now I request Triji Nanda, has been a magistrate and has been a prisoners' rights activist before joining as a magistrate. He works in Koraput district in Orissa, and he already served in 3-4 places in the state of Orissa.
Thank you, sir. I also thank the organizing team for inviting a magistrate. Maybe this is unprecedented. I may have to check if it is the first time in 75 years. While it makes this house more inclusive and participatory, for me it's a privilege to be part of this and hearing the panel and even the earlier panels, including the first session. What I understood through the doctrinal evolution or the reiteration of it by the apex court, as beautifully narrated by the first speaker, Abhinav, and the case study based analysis of Advocate Nihal, that in fact illustrates the obsession of law, especially criminal law, on mind, because it locates the cause of crime in the mind. And because of that, it ignores the body completely, whether it's suffering or otherwise. And the replication of implementation of these laws as beyond the imagination of the later and spirit of law, as Sukanya illustrated it. While I am asked by the organizer to speak on the gap that exists between the promise of law and the realization of it, especially with respect to the cases that I deal with in the capacity of a magistrate, and these special enactments are beyond the jurisdiction. But so far as I understand, the paradox that highlighted by the previous speaker is aptly, fairly theorized by scholars like Giorgio Agamben in State of Exceptions, where which actually justify the coexistence of paradox in the form of doctrine of innocence, in the form of honors of proof, or in the form of jail as rule or bail as exception, that coexist together. But my question here is, if this paradox is limited to these special enactments, or it even extend to the general laws, or is it part of the criminal justice system, the idea of criminal justice system as a whole? And to understand this, let us, if you take the example of recently enacted BNS, Bharatiya Nyaya Sanhita, as the name or title suggests, that the earlier Indian Penal Code is replaced by BNS, and the penal is now replaced by Nyaya or justice. But the text of it do not align well with the title, in the sense that it prescribes more punishment for the existing offenses. It enhances the punishment. It creates new crime, or it over-criminalizes the behaviors, or rather adds new criminal behaviors into BNS. So how do you understand in such situation the replacement of penal with Nyaya? So I want to ask, for introspection, if now penal means justice, punishment is justice, or justice is punishment, vice versa. And, this is a law that was that came into force last year. And since a couple of years, we have been hearing the High Court and Supreme Court saying that mooting about opening the walls of prison, making for open jail. On the one hand, while the judiciary is advocating for opening the walls of prison, on the other hand, BNS aims at fortifying the prison to keep the inhabitants for longer period. So this paradox actually defines constitutionalism in Indian perspective, so far as personal liberty is concerned. It is different in a sense that while the history of constitutionalism that we know is mostly about a conflict with Supreme Court, where, as it is portrayed, the Parliament is jealous to grab more and more power to materialize or to translate the constitutional aspiration into reality. So far as the personal liberty is concerned, here Parliament is more about the apathy on the part of legislature, so far as the constitutional aspiration is concerned. Inaction, omission from the part of legislature, in the sense it has given preference to continuity of law over constitutionalization of colonial principles. While Article 368, 4 and 5, subclause 4 and 5 still stand as an insult to the very fundamental judgment of Indian judiciary that declares them unconstitutional. And despite more than 50 years after that, and so many amendments has been done in between, but the article still survives, the clause as it is there. So it shows on the one hand that the Parliament is still yet to come out of that colonial hangover of legislative sovereignty. On the other hand, we see that the experience of the working of the Constitution with respect to personal liberty. So far as if I divide the journey hitherto into 3 phases, into 3 quarters, beginning with the first quarter, which I will say that it's completely inaction, because while I must, before that, I must inform this house that the magistracy has a history of its own, and that predates the Constitution and even perhaps the court, the way we understand it. But, the magistracy at the end of the day is to enforce a particular order. And it was enforcing an order even before the Constitution came into force. As Abhinav was saying, that this deliberation around UAPA or special enactment is nothing new. If you see the history, even during the East India Company, this preventive detention laws empowered a magistrate, to put someone for life behind the bar, or to transport someone to a different place for the entire life by mere suspicion. So the evolution of this power until now is a journey that should be mapped independently. But here, with respect to personal liberty, when I want to ask another question, that when the object of substantive law or the penal philosophy of the substantive law is punishment, is penal, can we expect justice from the procedural law? Because as a student of law, we know the object of procedural law is to execute the intention of the substantive law. So it has its limitation. In this respect, when you see Bharatiya Nagarika Suraksha Sanhita, again recently enacted, it also gives an impression that instead of prosecuting the criminals, it talks about protecting the citizen. But again, as I said, the jurisprudential interpretation and the rules of construction that limits the role of procedural law, and given the punitive nature of BNS, even the BNSS, if you look into it, it provides for trial in absentia. How do I understand it as? It focuses more on the enforcing the order, more on the offense than the individual, although we call them citizen. So here I ask another question beyond the way we understand the inhabitants of prison. You know, I being an, if I can say so, chowkidar at the entry and exit gate of prison, okay, I see, or maybe I read the history on the walls of it in a different way. And from that perspective, I want to ask that how do we define prisoner? How do we look upon them? Are they still part of we the people? Do they also share sovereignty with others, or they subject to be treated, to be corrected? This question is important because in the first quarter of constitutionalism, the pre-colonial laws were kept intact so far as the duty of a magistrate is concerned. And what was that? That was like the judicial magistrate was part of the executive within the district. The district magistrate was an executive head, was also the head of police and judicial magistrate. So while the country became independent in 1947, or we had a constitution in 1950, the judicial magistrate became independent after the 1973 Criminal Procedure Code. Until then, it remained dependent. It was so the first quarter speaks more about the apathy. And in the second, I used to, when I've been a student of Mulli sir actually, I used to accuse him that, the academician failed to make the constitutional code understand what the constitution is for at least 3 decades. And thereafter, from the latter part of 1970s, beginning with Maneka Gandhi, when the court said that, it puts a restriction, or rather a rider in the power of legislature, that it can enact law, but the law must be just, fair and reasonable if it is depriving someone of his life or personal liberty. And this is the beginning of this journey where the Supreme Court started redefining what the meaning of personal liberty. And this, as mentioned by previous panel speakers, this includes the journey of speedy trial, Hussain Khatun, and other cases where the apparent inhuman treatment being subjected to the prisoners was attracted the attention after Maneka Gandhi new interpretation, and that were declared unconstitutional, that practices were banned. And because with respect to the dignity of the prisoners, where for the first time it was held that the prisoners are also part of we the people. Okay. And the third quarter that I believe began with 2000 is more about fixing accountability so far as the personal liberty, with respect to personal liberty is concerned. For example, in Joginder Singh, 1992, the Supreme Court said arrest shall not be done unless it is necessary. In 1997, in D.K. Basu case, Supreme Court, devised a mechanism to guide the use of discretion by the police officer while executing an arrest. Like he should have a badge, and he should have a uniform, and he should inform family members. These are all steps to guide the discretion of a police officer making an arrest. And the failure of Joginder Singh and D.K. Basu in practice led to the emergence of Anes Kumar, that not only guides the use of discretion, but also fix accountability, both on the police executing the arrest and the judicial magistrate remanding the accused to the judicial custody, unless it is backed by a reason. But the question that we must ask myself is, why, even after 10 years, not a single magistrate is made accountable for departmental action? Few police officers are made responsible for it. Also, this conference is about the review of cases in the last year. I want to bring into what I believe from the position that I hold and from where I see is, it is, it's not about helpless or hopeless situations. The constitutional history of India suggests that if you engage with it, then it can also, it can also make adultery unconstitutional, decriminalize adultery. It can also acknowledge the right of LGBT. And when I was saying that the case came through not UAPA, but PMLA. So it is all about our engagement with the institution of governance, including judicial institutions. And I believe the failure of this is lack of engagement. And there are one doctrinal part and another is practical aspect. Doctrinal part is, as a student of constitutional law, we know that the role of executive is limited to the mandate that legislative apathy. When there is continuity of colonial law instead of constitutionalizing it, when court says something, when there is legislative apathy, there is no plan of action for the executive. When legislatures make something, along with that flows funds, along with that flows resources. It gives a direction to the executive how to do it, a plan of action. But when there is legislative enactment, the executive is without any plan of action. So when a decision comes from the court, Supreme Court or High Court says something, because there is no defined plan of action to execute it. It's a judgment. In such situation, what is required is, rather the beauty of constitution is, amid the apathy or inaction, omission of legislature or excess by executive, the constitution provides even further mechanism, that is activism through court. And for example, okay, I will just, one more point that I will make. I just refer to one case that is of the year 2024 in the month of December, in which the Supreme Court in Satendra Until versus State of Satendra Until case has made a mechanism to ensure the implementation of directions in the Anesh Kumar and the series of cases in Satendra Until. And what is that mechanism? It has fixed a body at the district level headed by district judge, and it has also made a direction to have a body at the High Court level, a committee for the implementation of the direction of the Supreme Court. So it's an endeavor by the Supreme Court to make the implementation automatic, because a monthly report, as per the order of the court, monthly report is to be submitted, scrutiny is to be made at the district level, at the High Court level, then it is to be submitted to the Supreme Court level. So in my categorization of last three, quarter, the fourth quarter can be a quarter of realization, provided, beyond the traditional idea of court and advocacy, if all sort of people involved in this process actually participate in making or ensuring the accountability of stakeholders, because there is no dearth of law in that respect. Thank you.
Thank you, Trijib. The contingency plan of the judiciary may not work as much as if state really makes it a legislative edict. That's what he was trying to say. Thank you. I think no, we've overstretched a little bit. I think half an hour. Can we stretch for another 15 minutes? Yeah. One round of questions at least. The house is open for questions. First, all of them will take questions and then respond. Yeah, please. Can somebody give the mic, please?
Hi, am I audible?
Please say whom do you address, please? Any specific person you want to answer?
Yeah, hi, sir. So my question is to Trajib, sir, from this side of the house. You talked about Agamben and you talked about how the law is kind of receding in a sense, right, with legislative apathy, and how we're focusing less on the criminal, with provisions like in absentia trial. So do you think there's like a shift in the way in which, like, when scholars kind of theorize on criminal law or the law as a whole, they talk about how modern criminal law is more on policing the individual, right? Like how, in a very Foucauldian sense, we're kind of trying to, like our focus is on the individual, but now there's this kind of lawlessness in a sense, right? It's not like more law, but it's like kind of we're focusing on the crime and we're focusing less on rehabilitating or reforming the individual, right? So would you say then that this kind of is in line with, let's say, the dominant kind of right-wing Hindu rhetoric, where this like lawlessness also allows like extra legal forces and extra legal power to kind of assert themselves more strongly? And how would you kind of characterize the nature of criminal law in India right now?
No, I don't subscribe to the idea that that is lawless.
Trajib? Be crisp, short, ask your question straight away.
Hi. So my question is for Trajib sir and Advocate Nihal. My question essentially is at the level of the district judiciary, what is missing? Like, as Trajib sir already pointed out, for a meaningful engagement which sort of leads to better constitutional results on a doctrinal or practical level, the doctrine is pretty clear at this point. I mean, as a law student, I know that Umar Khalid should have been given bail by now. It's pretty clear, it's clear as the sky. So doctrinally, all sort of district magistrates, judges sitting in NIA appointed courts in Chhattisgarh and Odisha, what is going wrong with them that they are not able to understand the fact that bail is the rule? What is going wrong in national judicial academies or academies that you might have attended, that they're not able to understand that, okay, the doctrine is, but only because the stamp is of the NIA, there is an NIA counsel standing in my court, that I have to sort of resort to the jail option. So what is that missing link?
Okay, anyone else? Yeah.
Yeah, so I had just a follow-up to his question. So my question is addressed to Mr. Abhinav. So in the end, the question of bail, you repeatedly said that certain benches decide in favor of the victim, in favor of the accused, and certain benches grant bail, certain benches doesn't. In cases of UAP and PMLA, we have seen that certain benches of Supreme Court have not granted bail and have deferred to the executive's argument. So should this be seen as a deference to the executive's overreach? And if yes, then how better should be controlled? How better? Because you have practice. So how better? What more guidance is needed to the judge in the discretion's exercise?
Yeah. One more question, please. Yeah. Here. If there is time, we can go for a second round of questions.
Hi, am I audible? This is a question specifically to what Abhinav sir said about how to make the process more enforceable. We shouldn't go towards constitutionalizing certain aspects of the process. My question is just that, we're taught to take into values of the constitution in every process, especially constitutional law, but even outside that. And something that's at the core of the whole bail process is how we place the dignity of the individual and the liberty of that individual, as opposed to making, because a crime is committed against the society. So is there a way that you can keep the right enforceable, but also balance this? Because this you trace back to the Constitution.
Yeah. Trajib, you can answer.
Lawlessness and focus on individual instead of an order, and amid the legislative apathy. What I believe is even amid a legislative apathy and executive access, there is still scope within the scheme of our constitution to realize the constitutional promises first. Secondly, as I was pointing out, this magistracy has a history of its own, in the sense, for example, if I'm not traveled to that, its etymological origin in Roman law, which is quite akin to, you know, the Sanskrit Pandit Wala or mythology or real, whatever it is. But with respect to the colonial origin of magistracy, you see what kind of order they were supposed to, and they were enforcing. They were enforcing Criminal Tribe Act. They were enforcing the law that makes, that's even travels beyond Lombroso, you know, the criminal tribe that makes people by birth criminal. They were enforcing the Forest Act that made indigenous homeless. They were enforcing Permanent Settlement Act that made wandering sovereign bonded labor. So what kind of order they were enforcing? And in that, you know, there was no discretion back then also. You were bound, the only accountability is for a magistrate is not enforcement. The enforcement was the rule. So when we inherited this colonial legacy, in the role of a magistrate, as I was pointing out that until 1974, no change was made with respect to its modus operandi. And even now, you know, that, for example, when we read doctrine of the widely accepted doctrine of innocence, doctrine of ignorance, you know, that ignorance of law is not an. And along with that, if you read Section 12 of the Legal Services Act, and the category of it, you will find that more than 95% of people are in need of legal aid in India, legal aid and awareness. And for example, when just assume the teacher coming to your school and 90% of the students do not know the language he speaks. You know, that is how court functions at the ground level, because more than 90% people do not understand the procedures, do not understand the code of the content of law. Even beyond that, for example, by default, this national university makes other local, you know, but those local universities, those local institutions produce the advocates who actually argue in the court what they learn, what is the source of their learning, what is the depth of their syllabus, how many law colleges are equipped with resources, facilities, so that they can understand these constitutional aspirations and they can argue it in the court and help people in realizing it. More than that, what I believe is that preconceived notions of representing a subject in the pre-constitutional is still prevalent, and even the advocate level, they are yet to realize that they are representing a sovereign, not the subject.
Thank you. Yeah, please.
Am I audible?
Yeah. So I think that the underlying theme that I felt was coming in three sort of questions that came my way was broadly on discretion and the exercise of judicial discretion when it comes to bail. And I'm enamored by the enthusiasm of the young gentleman who put that first question as to it is clear to all of us, then well, why is it not clear to someone? And I would really encourage you to go read Oliver Twist and that famous line about Mr. Bumble and the law being something. But that aside, that I think number one, to answer you, that is a problem, right? So the law, actually, it is not that clear because the law says that it is not clear. The law says that you have to assume that the material that is fronted by the prosecution has to be accepted almost without a demurrer. That may be whatever is a statement not recorded under oaths, that may be not tested, not supposed to be tested, and that is what the law is, right? So which is why the situation is what the situation is. In terms of judicial discretion, I think the problem is that fettering judicial discretion has got us where we are when it comes to things like UAPA and PMLA, and thinking about, you know, constitutional avenues for judicial discretion, as the lady had put the question in the last, has sort of put us here. But that doesn't stop us from coming out with a better exercise. If you were to read the judgment in Satinder Kumar until the last of the series of judgments that the division bench of the Supreme Court had passed, they reiterated the need that maybe India should revisit the idea of having a law on bail. Parliament has since said that that idea has been shelved with the passing of the BNSS. I think an exercise like that has never been out of fashion. It's really ununderstandable or rather unintelligible as to what is the problem there. Because if you were to consider some other countries that have sort of been on a similar journey where they've had that common law approach to bail and have sort of moved away from it, right? So this approach to bail that looks at merits to decide, it's a common law approach to bail. That's how common law defined things in like the evolution from, let's say, even the 13th century onwards. There has been the idea that for some offenses you shall never get bail. Like treason was, well, you're never going to come out, right? That was the law. There is an evolution. So in that evolution today, the idea is that there ought to be certain parameters on which that decision is made, plain and simple, so that there is consistency, there is enforceability, and there is also respect for the other values that are part of the system. That ought not to be confined to the black box of discretion and the idea that judges will exercise judicial discretion judiciously. That's just circuitous reasoning, right? So I think the way forward, whenever that way shows us, would be a bail act or a legislation that sort of implements the law as straightforwardly as possible. Just 30 seconds to say why that's not going to happen anytime soon is because you are stuck in a system that has 2.5 crore cases pending or whatever number that may be, where like far imagined sort of oasis, they're like a mirage that no one ever sees the conclusion of the trial, which makes bail that much more important and the merits and the accusation that much more important. Because everyone in the system knows that whatever might be the final conclusion, that is going to happen when all of us are dead, which is why whatever has to happen now gets so much more. So I think it's a very it's a problem that is bundled up like a ball of yarn, and we have to slowly start untangling it. And it's not going to be a solution that comes by just passing the Bail Act in absence of doing all the other things. So yeah.
Okay, thank you.
There was this one question, what is missing in district judiciary?
Yeah.
One word answer is spine. And thanks. And then apart from what is missing, I think what is affecting is also an important question. Because I've seen those trial court judges who are very courageous, who are very daredevil, and who dare to call spade a spade. What also affects is extraneous consideration, how the case is perceived by people, how it is projected in media, how they create devil out of that person and make it really difficult for the judge to exercise their discretion. Also, third thing that has happened is over a period of time, our district judiciary has been in a way demoralized by high courts and Supreme Courts. If I'm to give an example, there was this judgment of Zahur Watali, authored by Justice Mughlidhar in Delhi High Court. And as the jurisprudence stood then, it was perfectly fine for courts to look into admissibility of evidence if they are to give prima facie opinion about a case. But then Supreme Court overturned it and put it in such a way that as on today in UAPA, to my mind, it is easier to go for discharge than bail. So that has also happened. Secondly, second instance, if I may point out, there was this Bhima Koregaon case, and we were on default bail. 180 days had gone by, and there was no valid sanction, etc. And Hitendra Vishnu Thakur, Sanjay Dutt, all these judgments held the field. And a very beautiful judgment came from single bench of Bombay High Court. And that was overturned. That is overturned, and the jurisprudence on default bail has been diluted to such an extent that it can be played with in any ways with respect to special statutes. And also, we must not lose sight of the instance with respect to Sai Baba's case, where he managed to get acquittal in the first round, or say discharge, to put it more precisely. But on a Saturday hearing, on a holiday hearing, it was stayed. So, and then what happened with the judge who authored the judgment is also something that you should search for. An excellent judge, I must say. And it was really a marvelous piece of judgment on sanction and what it means to be there to have sanctioned what law it is. Sadly, that man had to resign. A very intelligent person, very bold, brave judge had to resign. So this is the way things have gone by. So therefore, the answer is a little longer. But missing, of course, spine. Secondly, added these factors, and then, of course, there are judges who are biased also. No denial of that. So that's it.
Yeah, on the request of organizers, I think now we can take 3 more questions. It seems there are some questions, so very quickly, crisply. Please, yeah. Somebody is raising hand there. Please give the-
So my question is for Mr. Sekhri and Mr. Rathod both. During the panel, we discussed how under the UAPA, it's possible for the judges to deny bail simply when there's reasonable grounds to believe that the charges against the accused are prima facie true. And Mr. Rathod, as part of his presentation, when he was talking about Sai Baba's ordeal, he spoke about how he was arrested because of possession of Maoist content. And that is also something that Ms. Sukanya spoke about, how multiple cases are about the possession of Maoist content. So how exactly does the court draw this link between the possession of Maoist content and the act of terrorism, which is what the UAPA focuses on? So could you perhaps elaborate on what can only be called as an exercise in legal gymnastics that the court does to reach this conclusion?
In fact, sorry.
Yeah. So this question is also to Mr. Rathod. I think probably Secretary can also add a perspective. So Mr. Secretary spoke of how law, the threshold in the trial courts is usually very low to imprison people. And you also spoke about how it is important to protect constitutional liberties largely. So the question is, based on your experience as a human rights lawyer, how do you think we should balance these considerations against, in the current usual political climate where national security is the most cited concern? Like essentially any criticism is also seen very suspiciously when you bring it to court. So how do you navigate these tensions as a human rights lawyer, or what perspective do you think is important in terms of how do you balance this national security and individual right to liberty? Because this concern is quite always the one which is put forward, especially in the light of how Mr. Secretary said, like the threshold is quite low.
No.
Hello, am I audible?
Yeah.
So my question is like, when I see this whole procedure and everything, I trace it back to the fact that our constitution included procedure established by law rather than due process of law. So, and after that, we moved away from the Maneka Gandhi and everything. We moved away to due process of law again. The original intent was left aside and we moved to more of a human rights perspective wherein the rights were given more importance. With the PNSS particularly, a change was brought in where bail could be denied if the offense could be linked to some organized crime or issues of national security. Again, nowhere defined. So this judicial discretion and also the series of jurisprudence as we are seeing and the laws which are being passed, are we again moving forward, moving back to the thing of procedure established by law, or what is it like? How do we balance it with that?
Yeah, quickly.
So that first question with respect to how do we deal with that accusation of terrorism in comparison to possession of literature, etc. Long back, Bombay High Court had delivered a judgment on UAPA Jyoti Chorgej matter, single judge bench judgment. And it has very beautifully interpreted the UAPA. And importantly, it has examined the provisions of law from point of view of section 15, which necessarily deals with terrorist act. And then it shows how every other offense in that act, particularly under chapter 4 and 6, is necessarily connected with the terrorist act. So now the interpretation that stands as on today, to which Delhi High Court differs, is that for invoking UAPA or any provisions under UAPA, there has to be a terrorist act which has been committed. And then those other parts of it, that is being member of the terrorist organization which was indulged in a terrorist act, or to be a member simpliciter, all those then can be seen provided there has been a terrorist act. Now, same thing has happened in Sai Baba's case, where there was no even, not even allegation of any offense under 15 or 16. And then the duty that fell on the court was to look into the documents, look into the videos, look into other evidences, and say that this does not constitute any offense, so as to bring him within the parameters of UAPA. Then Supreme Court in case of Vernon Twaha Fazal has also underscored this interpretation given by Bombay High Court. So that's how UAPA is seen. It is, as I said, it is easier to get discharge in UAPA case, easier to get acquittal in UAPA case, but very difficult to get bail. And the idea is that only, to keep these people in jail for as long time as possible. As I mentioned, one name, Surendra Gadling. Surendra Gadling was known as, and still known as, one of the expert of security legislations. He's handled cases of Tada, Pota, and he was again considered as master of UAPA also. And he came to be arrested just before he was going to argue suspension for Sai Baba. And it's been more than 6.5 years that he's in jail. He's awaiting even compliance of 207. So framing of charges and things are different. So that's what the basic idea of UAPA is. Second, that was how do we balance the issues? See, particularly in UAPA, there is a presumption clause given that if someone is found with arms and ammunition committing some terror act, then there is presumption of guilt. And in such cases, if you are holding that person back in the prison, I understand that could be done. There are other ways like that is being done in other countries where for the purposes of granting bail, they are put to condition that they will wear their whatever you call trackers, ankle bracelets, or there are other conditions. But what we are doing in our country is that whenever bails are given, it is ensured that most of the cases that I see is that that person is put to condition that he will not tamper with the evidences, he will not influence witnesses. And if he does that, that is considered as a supervening circumstance and he is sent back to jail. So whatever current mechanism that we have, if is interpreted and enforced properly, that is sufficient to my understanding. And therefore, the law itself takes care of this balancing methods.
Very, very quickly, I think the question of literature, I think that's been sufficiently answered. I think when it comes to the other question on national security, I think the young man actually has, that's probably the hardest thing, because all things said and done, it is the most unenviable position to be in that position as a judge, and I'm not saying as a lawyer, to be the one who is making a decision where ultimately you are going to not only be pilloried by the state, you're going to be pilloried everywhere, that you've left this so-called dreaded person, because frankly, no one knows, right? So, and the matters of national security are such that you will always defer to the intent or rather the material that the executive presents. And there's so much to it. In all of these UAPA matters, there'll be protected witnesses that are brought, documents are redacted. There's that overarching sense that is built that, you know, these are grave matters. So that gravity is, you're never allowed to leave it behind. And that really is the hardest sort of balance. And most often, frankly, you lose that balance at the lower courts, which is why it takes, let's say, a Supreme Court of India with all the might that it bears behind itself as an institution to front up to that material and then be able to look at it and call it out for whatever it may or may not be. I think that's why there is something to be said there. In respect of procedure established by law and due process of law, I think more is made of it than what our history books show. To be honest, seeing what was the process going, coming back. And I think it's a larger sort of strain of the Republic as such. So I don't think it's a question of just due process procedure established by law, but I think it's a question of political currents and how the law is always tethered to politics in that sense. So yeah, that would be my answer.
Yeah, see, gravity of the crime is not just the beginning of incarceration of the prisoner. Even after 20 years of incarceration, even for rehabilitation are also, they are trying to think about only the gravity as the sole criteria. What kind of rehabilitation has to be given. Therefore, we begin with gravity and end with gravity. I think that is what
I just want to make one point that while our discussion is actually confined to our country only, if you see the global perspective and you can divide the countries into colonizer and colonized, then you see that while the colonizer have actually transformed radically from what they were and the laws they made in the colonized country are still there. So it is more about the participation of citizen in the process of governance that I believe is more important and makes the difference.
Okay. Thank you. Thank you very much for all the participants and for the wonderful panel here. Thank you, one and all. Thank you. We don't want to delay further.
Hello, guys. The next panel will be starting at 4:45, so please come back.
Rakshita ma'am, am I audible?
Hi. Yes. Yes, you are.
Okay, ma'am. Ma'am, we will start with the panel at 4:45. So if you could turn on your video then.
All right. Sure. Sure.
Okay, ma'am. Thank you.
Thank you.
Hello, everyone. Welcome to today's last panel on secularism. So we'll be broadly talking about the idea, its brief history, and the present. Before I introduce the topic briefly, I'll introduce our panel for today's discussion. We have Professor Gurpreet Mahajan, former professor, Center for Political Studies, JNU. Then we have Professor Gitanjali Srikantan, Associate Professor of Law, BITS Law School. We also have Advocate Veena Gowda, women's rights lawyer based in Mumbai. And then we have Rakshita Goyal joining us online. She's a senior resident fellow with the Vidhi Center for Legal Policy. It would not be wrong to state that the story of India's freedom struggle is partly a story of secularism. For the many actors taking part in the struggle, the object was to reach a common destination of founding a society based on the principles of equality, fraternity, and liberty. When, for example, Pandit Jawaharlal Nehru was writing The Discovery of India, the vision was to ensure the formation of secularism as a core value of the envisioned democratic republic. For Maulana Azad, as for other Muslim intellectuals from the Congress party, the secularity of national culture was as significant as religious autonomy. The insistence was on, as Amar Sohal put it decades later in his book, The Muslim Secular, I quote, the creation of a theological truce between Hinduism and Islam, which concurrently upheld the distinct integrities of these two religions. For men coming from the peripheries, like Sheikh Muhammad Abdullah and Khan Abdul Ghaffar Khan, the refusal to completely secularize their Kashmiri and Pashtun nations also meant vociferous support for secular nationalism for all of India. The poet-philosopher Muhammad Iqbal was the major interlocutor in this interaction. To him, the unification of the Islamic ethic was the utmost priority and was predicated on uniting the Muslim regions of the Northwest into a self-governing, centralized province while still being part of India. Secularism came to be debated extensively in the Constituent Assembly later and was to form one of the core governing principles of the post-colonial nation-state of India. This time, however, it was the direct involvement of citizens and the various groups of citizens shaping the destiny of the country. Cases like Shah Banu and the Triple Talaq judgment, apart from other cases involving Muslim litigants mostly, marked watershed moments in India's secular courts, while at the same time leading to a theoretical decline. Personal laws, group rights, assimilation of groups and unity as an idealized concept that rather divides continue to shape India's secular polity today. To continue the discussion and take forward this debate on secularism and to inform us on the jurisprudence of the Supreme Court vis-a-vis secularism, I invite Professor Gurpreet Mahajan to the discussion.
Thank you very much for this invitation. I'm delighted to be here. We've had one very immersive session, immersive in terms of the nature of law as well as the practice, the actual practice of law. And after that very intense session, I'm going to perhaps begin by saying, as you know by now, I'm a student of political philosophy. I'm not I'm not from the legal profession, and I've never studied law. So my entry into this really comes from a slightly different point of view, and I'm not going to go, it's a vast subject, as Arif has just highlighted in his introductory note, that you could begin talking about the idea of secularism prior to the Constitution, in the Constitution, and its journey afterwards. But I'm not going to do that. I thought I'd do something more limited and begin with a question, namely, because about secularism and the courts, and the Supreme Court in particular. I'm asking this question, beginning with this question, because the Supreme Court has had a very important role in making this a very central principle of the Indian Constitution, whether it is the earlier judgment about basic structure or subsequently more recently, when the issue of the preamble of the Constitution came up and they dismissed the petition seeking a review of the term socialist and secular. So if we look at this idea that Supreme Court continuously reiterates the fact that secularism is one of the central values and principles of the Indian Constitution, my question really is, what does secularism imply? How do the courts look at this idea of secularism? Please say, when I say courts, I just mean Supreme Court, and that also, I'm not making a distinction between minority judgments and majority judgments, but generally statements and issues that come up and how they deal with them, and try to decipher more of a puzzle and some reflection on that puzzle. What is it that they have in mind when they talk about secularism? I think you get a variety of different ideas from the judgments of the court. The most expansive idea really is there in terms of saying secularism implies that there should be no reference to any identity, religious or caste identity. These are the two they take up most of the time. And this is a way of saying it is a classical liberal position, saying that, look, there should be, as it were, an idea that identities don't matter when it comes to the law, it comes to the practice of the state. So you have these very strong, bold statements, whether it is the Bhomai case or subsequent Indira Sawhney case. Repeatedly, they are saying that we want a society, we want to have a society in which there is absolutely no reference to any kind of identity. It gets repeated even more recently in the hijab case when it comes up. One of the judges actually says that if everyone is to wear a token of their identity, then how would we really think in terms of an integrated society? So they associate. So this is an underlying trend, one kind of trend that comes up over and over again, where secularism seems to imply erasure of identity, which is primarily religious identity and caste identity. Then within this larger notion, because this is the widest possible notion of secularism we can possibly have, you have a sub-strain where reference is not to the erasure of religious identity, but to no reference to caste identity. This is another kind of subset of this that comes up. Religion comes up occasionally, and the strongest statement we have is, during the Bhomai case, where it said that it is a constitutional duty of the government to wean political parties away and direct them towards something called secularism. But we don't know what that secularism implies or whatever. But the overall tenor is this, where they are saying, look, we don't want any reference to identity. So let's think in terms of erasure of identity that should be there. This, as I said, is the widest, most expansive notion of secularism. And it is a difficult idea to sustain beyond a certain time. And you have now more recently, and I'm just quoting the more recent one, where the previous Chief Justice of India would say that, look, ours is not a country where you were thinking in terms of complete separation of state and religion. And this he talks about when it comes to, again, religious instruction and religious education, etc., that markers of religious identity can exist and it is okay to live with them. And that does not in any way take away from the idea of secularism. This, I think, is the second kind of idea of secularism that we find, that it's not about completely doing away with your or indifference to religion and caste, but your personal identity comes in. Personally, I think there is some merit in this statement that is made, though not always consistently, because if you look at the Constituent Assembly debates, there is continuously this two underlying ideas. One which is espoused by Rajendra Prasad, amongst many others, who would say that religion is a source of moral law and you have to have a society which is guided by some not just law per se, which is legally defined, but by a moral law, which actually constrains the actions of people who are actually implementing the law and so on and so forth, or enunciating the law. And the other strain really is to say that, look, your identity is a part of who you are. Your religious identity is a part of your personal identity. And a stronger statement would be that it really defines expressions of your identity are closely linked with notions of human dignity. And I think both these currents are there in the Constituent Assembly. They don't come up clearly in the court's judgment subsequently, but they get manifested in this idea that you cannot really efface religious identities completely. So you have a second idea or a third idea of secularism. I'm putting the religion and caste erasure in terms of one single idea, where you are being indifferent to identities, and another idea of secularism, which the Supreme Court would come up with, which is talking much more of a limited idea of secularism, where you are thinking in terms of building a society in which you recognize the presence of religious identities, but nevertheless, you want to say something in terms of what would, I'm using the term, what would imply non-discrimination on grounds of religion. Again, this is a phrase which doesn't come up in the court's practice, but they do translate this idea of secularism in terms of two principles. One is religious freedom, and the other is neutrality towards religions, tolerance. But these are the three linking ideas that what would religious non-discrimination really imply? And they tell us it would imply, A, of course, thinking in terms of religious freedom, thinking in terms of neutrality, and third, as I said, tolerance. You can see each of these terms are extremely difficult and problematic. And we'll see, again, they are subject to a variety of different interpretations. And one can ask, has there been a shift in thinking about these elements over a period of time? I wanted to leave you at, and I'll return to it towards the end, that one way, at least the one I favor most, when I'm sort of not dabbling with law, is to think of secularism in a more limited sense as non-discrimination on religious grounds. So religious non-discrimination, I'm going to use this phrase over and over again, partly because even if you look at, because when we are thinking in terms of a concept or a value, you are thinking of ideas which get associated with it here in our country, not more specifically, but also more widely. Even in the United States, which worked with a completely different idea of secularism, where there was a rigid, supposedly a rigid wall of separation, eventually the courts had to face this issue, which is to take up the idea whether strict separation leads to discrimination of some group. So the question for them always was, if you look at the case histories, is in terms of who is being discriminated and what is the site of discrimination. Initially, when it comes to the wall of separation, it would be said, and the issue would be simple things like the fact that religious groups will not be given town halls to hold their meetings, while all other associations could do that. So religious groups felt and went to the court to say that they are discriminated, they are disadvantaged. Let's say not discriminated, disadvantaged. And to remedy that, they will say we have to make this wall a little more porous and more fluid, so that they can also have a presence in the public domain. And eventually this leads through various successive legislations into saying that, look, we will also allow some religious instruction in schools. But this will be what was called a time release period. That is, there will be a time, 1 hour off, let's just put it away from it. And parents can decide if their child should go for some religious education and which religious education of the denominations that the school is providing. This is a choice that is given. But then a case comes up, and now you have a completely different story. Earlier, religious groups are saying that they are disadvantaged, and now non-believers, which is atheists, would complain that this is what is discriminating them. And it's a very interesting case of a young child who is left free for an hour while all the rest of the class is going to some denominational teaching or the other. And he finds that he finds his life very dull, and they're very excited because that person is telling them all kinds of interesting stories and journeys and artifacts, etc. So he insists and wants to join a class of instruction, religious instruction. Parents don't want it. Parents go to the court. The court decides in their favor that this constitutes infringement of their liberty. They don't want the child to have, so this should not be allowed. This should not be permitted. I'm just saying that this idea of religious non-discrimination is something which we need to think about and hold on to when we are talking about secularism, because we forget about it, and most often it is in terms of the distance between state and religion. Separation, complete separation, incomplete separation, whatever that might be. Now coming back to India, where I think the courts have stayed with this idea, even when they say India has a different idea of secularism, they have somehow stayed with this idea that there has to be separation, some degree of separation between religion and state. And one way in which they think in terms of doing it, in terms of saying, let us look at how religious freedom is being defended in our country. So secularism becomes a way of saying we will defend religious freedom against incursions by the state. But again, this is a big question mark because, as you know, the Constitution does allow the state to intervene in religious matters, though it says that it will initially, of course, the statement is that it will interfere in secular aspects of religious institutions, not in the religious life of religious practices of religious institutions. And if I take that proposition and I find in the 50s, 60s, even 70s perhaps, the idea is that we will try, they allow state intervention, and all the cases that come up, really most of the cases come up about the, as you know, much talked about institution again these days over the last 10 or 15 years, is the Commissioner for Hindu Trusts. So the Hindu Commissioner for Religious Trusts and so on and so forth. So the courts, what they do is find in, because you have to, in all judgments, you strike a balance between competing values. And they strike this balance, it seems to me, in terms of religious freedom, like saying that, yes, such an appointment can be made, but that person is only to regulate the secular aspects, which means keep the accounts, see to the general management. They take up cases like disputes over the sale of land or whether there has been some inappropriate ways of by the trust that they have sold the land. But when it comes to what should the trust do, what should we be doing with the money that the trust has, they will say no deviation from the original intent. An interesting case that comes up is about, can this money of the trust be used to build some facilities for the pilgrims, which would also facilitate some religious activity and religious practice, and they don't agree with it. They say, no, the original intent of giving a feast to one particular group or caste should be upheld. So this is the way they interpret religious freedom. Another very striking case is, of course, when it comes up in terms of Dalit community. And this balance they strike is, you cannot restrict them from entering the temple, but how is freedom of religion to be protected? It is to be protected by saying exactly who will conduct the ceremony, where some people will stand, who is allowed into the main sanctum sanctorum. These are things which are matters of religion, not of state intervention. And they lay down all kinds of rules and regulations about what you can do, cannot do. But this is just a stark example of the way religious freedom was being defined in terms of incursions by the state, by and large, even against the Dalit community. Now you can see, I need hardly say very much more, that since about the 90s, you find this idea of religious freedom being interpreted in terms of religious freedom, not against state incursions, vis-a-vis the value of equality. And how do you balance the two? So whether it is the cases involving who is eligible to be a priest, and whether the norms, which are obviously exclusionary, be continued, or should it be treated as a matter of religion for them to decide? And again, the entry of women to Sabrimala, this is again the big issue. Is this a religious matter or not? And I think there is a change here that we can see. And of course, when both the judgments came, and many of us were very happy and delighted because one favors equality over many things. But when you sit back and see what it has allowed one to do is to say that matters of even what was called practices related to religion are now open for external intervention. So it's an enabling provision which is actually put in place by the Supreme Court because they favor equality. But in favoring this, what has happened is that if your judiciary can intervene, but so can legislature, because state must be seen as comprising of all these three units. External intervention into this is permissible. And you will have a discussion on Uniform Civil Code, which is anyway in the directive principles. So I'm just saying that these judgments in balancing this create all kinds of issues which we need to think about. Because the alternative would have been really to think in terms of pushing and communities into making these kinds of changes. Are there ways? Have we failed? Have communities failed? And this is why this is needed. But at this point, not getting into it, just leave you with this thought that there are these kinds of issues that have come up, because of which then you have a whole new range of other issues, and whether they can be challenged or can't be challenged, and so on and so forth. Let's look at the other. Just tap when I'm running out of time. Oh gosh. Okay. Religious neutrality. What can one say? Religious neutrality, and how do you really think in terms of what is neutral and fair? Particularly, as you know, since the courts will interpret not only what is an essential practice, or what they now call an integral, a practice integral to religion. This is the term that they use now. But they will also decide whether you are a separate sect or you are part of the same religion. So these are not matters in which you can be neutral. And I know this is going to come up in the subsequent presentations, that this is where they will operate with an idea of what constitutes a religious community and what are its core tenets, because of which all these come together or come separately. Couple of last things very quickly. If you look at completely different cases involving, the panchayat, in many states, the panchayat made the rule that 2 children, anyone having more than 2 children, not eligible to contest. And one of the things that the Supreme Court actually says at this time is they interpret this as, because the petitioner is a Muslim, as polygamy is not an integral practice of this religion. I may agree. It is not, or I may disagree, that's not the issue. But surely, this was not a matter of religious practice. It could well have been brought in under the fact that, look, we could have actually said that you're not the only, you could reject his petition by saying you're not the only community that is affected. There are many others who also have more than 2 children. Or you could support by giving the argument that you don't apply this rule at higher levels, while the lower level, the panchayats, where there should be mass participation, you're making very prohibitive rules and regulation. But it doesn't treat this as a matter of religion. And one needs to begin to think, how are they thinking in terms of neutrality? And now, of course, there is all these ideas about positive secularism. And the newest one, of course, is to make a distinction between religion and culture. All these things that we do, which we could have happily said are part of religious practice, and we could have, and that's how it was framed, that we bring many different religions and multi-faith prayers and ceremonies would be held. Now we would say that all these practices are only matters of culture. So you can, break coconuts and light lamps and call it culture, rather than have multi-faith ceremonies, which used to be the case. So this is how, no time. Secularism has been defined, redefined, leaving us with more puzzles. But if I have come back in the thing, we'll talk about non-discrimination as a value.
Thank you, Professor Mahajan, for this really excellent talk on secularism. I mean, you problematized the whole idea, secularism as non-discrimination, for example, the principle of non-discrimination, that should be looked at, because the Supreme Court jurisprudence has created a host of issues that are not really being addressed. And instead of addressing those issues, we end up creating a number of problems. So to carry forward this discussion, we have Professor Gitanjali, who will broadly talk about religion and the Constitution of India.
Thank you very much. I'd like to thank the organizers for calling me. This is my first visit to Nalsar and my first visit to Hyderabad. I'm very happy to speak at this conference. I was asked to speak about religion and the Constitution. I just want to talk a bit about my background. Although I'm trained as a lawyer, I primarily consider myself a historian of law, and that's been my field and specialization. And in my presentation today, I will try to link up the present with the past to show how some of our problems about secularism, about defining what is religious and what is secular, and the kinds of problems that have come up in the Supreme Court are due to certain other kinds of legacies as to how we think about religion, how we define it, and how we primarily define religious communities. So I'll be reading out my presentation. Right. So disputes with respect to places of worship have multiplied in India, along with attempts to actively change the character and function of certain shrines. These include legislative attempts like the Waqf Amendment Bill, as well as other petitions to strike down the Places of Worship Act of 1991, which have now resulted in the Supreme Court forming a special bench. This brings us to the question of the definition of religion itself, which is a long-standing irritant in the relationship between state and religious communities. A state neutrality becomes difficult to implement if there is no clear definition of religion. As all students of constitutional law know, the key case involving the definition of religion is the Shirur Math case, which I think Professor Mahajan also briefly referenced. And this case addressed the rights of a religious institution to manage its own affairs in the context of expenditure on rituals, festivals, and other activities ancillary to the same without interference from the government. And what was held in this case is that there has to be a demarcation, and that the head of the Math, he had the right to perform various activities that were essential to these institution in the context of festivals or feeding activities, feeding people from a particular caste, etc. This led to a test called the Essential Practices Test. And this test has evolved, and there was a transition from the conception of essential practices as practices that are essentially religious, that these practices are religious and they should be separated from practices which are not religious, to what is essential to the religion itself. So this marks evolution in the constitutional doctrine. There's been a lot of ink and blood that has been spilled over the Essential Practices Test. What I want to argue is that none of this deals with the definition of religion itself as to what makes a religious community Hindu or Muslim or Christian. What are the kinds of factors we use to define a religious community? And I'd argue that the current imbroglio around places of worship, the growing majoritarianism and erosion of the rights of minorities is due to an understanding of religion being defined as a set of doctrines, which leads to the conception of communal conflict, that there are two religious communities in India that are irreconcilably opposed to each other. This is a very colonial conception. And the colonizers had the idea that there were these two communities and that they were locked in conflict, and India could not improve, and India had to be colonized because of communal conflict. In the post-colonial context, there's a reification of these communities through a secular language of social reform. The key case with respect to the definition of religion, this is particularly in relation to Hinduism, was addressed in the Shastri Yagnapurushdas case. In this case, there was a sect called the Swaminarayan sect who claimed to be distinct from Hindus. And they claimed that they could not let other Hindus, including people from lower castes, to enter their temples. This case began as an objection to the Bombay Harijan Temple Act, which resulted in a civil court ruling that the Swaminarayan sect was not distinct from Hinduism, but their temples were not used by Hindus outside the sect. And therefore, it didn't fall under the definition of temple within the act. This led to an appeal to the High Court, who once again went into this question of whether they were Hindus, and they sent the case back to the trial court. And in the meantime, the definition of the Bombay Harijan Temple Entry Act was amended, and it was broadened to include places of worship used by any section of the Hindu community, and the definition of Hindus was expanded to include all sections and classes of Hindus. The Supreme Court ultimately ruled that the Swaminarayan sect was part of Hinduism and that the temples were Hindu temples. And the legal reasoning is that they connected the history of Hinduism to a cycle of social reform. They saw Swaminarayan, whose name was Sahajanand. He was a reformer in Gujarat. They saw him as a reformer who was born to cleanse Hinduism of its corruption and impurities. And they also saw that his teachings were consistent with Hindu philosophy. Therefore, his followers were Hindus and his temples were also Hindu temples. And the court emphasized the encompassing nature and inclusivity of Hinduism, saying that it does not adhere to a single prophet, dogma, or set of rites, and described it as a way of life. In deciding whether the Swaminarayan sect were Hindus, they rejected a plethora of evidence that non-Hindus were members of the sect and continued to practice their own religion. In the lower court proceedings, Parsis and Muslims testified to being members of the sect and following their own religions. The unique texts of the Swaminarayan sect, such as the Shikshapatri, which contained the teachings of Swaminarayan, the Vachanamrit, which is a collection of the sermons, they showed that Swaminarayan was considered God and that he focused on certain deities in respect to the exclusion of others. In constructing this history of Hinduism, the court also brought in the founders of Buddhism, Sikhism as Jainism as rooting out corruption in Hindu thought. And the court says that this is what led them to form separate creeds. So Buddhism, Hinduism, and Jainism are all brought, Buddhism, Jainism, and Sikhism are all brought within the definition of Hinduism. And for everybody who's also studied family law, we know that the various enactments with respect to marriage and divorce in respect of Hindus also applies to Buddhists, Sikhs, and Jains. However, this kind of conclusion was not necessary in the context of the Supreme Court, as the trial court in the Swaminarayan case held that Buddhism was distinct because of its atheistic teaching, and Jainism does not recognize the authority of the Vedas. What the trial court did is that it linked up Hinduism with Vedic sources and saw Swaminarayan as being linked to the same in the context of the kind of caste-related beliefs that the Swaminarayan sect had, that they did not interdine or intermarry with other castes. So they did not see the Vedas as an original source which had to be reinterpreted, but they saw caste as being essential to understanding and defining Hinduism. What does one learn from this case? Due to the all-encompassing nature of the definition of Hinduism, the Swaminarayan temple was interpreted as being a public temple, accessible to all Hindus. And this may be the language that a court wishes to follow due to the dictates of the Constitution, like Article 25, Clause 2, which stipulates that state needs to throw open certain religious institutions to all classes of Hindus. But the problem with it is the conception of the public opens up a Pandora's box in allowing all Hindus to access temples irrespective of region and locality. The spurt in disputes around places of worship have been initiated by pan-Hindu nationalist organizations. This is also, say, the case of Ayodhya, where a local dispute became a pan-Indian dispute. And these well-known instances of Gyanvapi Mosque at Vanasi Redga Mosque at Madura, the petitions with respect to the Sambal Mosque and Ajmer Dargah, need to be looked at in the context of other flashpoints, such as the Baba Budangiri Dargah in Karnataka, as well as recent incidents in Tamil Nadu, where the Thirupurakandam hill saw a number of protests from Hindu organizations on the issue of renaming the hill and non-vegetarian food being consumed by Muslims at the Dargah there. When the Hindu Munani came to the court with a petition and said that he wanted to take out a procession, the court rejected it, saying that Hindus, Muslims, and Jains have cohabited this hill peacefully. There was a Dargah and a temple, and they've coexisted for a long time. And that this unity in diversity is a strength of our nation, and the government has to maintain harmony among all religious communities. This kind of decision can be considered a bit of an exception, given the manner and the way in which surveys are being ordered to look for temples under mosques. And what I'd like to say, the typical way in which the dispute emerges is through introducing changes in ritual and alleging that there is a Hindu deity or idol that is present at the site. For instance, in the case of Gyanvapi, there is a claim that there is a Shivling which has to be worshipped. This leads to a certain kind of reification that there is, in the sense there is a standard Hinduism and every Hindu will follow these practices. And this is how real Hindus would behave. One of the reasons for talking about the deity as a crucial figure is because of the colonial law itself. The colonial law allowed for the idol or the deity to be a juridical entity which owns property. In the pre-colonial context, there was no such law. In the words of a very well-known Indologist, Gunther Sontheimer, the idol is an ownerless thing. So this has been one of the reasons why these disputes have continued, because once you place the idol, there's a presumption that the idol owns the property. This kind of consolidation of identity overrides local practice and how people have coexisted, where this legalistic conception of property is not there. One example of how this transition has occurred also in a very drastic way is the case of the Baba Budangiri Dargah in Karnataka. In this Dargah, there is a grave of a Sufi saint known as Baba Budan or Dada Hayat Mir Kalandar. And he was also considered to be the Hindu deity Dattatreya. Both Hindus and Muslims visited this particular Dargah. And the practices were a mixture of various things. There were Muslim rituals, there were flowers and coconuts offered. There was no kind of standard set of rituals. When the local Waqf board attempted to take over this Dargah, and this was in 1978, the Karnataka High Court acceded to the wishes of its Hindu followers by declaring the shrine as neither Hindu nor Muslim because of its followers and the kinds of practices. However, in the 80s, the Dargah became a flashpoint due to the activities of Hindu political organizations, the result of which these organizations claimed that the shrine was Hindu and attempted to change festivals by introducing an annual festival called Datta Jayanti, which involved Vedic rituals. This led to prolonged litigation. The most recent judgment, which is very different from the 1978 judgment, this judgment came out in 2021. The High Court said that due to this nature of this shrine belonging to both Hindus and Muslims, both the Vedic practices and the Muslim rituals had to be followed. That means they transformed the entire character of the shrine. So you have Vedic pujas being conducted in the shrine, and you have a Brahmin priest. And this eventually, of course, is a larger goal of taking over shrine. So it leads to a reification of identities that all Hindus perform these Vedic rituals, and Muslims perform something else. And that is the question that I'm going to come to as to how this reification of religion and how this idea of social reform works very differently with respect to Muslims. In Hindus, it's about reinterpreting the Vedas. But with Muslims, it's about attacking their institutions. This is particularly seen in the context of the Waqf Amendment Bill. It's very interesting to see the kind of intervention that's made, because the concern about corruption and mismanagement is actually a very colonial idea. The Waqf boards came into existence in the early 20th century because the colonial government alleged that these various properties were being mismanaged. Now, in a post-colonial context, the government is intervening once again because of that. I'll just go into the various provisions of this Waqf Amendment Bill. It allows the government to interfere in Waqf property and acquire their land. For instance, there's a provision in the bill that any government property which is Waqf will cease to be Waqf. And the collector of the area will determine what is the ownership of the Waqf in the case of uncertainty, and they will submit a report to the state government. The power of the Waqf board to declare a property as Waqf is completely taken away. And even the decision of the Waqf tribunal in relation to whether a property is Waqf, that's also taken away in the sense that they can come out with a decision, but you can appeal the decision. There's a reduction in Muslim representation. It allows for non-Muslim representation in both the Waqf councils and the Waqf tribunals. And there is an increase in non-Muslim members. The Act requires all members of state Waqf boards to be Muslim, but the bill changes this to mandate at least 2 non-Muslim members and at least 7 out of 11 members to be non-Muslims. And out of the 2 Muslim members, 2 of them should be women. This is rather unusual because the legislation on Hindu endowment stipulates that all members must be Hindu. So clearly, there is no kind of equality in the way the religious communities are being treated. Another aspect of the bill, it allows for waqfs to be made by other Muslim communities, such as the Bohras and the Khojas. They fall within the Shia sect of Islam, and there are Shia waqf boards. But now they are allowed to form their own waqf boards. And it also says that they should be represented in the waqf boards as well, along with representation for backward classes among Muslims. That is the Indian Pasmanda Muslims. There is no kind of parallel recognition for different Hindu communities. So this question of saying that diversity in Muslim communities should be recognized is not, in a sense, there is there's no recognition of diversity among Hindu communities. It's not treated, they're not treated on an equal basis. Another provision limits the creation of waqf to only people who profess Islam for at least 5 years. That means even if you're a Muslim by birth, you cannot create a waqf unless you show that you actively practice Islam. So this raises a question as to what would be the practice of Islam, and allows the government to declare many waqfs as invalid. We can see all these provisions especially in the context of the fact that there is no parallel recognition for different Hindu communities, the way there is recognition for different Muslim communities as a way of weakening Muslim identity. The act also interferes in Muslim personal law by restricting waqfs becoming public endowments if there are no heirs, stating that the endowments will not be recognized if they disinherit female heirs. So this is also a very vague provision. And it's not clear as to what they mean by disinheriting female heirs. I want to conclude by saying that this reification of religion, the idea that there are these two religious communities in conflict, is likely to continue unless we have a different regulatory framework and a framework which ensures that local disputes are resolved in a local framework and don't assume a pan-national or pan-Hindu context. And a framework for endowments which moves away from its colonial inheritance. Right? Yeah, thank you very much. I hope I didn't exceed time.
Thank you, Professor Gitanjali, for a wonderful talk. Apart from going through the biography of the Swaminarayan temple case, Professor Gitanjali also gave us a historical detail of the Places of Worship Act. She took us through the complex narrative of the Waqf Amendment Bill as well. So our next speaker today is Veena Gowda. Advocate Veena Gowda will talk about matrimonial law and the Uniform Civil Code broadly.
Thank you very much to Nalsar for inviting me on this occasion, and the Courts and the Constitution Organizing Committee. All of you have been very kind and very generous. I think we all came in very late, and I think students were there and making, like, Nandini said, making sure that we're all in our rooms and in bed and have our food. So thank you very much. And thank you very much for being here at the last session too. I hope it's not just for attendance, but even if that's the reason you are here. I was just looking at all the panelists from the morning and I was like, we normally get very few weekends, and I was wondering why each one of us is here to speak to this audience. And I think it's because each one of us feel very passionately about the work we do and the areas that we work within. And I do hope, I was reading the vision of this institution, which says to bridge the divide between law and justice. And I do hope that whatever you've heard today and what you will hear tomorrow will contribute to this bridging of, the divide between law and justice. And someday that law will be justice in itself. So we've heard several definitions of secularism. And I think since we're talking about the Uniform Civil Code, I'm reminded of Professor Bipin Chandra's definition of secularism. He says that in the Indian context, secularism must mean above all opposition to communalism. And I think that is something that we really need to remember and say that within all the definitions that Dr. Gurpreet gave, that I think today, especially when we talk about the debate of the Uniform Civil Code, it is somewhere to say an opposition to communalism, that we cannot be divided. Because as we see, what does the debate around Uniform Civil Code do? There is a certain demonization of certain communities, and there is a privileging of certain communities and certain practices. And that has somehow become the whole tone of the Uniform Civil Code discussion. And I think actually the Uniform Civil Code, or a gender just law, was actually a demand that starts from the women's movement even pre-independence time, when we said that religious laws were anti-women and that we needed a gender just or a uniform civil code. Then we know that subsequently that it comes as a directive principle of state policy within the Constitution. And then for a few years, it's kind of forgotten. Then, of course, the Shah Banu judgment happens. And then there is this whole revival where the Muslim community drafts its own legislation, gives it to the Rajiv Gandhi government, which passes this legislation. And that is seen as an act where the community removed Muslim women from the secular framework, that is Section 125 maintenance, CRPC, and put them in a religious identity and a religious law. But somewhere we also need to look at this a little differently. This is not the first time that someone has been removed from certain secular law and put into the religious law. And it is not like the community said, okay, this is what the Supreme Court has held. We do not agree with this law. So therefore, we will frame and we will decide what our law is. They did follow the constitutional process, gave a bill to the parliament, which the parliament passed. I don't see what the difficulty in understanding that it was a constitutional process that was followed. Now, like I said, this is not the first time that something like this has happened. As we all know, we have the Special Marriage Act. So if people, I mean, it was in 1954, the law then said that if couples got married under the Special Marriage Act, then the inheritance and succession will not be governed. If Hindus got married under it, it will not be governed by the Hindu Succession Act. But it will be, it will not be, but it will be under the Indian Succession Act, which meant that if there were certain couples, Hindu couples who got married under the Special Marriage Act, it would create a bit of a difficult situation vis-a-vis property concerning Hindus. Therefore, in 76, an amendment was brought in, whereby they said that if two Hindus marry under the Special Marriage Act, then the Indian Succession Act will not apply, but what will apply is the Hindu Succession Act. This is also removing certain people from what we call as secular laws and bringing them into their religious identities. But somehow we don't hear anyone talk about this. The second thing was that is, for example, the Guardians and Wards Act has been there since 1890. But despite which, when we had certain laws within the area of personal laws, the Hindu Guardianship and Adoption and Hindu Minority and Guardianship Act was brought in, thus again removing Hindus outside of the secular law of Guardians and Wards Act. So I think what I'm trying to say is that wanting to keep your flock together is not only done by minority communities or certain communities that we demonize, etc. But every community does that. Every community wants to keep their flock together. So therefore, that is one part of it that it has. And so therefore, whenever we talk about the Uniform Civil Code, what the purpose of this is said to be national integration and gender justice. Now, just because you have a uniform law, does it really mean that there will be national integration? Forget national integration. We are a country where if there is interreligious marriages, there's honor killing. If there's intercaste marriage, there is honor killing. Forget all of that. If there is inter-gotra or within the gotra marriage, and if it is within a caste, there is honor killing. I mean, if you want to integrate a nation, I don't think one can do with a uniform civil law. One has to. I mean, you will not have national integration without complete citizenship to people of all communities and a certain sense of security. Similarly, uniformity will not mean equality or gender justice by its self. So we have to reimagine the law. So therefore, what did we have last year? We had the Uttarakhand Uniform Civil Code was brought in last year. And how do we look at that law, and what does that law actually tell us? I do hope that, because when you say that we want, see, because especially with all of this computerization, e-filing, all of us want a certain certainty and a certain kind of a regular or whatever. We feel that there is a discipline, there's a schedule, and then that seems very enticing, and uniformity is also part of that. But just because you have uniformity does not mean you have justice. It does not, I mean, you have to bridge that gap between law and justice, so that in the 15th edition of Courts and Constitution, you are not looking back and saying, oh my God, what were we doing when the Uniform Civil Code was drafted? You know, I mean, we've been here, for example, in 2018, the Law Commission actually looked at this whole issue of, do we need a Uniform Civil Code? And the Law Commission actually said, no, we don't right now. And what you need is some kind of reform within. You know, I mean, for example, feminist scholars like Flavia Agnes have been saying this for a very long time, where they say that you bring in certain laws from above. You know, it doesn't really trickle down. I mean, since when has bigamy been outlawed for Hindus? We still, even in a city of Bombay, still get cases of second wives coming into, I mean, you know, asking for remedies. So much so that even the Supreme Court has been vacillating over this. In some judgments, they say, no, it's okay, the second wife has to be given right. And in another, they will say that, no, she has no rights at all. So therefore, the law has to come from within. There have to be reforms that people actually want or kind of need at that point in time. And secondly is that, for example, when I think the same-sex marriage or marriage equality petition was being argued. And people from the LGBTQI plus community said that you have to recognize and you have to change the nature of marriage to include same-sex couples. The court and the state argued that, no, this is not possible. This is not possible because it's very complicated in law, because there are very many laws intersecting each other, etc. But somehow they seem to have just forgotten all of that and brought in this extremely superficial law in the nature of Uttarakhand Uniform Civil Code. So I can't believe that in 2020s that this is the limitation of our vision for a law. We need to reimagine the law. For example, what does the Uniform Civil Code do? It still has this very, heterosexual thing of relationship, does not relook at the possibility of, some kind of civil unions, etc. And the framework of the law itself is still, what is the problem with matrimonial law today? Everyone talks, when we talk about family law or matrimonial law, I mean, a lot of my practice, since I work on violence against women, is within the family courts. And many people tell me, how is it that you actually do this? I mean, family law, I mean, it really bothers me and whatever. And I want to ask a criminal lawyer, how do you manage to do this for so many years? I don't see what the difference is. But the difference in family law is somewhere that the law state do not really look at it as a law or a bundle of rights. You still think that this is a law that you can sit across the table and we can mediate and we can finish this. Yes, maybe you can. And you would have been able to if you had much stronger substantive rights. So when do I sit? When can I sit on a negotiating table and say, I mean, agree to what I want, or this is what the law is? How does in the US Jeff Bezos, whatever, decides his multi-billion wealth in so quickly? Because there is a concept of matrimonial property. There is a concept of division of property. However, if you see the law of Uttarakhand, it still only talks within the language of maintenance and alimony, and no concept of matrimonial property. While maintenance will say that it includes medical as well as residence, etc., that we already have in our Domestic Violence Act, and the courts have already read into the concept of maintenance that it includes residence, etc. So it doesn't really go beyond what we imagined. So what is the purpose then of having this law? I mean, why are you bringing in, if anyway, it merely cannot be this uniformity, because as I said, uniformity doesn't necessarily lead us to any form of justice, at least what I understand. But it also seems to be for control. The state wanting more and more control in our personal and private lives. I mean, why would you otherwise have something of where you say that, if you're a live-in relationship, you have to go register. You don't only have to register. If you don't, then there are criminal consequences to that. Much has been spoken about that. In addition to that, you have to also register your divorce. If a court has given a divorce, can't you connect it? I mean, all of you are living in digital India. People have to go and register your divorces too with the registrar. The registrar has the power in live-in relationship, etc., to actually say you can't live together. If you break up, you have to register that too. Secondly, is that you cannot look at the Uniform Civil Code without also looking at other changes in the law that are coming in. One is, for example, the banning of triple talaq, the Triple Talaq Act, or the Muslim Women's Right. What does it actually do? The Supreme Court has actually banned talaq-e-biddat, and it says that if you give oral triple talaq, it does not dissolve the marriage. But the act says that if you do give that, it's a criminal offense. So you're doing an act which actually has no legal consequences, but you're criminalizing an act which has no legal consequences at all. So what you're literally doing is you're criminalizing desertion. I'm sorry, but every other community men are deserting their wives. I mean, most of my cases are of Hindu women. And secondly, the anti-conversion laws. You cannot look at family law, you cannot look at the Uniform Civil Code without looking at even that, which says that conversion for the purposes of marriage itself is an offense, and the district magistrate, etc., will have to. He has a lot of work coming his way with all these new laws. I presume also because So therefore. To conclude, since I think, is that I think it's time that each one of us contribute towards reimagining this law and not stick within the framework of already the law that existed in the 1950s. Thank you very much.
Thank you for an excellent presentation. Very much a lawyer's perspective, but also loaded with academic nuance. So we have our last speaker today who is joining us online. I appreciate your patience, Rakshita. Thank you so much for joining us. So she'll be broadly talking about how personal law reform often sidelines the concerns of other groups like women. So Rakshita.
Thank you so much for that introduction, Aurif, and thank you for having me and inviting me. And I'm delighted to be a part of this panel on a subject as vital and timely as secularism. And it's been very interesting to hear all the perspectives that the speakers before me have shared. And what I want to do today is that I want to invite us to reflect deeply on secularism, not as a slogan, but as a contested space where religious freedom, personal laws, and the promise of equality under the Constitution meet. And I want to explore how this shapes the lives of women and queer individuals in India. The broad point I want to make is that secularism and religious freedom should not be understood in a way that compromises gender equality or queer inclusion, but in a way that bolsters it. So, gender cannot be a mere entry point for reform in these cases, and women and queer persons should not become casualties in the tug of war that we often see unfolding between religious tradition and political agenda. So I'm not going to go into the issue of how exactly personal laws discriminate against women and queer individuals. I think there's enough scholarship that exists out there on this subject, showing how these groups are discriminated against. For example, when it comes to women, discriminatory provisions exist across the spectrum from the modes of divorce that are available to the inheritance share that we are entitled to receive. Now, coming to the question of secularism, I think Professor Mahajan, when she was talking about it, she really summed up the various ways of looking at secularism in India and the various ways in which our courts have looked at it too. We've all heard how Indian secularism is different from secularism in secularism in Western countries, where there is no rigid separation of religion and state that exists. And I would actually like to draw on the theory that Professor Rajiv Bhargav has been talking about, where he positions secularism in India to be based on principal distance, where what he said is that Indian secularism is not anti-religion, but it's against religious domination. And this religious domination is both inter-religious domination and intra-religious domination. For example, if a woman is prevented from entering a religious space because she is menstruating on any religious ground whatsoever, this would be intra-religious domination because both the oppressor and the oppressed are from the same religious community. On the other hand, if the practices of one community are selectively criminalized, this would be inter-religious domination. The point here is that while our constitution is and our state must be respectful of religiosity and religious freedom, the state can also engage with religion to ensure that religious practices align with our constitutional values. And the Supreme Court has said this time and again, where they've recognized that Indian secularism does not demand the exclusion of religion from public life, but it requires that religious freedoms be exercised within constitutional limits. Which is why throughout its history, the judiciary has on occasion viewed governmental intervention in matters of religion as a vital component in the state's movement to initiate social welfare and reform. For example, the court has carved out jurisprudence on essential religious practices, and they've tried to rationalize where and why it can and cannot intervene when it comes to religious matters. Though today I have to say that I'm not going to go into whether or not the court should be employing this test at all and what the alternatives are. Now, this balancing act when it comes to religious freedom and what the state and the courts should be doing to ensure constitutional protections plays out in the interpretation of Article 25, which guarantees freedom, and other fundamental rights like Article 14, which ensures equality before the law. Now, Article 25 guarantees the freedom of conscience and the right to freely profess, practice, and propagate religion. However, this freedom is not absolute. It is subject to public order, morality, health, and other fundamental rights. And the judiciary has often been called upon to interpret these limitations, especially when religious practices appear to conflict with other constitutional values. Now, the intersection of Article 25 with religious personal laws has also been a complex area. And in the past, the court has been rather reluctant in positioning itself vis-a-vis the personal laws, and it has practiced a generally uncharacteristic hands-off approach. if you look at one of the earliest cases which kind of probed this tension between personal laws and fundamental rights, it was State of Bombay versus Narsuappa Mali in 1952, and it laid the groundwork for this kind of uncertainty. A Hindu man who was convicted under a bigamy prohibition law argued that it violated his Article 14 equality rights because Muslim men did not face any such restriction. The Bombay High Court, while looking at this issue, ruled that personal laws aren't laws in force under Article 13, and which is why they're immune from constitutional challenge. In a later 1996 case, C. Mudaliar versus Idol of Swaminathan Swamy, the court did hint that personal laws would be void if they breach fundamental rights. But next year itself, this position changed and Narsuappa Mali was reaffirmed in another Supreme Court judgment where several provisions of Hindu, Muslim, and Christian personal laws were challenged. And our high courts also have diverged when it comes to this particular issue. Some have followed Narsuappa Mali, while others have tended to question it. Why this inconsistency? Something Justice Gajendra Gadkar said in Narsuappa Mali actually points us towards an answer. He said that personal laws do not derive their validity on the ground that they have been passed by the legislature. The foundational sources of these laws are their scriptural texts. But this view is at odds with history. Colonial Hindu and Muslim laws emerged from a process of state rationalization, and they weren't a mere codification of religious commands. For example, various Hindu reforms, such as the Hindu Gains of Learning Act, 1930, and the Hindu Women's Right to Property Act, 1937, used state power to favor some of the economic interests of elite males. And in doing so, they reshaped family structures even without a scriptural basis. For example, in the case of Hindu law, each time a change was introduced, the reformers ended up relying on the state's lawmaking authority exactly because religious scriptures did not support that kind of innovation. For example, when Mitakshara co-passionary property rules were interpreted by colonial judges, they basically said that if joint family funds are used for the education or training of a co-passionary member, then that member's earnings from such training go back into the common pool of family property. But the Hindu Gains of Learning Act made these earnings the individual property of the earner. This was done because there was an emerging class of urban professional men who wanted fewer restrictions on the flow of capital. And this applies to Muslim personal law as well. Shariat acquired exclusive jurisdiction over certain issues as Muslim personal law because the state declared it to be so. And the choice of these matters and the final shape of the 1937 Act were determined by socio-political considerations more than religious considerations. For example, the decision to keep agricultural property out of the ambit of the Shariat Act. It's not a religious injunction as per the Quran. I'll take one more example. The Resolution of Muslim Marriage Act 1939 provided grounds on which a Muslim wife can seek divorce, and it mainly codified the rules of divorce as per the Hanafi school of Islamic law. But while it elaborated some of these rules, it also substantially modified some others. Under Hanafi law, a minor can only repudiate their marriage if, on attaining puberty, they can show that the guardian who had given them in marriage had acted fraudulently, or they can show that the marriage contract was to their disadvantage. This is called option at puberty. But the 1939 Act changed this rule for Muslim women, but not for Muslim men. A woman who has been married before the age of 14 can repudiate it on reaching the age of puberty, but she can only do this before turning 18, and if the marriage has not been consummated. So today, if a Muslim woman exercises the option at puberty, the source of her right is not religion per se, but the state. One of the questions that now arises for us to grapple with is that once these commands have been given statutory form and they've been interpreted by state-appointed judges sitting in state-established courts, how much religious or divine character do they still retain? And this is a question that Justice Krishna Iyer also asked when in the case of Asan Rathore in 1971, where he said that personal law is law by virtue of the sovereign sanction, enforceable through courts, not Manu or Muhammad, but the state. If we are to take this view, religious personal laws derive their validity from state authority, not religion alone, and they are shaped by socio-political forces as well. If this is the case, they should also face constitutional scrutiny like any other law. However, when looking into fundamental rights, courts have seldom relied on this strand of thinking. One example is the case of Shaira Bano, where the practice of triple talaq was struck down by the Supreme Court. The petitioner and the intervening women's groups based their petitions mainly on the argument that triple talaq violated fundamental rights, that is Articles 14, 15, and 21. And they argued that Muslim personal law should be considered as law in force for the purposes of Article 13. They also argued that the Constitution's provisions on religious freedom don't prevent the court from looking into this matter, and that Article 25 itself says that religious freedom is subject to other provisions in Part 3. On the other hand, Articles 14 and 15 are not subject to any such restrictions. And they also said that triple talaq is not even protected by Article 25 because it's not an essential religious practice. However, when it came to the court looking into this matter, they looked into this question by determining whether triple talaq was codified under the Shariat Act, and Justices Nariman and Lalit held that it was statutory law and subject to fundamental rights scrutiny, while Justices Keher, Nazir, and Joseph disagreed, with Justice Joseph arguing that triple talaq violated the Quran and the Shariat, and which is why it deserved to be struck down. Justices Keher and Nazir finally said that triple talaq was part of uncodified personal law and outside constitutional scrutiny. Justices Nariman and Lalit came to a different conclusion, where they said that triple talaq was not an essential religious practice, and applying a manifest arbitrariness test, they struck it down as unconstitutional under Article 14. Now, even though the practice was eventually struck down, the court failed to engage meaningfully with gender equality as a core constitutional principle here. Two of the judges framed their reasoning largely around arbitrariness under Article 14 rather than explicitly going into the discriminatory nature of unilateral divorce rights granted to Muslim men. The judges also focused more on why triple talaq is theologically unsound under the essential religious practices test and how it's un-Islamic. This approach sidelined a more robust gender justice argument under Articles 14 and 15. And this was a missed opportunity to set a broader precedent for challenging patriarchal norms that are embedded in our personal laws. The court also refrained from overruling Narsuappa Mali and the constitutional status of personal laws, which is why it remains as unclear as ever, as does the interaction of Article 25 with other fundamental rights in such cases. For instance, two of the judges said that only uncodified personal laws are beyond fundamental rights scrutiny, but then later on they also went on to say that the entirety of personal law is protected as a matter of religious freedom, reaffirming Narsuappa Mali. This approach kind of prioritizes religious doctrine and group rights over fundamental rights protections, making one think that religious laws operate in a sort of constitutional vacuum. If the court had gone ahead and clarified the scope of these issues, it would have enabled not just Muslim women like Bano, but also women from other religions, as well as marginalized groups, to challenge discriminatory provisions in the personal laws applicable to them while keeping alive the religious diversity in India. This omission is worse because women and other groups, such as the LGBTQI+ community, are always neglected in conversations around personal law reform. It starts as being about women without a doubt, but it becomes about everything else later on. National integration, political party positions, secularism. Let's take the Uttarakhand UCC as an example. The government says that they have passed it for the betterment of women. Here also, they would have us believe that it's only Muslim women who are caught in the web of oppression. But it's hardly a gender just ideal. Its flaws are in fact glaring. It proves true all the fears about a UCC under this government that people have voiced over the years. Religiously, it's unequal. It selectively criminalizes Muslim law practices, such as extrajudicial modes of divorce like Khula and Mubarak, while at the same time shielding Hindu and tribal norms. For example, Hindu undivided family tax benefits and scheduled tribe exemptions persist. And not just this code also fails women on multiple counts. The requirement of mandatory registration of live-in relationships with a jail term for non-compliance curbs women's autonomy, and it clashes with the right to privacy that we have under the Constitution. Mothers have still not been made guardians of children at par with fathers, which is the case across personal laws, and restitution of conjugal rights found in the Hindu Marriage Act and the Special Marriage Act has been retained as a matrimonial remedy. The queer exclusion also is stark. Same-sex unions aren't recognized despite the observations made by the Supreme Court about this being a legislative prerogative in Supreo versus Union of India. Apart from this, some of the reactions to the UCC from religious groups have also been interesting to observe. Some people have rightly observed that the UCC is rife with discrimination and bias under the garb of uniformity. But others have also questioned the government's ability to pass this law because it goes against religious diktats. Some petitions have also been filed before the Uttarakhand High Court arguing that the laws prescribed in the Quran are essential religious practices for Muslims and that the Uttarakhand UCC clashes with them. But the women are again missing from these conversations about religion. What do they think? What do they actually want? Now, Muslim women, like those from the Bharatiya Muslim Mahila Andolan, have spoken about codifying Muslim personal law and reforming it. They have even prepared gender-just drafts of Muslim personal law based on Quranic injunctions. But because of how difficult it has been to translate these into actual laws and policy, they have ended up resorting to the judicial route in cases like Shaira Banu. And history shows us that whenever reforms seek to expand rights for women or other marginalized communities within religious frameworks, the backlash follows a pretty familiar pattern. And the argument is always the same, that such reforms threaten the sanctity of religion, culture, and our families. This was the case with the Hindu Code Bill debates in the 1950s, the Hindu Succession Act debate in 2005, and this was the case with the Shah Bano case, and it's also the case now when courts are asked to intervene in discriminatory practices. For example, when the Hindu Code Bill was first introduced and sought to do away with co-partnery property, and later on when in 2005 co-partnery property rights were extended to women, a lot of parliamentarians basically said that we can't end up doing this. This is against religion, and this also questions the structural integrity of our family. A stranger will come into the family and start administering our property. At the same time, when the 1937 Shariat Act was being passed, there was opposition from the community about the enactment of the Shariat Act, despite the fact that it extended Shariat and Quranic law to Muslims in the country. Before that, customary practices had been followed, a lot of which did not let women be full owners of property. The Shariat Act, on the other hand, as per Quranic law, would ensure that women would become full and complete owners of the property that they would end up inheriting. And these reactions reveal a very uncomfortable truth, that the resistance to these reforms, even though it's positioned that way, ends up being less about protecting faith and more about preserving entrenched power structures. But if we are to take constitutional secularism seriously, the kind that Professor Rajiv Bhargav talks about, which wants to resist religious domination in this country, both interreligious and intra-religious, we must recognize that gender justice cannot be indefinitely deferred in the name of respect for religion. In fact, the very religion of secularism in India protects against this kind of fate. And to keep this vision alive, we need to resist top-down, politically motivated interventions masquerading as reform, such as the Uttarakhand UCC. But we also need to ensure that legal frameworks reflect constitutional values of equality and dignity, no matter which community is involved. And a secular state should not pick and choose when to intervene. It must uphold justice consistently, not selectively.
You brought in themes of secularism, religious identity, and their interaction with rights of women, for example. Yeah. So we now invite questions from the audience, preferably those who could not ask questions in the last panel discussion.
My question is for Professor Mahajan. I think you used a very interesting framework to recast secularism as right to religious, as religious non-discrimination. So this is in nature of a gentle provocation that for any theory of non-discrimination to work, it works on a social history of adverse treatment on access of that identity. So are you envisaging the right to religious non-discrimination as a right only for minority religion? Because what would happen to dominant religion, like say, at least in context of India, Hindus and the Parsis, who have no history of such kind of adverse treatment? So is it in addition to religious freedom? And there is a second question which flows from looking at religious non-discrimination, that while we understand that there can be domination by outside groups on basis of religion, how this theory account for the treatment of individual members within a religious group? How the theory of non-discrimination account for that, knowing that religious or a group identity or a religious group identity is an identity where individuals who are a part of this, there is a certain kind of coerciveness which is there, because the group also has to sustain, which will sustain on the obligations of those individual members. So how would this kind of theory of non-discrimination account for that? Thank you.
My question is for Veena, ma'am. Ma'am, so during your presentation, you mentioned that, when the law is imposed from the above, it does not trickle down to the grassroots levels, which is why it's ineffective in most cases, which is why perhaps the religion should evolve from within. But my question is that, isn't that being too optimistic? Because when we look at the Indian society, if we didn't have laws like the Sati Prevention Act or a lot of other laws that prohibited insidious practices within the Hindu religion, like untouchability or several other practices like bigamy, we would perhaps see these practices still in various parts of the Indian society. So then in that case, wouldn't you say that criminal law has this unique ability of attaching stigma to the practice that it outlaws? And that necessarily then leads to a change in public morality, which then leads to the religion to evolve from within. So in that case, instead of dismissing the Uniform Civil Code altogether, perhaps shouldn't we think of a middle solution where instead of saying that the UCC shouldn't be the case, we have a more consultative process where we have the stakeholders in place. And while there are several flaws in the Uttarakhand UCC, perhaps then shouldn't we strive for a better model instead of dismissing the UCC?
Hello. So Professor Mahajan, I think you talked about how courts favor equality, and so they often sort of allow external intervention. And this also permits legislatures to have external intervention. But when Ms. Goel was talking about intersectionality, she also mentioned about how a lot of it is about maintaining power structures. And so if we look at something within the religion and we talk about women or say homosexual people, there will always be a power structure within the religion as well, where say straight men might not permit reforms within the religion which sort of largely favor women or like the LGBT community. And so there, this whole concept of religion reforming itself from within itself might get more difficult, and their external intervention from courts or even from legislatures might become a sort of more viable route to go about it. And so looking at this sort of minorities within minorities that can exist, there do you think this external intervention becomes a better sort of approach?
Anyone else? I think we can answer and then we can.
On, yeah. As you can, what I understand now is that actually no 1 hour can settle this very important issue of equality. And equality for women, equality for other genders, and so on and so forth. So, but let me tell, but the reason I approached the issue the way I did is there are many difficulties. And at the end of the day, one has to think in terms of how is that equality to be achieved? And what are the kinds of pitfalls and dangers we might want to avoid, even though we want that equality to be realized as soon as possible, and hopefully in my lifetime, certainly in yours. And for that to happen, I think these words we've been using very frequently, and I think we should come back to them. We see equality as a constitutional value, and I agree with Rakshita, it is a constitutional value, 14 and 15, but so is Article 25, a constitutional value. We need to think in terms of how are we going to balance these two different kinds of frameworks. Will religion be given that special status which it was given under 25 to some extent, despite it being subject to some restrictions of public order and so on and so forth? Should equality trump? But there's another element we should bring into the conversation, which is not just particular fundamental rights, but the overall structure and value structure of the Constitution. If we had gone in that direction, I would urge and say that, look, if one looks at the totality of the Constitution and the debates and discussions that went into making of that Constitution, the value they privileged, even, and that's why they didn't use the word secularism, is equality between groups, not personal liberty. And enough proof of that in the previous panel and those before, I'm sure. Not equality of the individual, equality between groups. That's why they placed 14, 15, and 25, and 29 and 30, despite those things. And this is another factor we have to bring into play. And there was a reason, and I think that's why I personally favor the phrase that even though they didn't use the term, they envisaged what we today call a multicultural design, where the assurance to different communities, and this is how I interpret 25 particularly, and also 29, 30, is to assure the different communities that they will not be coerced to assimilate culturally into the dominant community. And there was a lot of discussion about the majority community. And I think this is a real concern. This is what gave place to personal laws with all the difficulties, all the problems which were brought up even then, which you mentioned here. They were aware of that, and yet they brought this in. And we need to keep this. So what is the possibility? It is possible that we could have gone with the legislative route, which after some reluctance, Nehru did do for the majority community, assuming that they speak for the majority. Assumption was that other communities would do something similar. And one should understand that I think we are in this present situation due to a range of complexities. After lots of difficulty, and you mentioned Flavia Agnes's work, 20 years of deliberation, there was reform or some change in the Christian personal laws. Parsi community changed their laws with one panchayat sitting. So quite easily, this becomes a situation when we are talking about gender equality, it seems only one personal law is not being changed. And there is a Nikah Nama, you mentioned that there's an alternative Nikah Nama that women have brought up. So there's multiple issues at work. And then in this situation where there is an embedded power structure in society, in religious communities. So part of the blame in all those various things, but what is still the best route? And I hear everybody around on this panel to say how many times when the state intervenes, they reform, they change personal laws also are not based on religion, but do something else. They intervene now in the name of equality in order to highlight some kind of anomalies. So it's a tricky route. And personally, one could think in terms of what are the alternatives and how do we go about doing that? I think one needs to find ways in which you have to nudge communities and compel them into bringing other groups, women, other groups into who have been vocal and demanding to make a change in a time-bound kind of way. But that process of dialogue, I think, and some kind of nudging has to be followed, without which I think you will always have situations where you will be then saying the state has done this and that, etc., etc. So that's one part of the larger story. In this present scenario, I'm talking too much, but 2 minutes more, because I should say this, I was avoiding the word demonizing, but you did that, so it's good to put that on the table. One aspect of non-discrimination I would like, and I think there is a difference between three organs of the government, particularly legislature, executive on one side and the judiciary on the other. And there's a huge debate in contemporary times the world over as to what should prevail. In our country also we ask whether there should be judicial activism, or why is there judicial activism? These are things they should not interfere in, and this is the domain of the legislature to do this sort of thing. The reason is, A, that will be will of the people, which can become majoritarian, and it may at many times. And on the other side, you look at the courts as the area, because they're not elected people, you assume that they will be offering some reasons and reasons consistently, and therefore we ask what principle is at work. And that is why one needs to also scrutinize and say, we are expecting this from the courts. Hopefully they will deliver, and we should nudge them into doing this and delivering a coherent thing. In this framework, I privileged that idea of non-discrimination because, for instance, one could easily say, why do the courts not take up suo moto such elements as to where you can say there is demonizing or selective targeting of people and of one community or two communities or three or etc., etc. They don't do it. And I think privileging this idea over saying religious freedom and this and that helps. I also privilege non-discrimination, and may not address your question directly, but I may come to it in a bit or maybe later, over the idea of anti-secularism as being the other side of communalism, the more enabling side. You want to avoid communalism, and therefore, and I think there's a very strong point that people makes there. Sometimes it's easy, it is good to just go for it and say, we don't want it to be communalism. We don't want communal society. A non-communal society is a secular one. But what is non-communal? One could be when we, let's say, the state intervenes or puts up these big pandals, not now, but for over the last 50 years for Kumbh Mela or for Hajj. Will we call it communal or not? And I think there is good reason to say it is not. I think this is the speciality of Article 25. It allows the state, but it's also a double-edged sword as to how it is going to be used. You allow that, when does it cross the boundary? When does it cross the boundary? And the courts tells us that it crosses the boundary, for instance, this time when an order is given to say that you must display your names, etc., etc. When they just say just simply that it would be a violation of fundamental right of secularism or something, but it'd be nice to know what aspect is it. Is it because it impinges on people's livelihoods? Or are we going back and saying that's a better idea to say, look, let's not bring religious identity as far as possible into this and then have this balancing act of what will. And that's why I think the principle, the idea of principle distance is attractive, but how do I make this idea translatable? What kind of distance will I expect the state to have in these matters? there are some cases, and that's why religion is separate also from caste issues, because there was a constitutional provision to say abolish untouchability. And it also said what you cannot do, you cannot have separate wells, and you have to have access to all public things. And I think there was an intent behind thinking of equality in terms of what does inequality imply. Similarly, I think we could spell that out more clearly in the case of caste, but we couldn't do it. And I think the only alternative way of thinking about this idea, and it's a very complex idea of history of equality, what would equality imply for women, for instance? Some different treatment, some of the time at least. Idea of non-discrimination helps me to start thinking of that process and identifying and then saying, okay, this would constitute discrimination. And I can say why it may result in discrimination in terms of saying, whether I have to display my sort of name on the shop, or when I'm told that you will not buy vegetables from X and Y. It can constitute, we can think of it in terms of discriminating against some people as opposed to facilitating religion. Even there it is going to be difficult, but I would say there is this element. What you were trying to say in non-discrimination, I should stop, I can't come back to it, is the idea of tolerance, that Hindu society is tolerant. I agree, it is tolerant. But tolerance is not an idea that will help us today in the contemporary time, because it is noblesse oblige. It's my generosity which accommodates. And I think the Constitution made it very clear, to me at least in the debates, that they are not going in for that. That is why they put 25, 29, 30, that they will provide special, they are thinking in terms of vulnerable, all minorities as vulnerable minorities, and safeguards and an assurance that they will not be asked to assimilate. It's not about the fact whether there is a past history. I could say some more about it, but no.
Actually, I think we could have stopped there. But since there was a question to me, I think now there are various ways of looking at this. I mean, does it mean that then you don't have any form of law reform, etc., from the legislature? No, not at all. I think there are two approaches to it. Like she gave examples of where reform has taken place. For example, when the Indian Divorce Act was amended, it was women from the community who approached the state to say that, make that change. Similarly, today when we have the judgment on the triple talaq, it was women from within the community who approach. So there is, I think that reform within also means that. And secondly, I think the other option, what one says, is that some form of a piecemeal legislation, instead of having this overarching uniform civil code. Like, for example, I mean, it's not like the Domestic Violence Act, which is secular, applies to everyone, a demand from the women's movement, etc., taking experiences of women and taking it into the law is also one. I'm not such a fan of over-criminalizing aspects of, I mean, for example, we've seen, I mean, even within the women, violence against women, 498A or what is 84 now, has not really in that sense worked unless you give certain certain rights to women. The other is, which I think I forgot to mention, I don't know if is that we already have what is called the Special Marriage Act, which is often seen as an optional or a voluntary civil code that people can opt, and that it has to be that optional. Don't make it compulsory uniform civil code. Some certain changes, even to see how it, like, for example, if you say, we don't know how this thing will play out of property rights, etc., make certain changes in that law to give additional rights to women, and then see how that works. So you have that, make that a little more gender just, and so that then people can voluntarily opt for it. I mean, actually, even now you see that even many educated urban people don't register their marriages under the Special Marriage Act. I think even the awareness that you can, because there is a sense that once you go and register your marriage under the Special Marriage Act, and you're giving up your religious identity, etc., is kind of what prevails. So there are these various ways of doing it rather than this overarching compulsory pushing down people's throat kind of a.
Do we have more questions? No. Thank you to all the panelists for taking up. Yeah.
Thing in that case, because you brought in this issue of Special Marriage Act, which is there. In the 1990s, when this issue came up for gender just laws, one of the things that a group of women, and they wrote about it, asked was, because the issue was that people want to marry and they just habitually marry by religious rites and rituals. So automatically you get governed by the personal law. So they said we should opt for something called, the term they used was reverse optionality. That by default, no matter what ceremony you have, you are married under Special Marriage Act, unless you go and register and say that we will marry under this. And that could be a way in which they will have a better, not the best possible scenario that is available to them. Maybe we could make changes also in the Special Marriage Act. But many other suggestions have also been given as to how equality might be pursued for women.
Thank you for taking your time out to join us at Nalsar. Thank you, everyone.
Yeah. Hi all, I have a quick announcement. We have a Bharatanatyam performance by renowned dancer Aranyani Bhargav. She's going to be performing a poem by Faiz Ahmad Faiz on the bombing of a safe zone in Palestine. So please make your way to the CCD place and you shouldn't miss the performance.
Anna?
Give it